Please.
Yes.
My lord, I have, by way of this, I have flagged an issue which I believe requires your lordship's consideration, one way or the other. Your lordships had issued notice, my lord, on 17th of September, and thereafter, my lord, by a detailed order of 7th October, my lord, this constitution bench has been. My lord, the 7th October order, if your lordship just has a look at,
Yes.
mentions both sides of the argument, other side's arguments as well as this side, and what I have submitted, my lord, before your lordship for your consideration. Can I just place that for a minute, just 1 minute? My lord, if your lordship has 7th October, para 2. This court, by the order dated 17 September 25, had considered an application filed by amicus who pointed out anomalous situation in most of the states. Judicial officers recruited as civil judges often do not reach the level of principal district judge, leave aside reaching the position of a high court judge. This has resulted.
Yeah, I think all of us have read the order.
Your lordship, they read.
Yes.
So now, my lord, having read that now, so now there's a few interventions have been filed as per the office report 8. So 4 seem to take the view that what I'm saying requires consideration, and definitely 4 are opposing it. So my request to your lordships is if your lordships would have it on some day for hearing.
Yes, so we'll
Yes.
fix up the date.
So, my lord, what
Nodal council.
This, of course, my lord, the amicus has some information on this, but your lordship has noted that there is a different high courts, my lord, have different experience.
Yes.
correct, that's it.
Your lordships are under this have, my lord, constituted a committee, a fact-finding committee, for the purpose of seeing whether this problem is as.
Fortunately, all 5 of us have experiences of the.
No, that is true, my lord. But what is the current state of facts, my lord? Because there is evidence both ways.
My lord, so far as the current. All right.
Lordship to consider whether there should be, it should be first referred to a committee, somebody your lordship may appoint.
So that data would be available to us. All the high courts are
My
before
lord,
us.
I am going to file. In fact, last time.
All the high courts are before us. So it's not a very difficult data. So they have to just give 2 figures, 3 figures, the total number of service judges appointed to the high court. Out of them, how many from the directly recruited from the bar, and out of them, how many promoted?
Your lordship may recall last time, my Lord and Justice Chandran were on the bench. I had handed over a compilation of whatever the High Court has said. I'll file it with my compilation before argument so that everyone can have a look at it. No problem.
All states have not filed affidavits.
Oh,
And we have not yet given the detail. Your lordship.
we are applying for Calcutta High Court. Calcutta High Court.
Here for Delhi High Court, my lord, the position is reversed. Out of 13 principal district judges, only 2 are direct, 11 are promoted.
Therefore,
And my lord, in the High Court, my lord, there are 17 honorable judges.
therefore, if they view
Yes, my lord, I have,
what
yes, I prepared, my lord, lordship, may formulate some question of law.
benefit you,
That will vary from state to state.
No, no, that's what I have.
Rajiv Gupta is also.
Some all 12 judges are from civil judges.
That's
They
right.
are no more hard to serve.
No, so lordship may formulate some point, which I have suggested, my lord, subject to your lordship's
what are the points?
Kindly give it.
Because also data of all the high courts are not available.
Wherever the recruitment has taken place annually in terms of the timeline laid down by the school,
Exactly, that is.
probably there the direct recruits have got a lot of advantage. But where the
Selection has not taken place, yes.
couldn't take place for a couple of years, obviously, only the.
But
unit
normally,
officers
if the
are-
Malik Mazhar matter, your lordships have been supervising that, monitoring it also. So therefore, my lord, by and large, it has been complied with. Malik Mazhar.
Just take a copy if you can.
No, who says it has been complied? It has not been complied in my state.
But by and large, it has.
I don't know, there's nothing, no record to indicate.
No, this is.
My lord, can I make a
1
submission?
minute.
Yeah, just one submission, my lord.
Let
Yeah, your lordship finds
the amicus,
we may have to consider whether, no, yeah.
you want the amicus,
No,
what
no,
question you
I
want?
thought before we start, I thought I'll make one submission in all humility.
We are not starting today.
No, not arguments, my lord. My point is, will a 5-judge bench be sufficient is a question that I want to humbly bring to your lordship's notice. 2 constitution benches have taken the clear view when an integrated cadre is constituted by 2 sources, thereafter discrimination is impermissible. two constitution benches have taken that view. And therefore, your lordship may have to consider whether we can, the five judge bench at the end of the exercise, we should not be stuck with that, my lord. And I thought it my duty to point out before your lordships, please consider whether we can do that at the end of it, after taking a lot of time. This should not trouble your lordship. I'll cite those two decisions, your lordship may kindly see them. They are authoritative for the proposition that when two streams make a common integrated, their birthmark loses. Thereafter, there's no birthmark. You cannot thereafter make any reservation. That would be offending Article 14. And therefore, that question, if your lordship want to alter that, maybe your lordship may consider. I'm just pointing out, my lord, your lordship, because at the end of the day, I don't want the whole exercise to be a wasteful exercise.
What is our interpretation? We don't apply because we are saying that experience is something which takes it to a level of. Aware of those judgments, and I'll be citing them first when we start the matter, because I don't think they cover the point at all. In fact, they are open to interpretation. I know the two, Roshan Lal and Milord Tirlokinath are the two judgments.
These are the two judgments.
Correct.
I'm already aware of that, so I'll be dealing with that, but your lordship will hear it holistically with everything else. That's what my submission is.
No, but all that I wanted to submit was, Lord, all.
Pardon?
Exceptions question where you can deviate without reaching Article 14. Yes. Judgments are not there as a constitutional dictum where they will apply invariably in every case.
That's right. So that's my submission. I'll be
No,
making.
I think they are. That's a going to be.
That's
At the end of the day, my lord, at the end of the day, let it not be, that should not be seen that, will it be better to have, you're expending, investing judicial time in it. So let's be sure that we can do that. That's all that I say. So
27. We will consider this issue also whether it requires we refer to a larger bench or not.
What are the questions according to you are arising? You just formulate your respective question.
Very
Your written submission, on the top you frame your question and then you can give your submission.
we'll do that.
I think, my lord,
All of-
formulate the question,
all of us
it's
may-
easier
all of
for
us
us to
can-
address your lordship.
You know what is the issue?
I appeal for the High Court.
No, we have identified the issue in the order.
The order, the issue is identified. The prayers are actually the prayers in the IA is the issue.
The prayer in the eye also is identifiable. It's not something vague. Like
My lord, there are some more
My lords,
intervention
my
applications.
lords, I appear.
My lord, there are some more
Because we had
intervention.
moved an intervention
No, lordship
application
allowed
last
the
evening.
intervention.
Last time you
Lordship
lordship
can't allow
allowed.
the.
We'll hear all of you.
Lordship would formally allow.
Not necessary to allow and.
But it's easier for us to file commissions.
Last time, my lords have said all interventions allowed. Last time that is
There are
it.
few more.
There are four, five applications.
all interventions which are filed till today are allowed.
Yes.
Lordship, please.
Request, no, there's one.
Otherwise, they'll be floodgate.
Because that is one IA because I have filed.
Because that is what we have said. Other way of saying it.
I got one at 11 p.m. last night.
Because one, yes, because we had filed one intervention application on behalf of this income.
Whatever are filed till today will be allowed.
Lordship, please.
So let's,
My intervention was filed.
from our side, Manu Krishnan can be the nodal
Yes,
counsel.
Mr. Manu Krishnan.
Yes, from our side. He's, Mr. Basant is also being instructed. Manu Krishnan is,
And
Mr. Bhatman.
from your side?
My lord, I was thinking I'll give my submissions along with.
No. There should be a nodal council who supports your.
That's what I'm, no, what I'm saying is, so the amicus will give it, I will give it, and then one of the other, perhaps, Miss Mayuri Raghu.
Miss Mayuri Raghu.
Yeah, she can do that.
Mayuri Raghu. But there was one factor which I wish to point out, subject to, may have been disclosed to Lordship's reading. Because in our case, we clearly stated they are, that the judgment of Justice Chandra perhaps may be under review. But Justice Chandra's judgment may be under review.
Vinod.
It may be under review.
Which judgment?
From the Bihar High Court, where it has come. And it's in appeal not before Manoj Justice Kant also.
So that's not, I don't think that's an issue in that.
That was only with respect to who gets seniority, correct? Who gets it, the direct recruit, the Bihar rules provided that the direct recruits will get seniority. That's about 94 people at one go. 2011 to 18, there were no selections. So that is a peculiar situation though. That I said that.
That itself would be subject matter of debate before launch. It's not we intend to raise it because rule says not the direct recruits are going to get their seniority from the date prior anterior to their appointment. It is not permissible.
We will not be able to determine the interest seniority of different states.
Wish to do anything else except to point out
That is an unending process. We can only lay down the general principles that will have to be followed.
I don't think your lordships will go into individual high court rules, otherwise then your lordships never do this. Individual high court rules, I don't think your lordships will be going into in this matter at least.
Like what you have done in Dheeraj Mohan, we will be laying down the principles,
Right.
which will be followed by all the high court and the state government.
Please.
Just for one piece of clarity, after going through both orders, there seems to be one aspect which is of the principal district judges and the recruitment to that. The other is with reference to high court judges and where they come in. Would the questions be framed on both? Or is it with reference to the cadre of principal
As my
district
learned
judges?
brother has pointed out,
Yes,
as far as high court is concerned, it's not a promotion.
yes.
It's not a.
It's not.
No, your lordships
No,
were
so
only referring to.
the problem is in Kerala, for example, they don't have a cadre of principal district judges. There's no cadre, it's not in the rules. What they do.
States.
Yes.
Gopal, in
Yes.
most of the states, there is no designation nomenclature
Correct,
of principal district judge.
Correct.
There is only a district judge. Right?
Yes.
So wherever in the state there is a principal district judge or in the other state is a district judge, I think that's one and the same thing. It's only a question of head of the district judiciary.
Yeah, exactly.
Let us
Exactly.
take in general parlance as head of the district judiciary.
Yes.
So what should be the mode of,
Sourcing.
interest determination of seniority in that cadre? That can broadly, as Honorable CBI has pointed out, we can lay down the general guidelines and principles, which can then could be followed by states, respective states and the consultation.
If the amicus could
It's a
frame
question
those
of- it's a
questions.
question of nomenclature.
Yes.
Wherever there is a principal district judge, the head of the district is called principal district judge.
Correct.
All others are called as district judges.
Yes.
Wherever the district judge heads the district judiciary, others are called as additional district judges.
Correct.
Actually,
The reason
actually, the better expression that all of you can use is the, the interest seniority in the superior judicial service.
That's correct.
Basically, because it's a question of determination on the entry point.
That's
And the entry point is in superior judicial service.
My lord,
In some of the
superior,
states, you
superior
might-
stroke higher judicial service.
Debatable higher judicial service in general. Yes.
But within the higher judicial service, one is.
How can you do, Mr. Ansaria, that probably you,
It's not a posting.
It's a posting, my lord.
It's only a post.
No, it's the administrative side. It's the administrative side of the High Court. It's the administrative side of the High Court, my lord. They decide, who may not junior.
And they look at suitability, so they're not looking at.
the same. And
Posts are fixed. Some posts, Mr. Hansaria, you are right. It is a complete cadre of district judges. But some posts in that cadre are fixed for district judges selection grade. So there are stratification in the cadre of district judge itself. There is the first district judge entry level, then you have the district judge selection grade, and then you have the super time scale. So what happens is, for the post of principal district judge, a district judge entry level is never considered.
Yeah.
You must you must be upgraded
Yeah.
to a district judge selection grade. Then only you come in the zone of consideration.
My lord, so for
So
example,
what we
yes,
propose to consider is
yes.
that this zone of consideration of movement, again, is not on seniority per se.
Yes.
It is merit cum seniority.
Yes, my lord, that's what
So
I want.
let us say if the selection grade comes into 5 posts,
Yes.
we have to have a zone of selection of 15. Would we put in a preferential quota
Yes.
for the promotees from the base level, that is the civil judge junior division level, for consideration and the zone?
My lord.
This is an issue which we would like to discuss.
Yes. My lord, what I was submitting is, my lord,
It is,
that
it is,
within
it is hard
the
to
rules,
explain
my
the
lord,
issue.
so far as Delhi is
And that
considered
is why we
administrative
need your
orders.
assistance.
So would your lordship ask all the high courts and amicus to see, my lord, what are the provisions in all the high court? Because different high courts have different provisions. There are no rules, my lord. For example, there are no rules. There is a full court decision.
Mr. Ansaria, it's only because of lack of uniformity in the rules that this problem we are facing.
Yes, yes, my lord.
The very fact that all of you are and all of us are assembled here is only because of
So
this reason.
this will require collating all the information from all the high courts regarding the present stand and the provision regarding the rules.
Actually, learned amicus is already having the,
It's, my lord, what has been given to us, it does not have.
No,
For
no, to
three
be
or four
fair,
high courts, it has
to be
only.
fair, I think the learned amicus is trying his best based
Yes,
on the
ma'am.
pleadings
It
that
is
are
not
coming.
available.
Sorry, bro, I got.
That compilation of all the rules of
Right.
the High Court, it's not 100.
No, no, we'll file.
25.
I'll file it with my submission.
Compilation of those rules, collation and a comparative table, that in the case of seniority, how they deal with.
Yeah, I'll do
And then you can just prepare a small note of highlighting
summary
the
of that.
significant differentiation between that criteria.
Absolutely.
Sometimes they follow continuous length, the others follow the date of entry, the third follow roster points.
Right.
Sometimes there is a mix of rota and quota. So these all
Different, my lord.
there are a lot of
I'll make sure it's there. I'll file it.
Some of the high courts have placed the statistics with reference to the, over the last 5 years, from which sources they have come, etc. Some of them have not. Now, I'm with Mr. Bhatnagar on this. He needs as much assistance as he requires to come up with this. In his own note, there are many states where the response hasn't come. So one suggestion that I have is, if the registry of this court can reach out, then immediately it'll come, it'll be uploaded, and we'll have the advantage of that.
Because only 3 states have been given, my lord, perhaps in the note by the amicus. 3 or 4 states, because rest are not available. So Lordship may kindly require, my lord, consider issuing directions to the High Court. They must give data for last 5 years as the posting of principal district judges, and also, my lord, the relevant rules or the administrative guidelines for selection of or posting as a principal district judge. Because in Delhi, there is only a full court rule.
Let's not interfere too much of the, that's a domain of the High Court, that what should be the criteria of posting.
No, my lord, I want Lordship may have it. No, I am only saying Lordship may have that material.
It's not unnecessarily expand the scope of this issue.
No, my lord.
That's absolute prerogative of the High Courts, we must respect that.
No,
What is the criteria of posting of the district, that has to be resolved by them.
No,
not by
but that is
Supreme
what
Court.
your Lordships are considering, my lord. What your Lordships are considering is,
Let's not
what-
go left and right, straight
No.
to the issue.
the rules must be available to the court, my lord. That's all I am saying.
That's my learned brother has already informed, you didn't listen to what his lordship was telling the amicus.
Yes.
File
He
it.
has already told him that you have filed a compilation of the rules.
That's all, my lord.
Yes.
And be attended to the-
also.
No, that's all I'm saying.
attended to what falls from the court.
Yes, I've seen that.
already filed their rules, my lord, and guidelines.
Not all.
Very good.
But usually this process is not governed by rules.
That's what, we can't share you publicly.
No,
You know.
As far as this.
Guidelines
Yes.
are there.
Guidelines are there, my lord.
There are no statutory rules, there are guidelines or
By the full court.
Guidelines by the full.
The,
But fluidity about the issues involved in this matter, it's quite wide scale. Let the amicus not perhaps pinpoint the issues and then we can proceed.
Yes, Lordship may fix once again, once the amicus picks up the,
Coming so problem. Let the amicus frame the issues and we'll follow that.
the following question for consideration by the constitution big. Correct. What should be the criteria for determining seniority in the cadre of higher services? From the
Issuance of lesser.
needless to say that while considering the aforesaid issue, you would also consider the other ancillary or related issues. Sorry, the parties were, if the council were supporting the prayer made in the IA, would be heard on 28th of October, and the party who are opposing the prayer would be heard on 29th of October. Sorry, the councils shall file their submissions on or prior to 27th of October
27th.
2025. Sorry, the nodal council for the parties supporting the prayer in the IA would be Ms. Mayuri Raghuvanshi, and the nodal council for those opposing the prayer in the IA would be Manu Vishwan.
Yeah.
File it by 27th.
27th, reopening day.
28th.
28th, my lord, 27th would be reopening, my lord.
So 28th, 29th, yes.
Yes,
Right.
but
On the opening day, we don't want to pay for
I
it.
thought Lordship was saying 27th.
No, 27th for
Yeah?
filing the statement, 27th, your lordship is saying?
Yes,
Yes.
That the reopening day, can it be, that's the reopening day, can it
Yes.
be a little
you
later?
can file it on the opening day.
Laws may allow.
Lordships have allowed the IAs
They are only allowed the highest file till today.
For intervention and experiment, my lord.
Please,
So you distribute the times.
Yes, so
Time slots amount.
we'll make sure that our side is this thing, Mayuri. My lord, we have filed, or I have filed three things, my lord, a sort of detailed written submissions which I would like to place before your lordships. And then, my lord, there is a compilation of case law. And then, as my lord had said, there's also a compilation of the rules. My lord Justice Suryakant had said we should also file the High Court rules. So we filed those also in a separate compilation. If your lordships take, we've also provided printed copies of the written submissions. If your lordship either wants the PDF volume or the printed copy, either both are there. The registry asked us for printed copies, we've given that. Otherwise, it is in volume 1 are the submissions. And it's right at the beginning, my lord. In fact, it starts at PDF page 3. PDF page 3 is the index, right? Yes. PDF page 3, and otherwise, my lord, it's the index page of the printed copy. Your lordship may have the printed copy, otherwise, no problem.
1 to 50.
That's right.
Some say convenience compilation.
Sorry, my lord.
Amicus.
Amicus.
It's, my lord, the written submissions.
Yes.
My lord, may I just start with the introduction, which is at page 1?
Yes.
Because this is, my lord, the orders passed by your lordships in this application that your lordships are considering. It says, my lord, by way of the present application, an anomalous situation in respect of the inter se seniority of district judges, direct recruits and district judges promotees has been placed. This Honorable Court's order dated 7th October 2025 recorded as follows. I'm just put two paras. This court, by the order dated 17 September 25, had considered an application filed by amicus who pointed out an anomalous situation in most of the states. Judicial officers recruited as civil judge often do not reach the level of principal district judge, leave aside reaching the position of a high court judge. This has resulted in many bright young lawyers being dissuaded from joining the service at the level of CJ. At para 10 and 11, this Honorable Court stated as follows. It cannot be disputed that judges who were initially appointed at CJ gain rich experience since they have been serving in the judiciary for a number of decades. Furthermore, every judicial officer, be it one who was initially recruited as CJ or one who was directly recruited as district judge, has an aspiration to reach at least up to the position of a high court judge. We are therefore of the view that a proper balance has to be struck between the competing claims. However, this issue would involve consideration of some of the judgments and orders passed by benches comprising of 3 learned judges of this court. Therefore, in order to put the entire controversy at rest and provide a meaningful and long-lasting situation, we are of the considered view that it will be appropriate if the issue is considered by a constitution bench of 5 learned judges. And then, my lord, the question framed on the next date, which was 14/10/25, is as follows. What should be the criteria for determining seniority in the high judicial service? So the question, though wide, is, my lord, I have limited my submissions to the question as recorded in the 7th October order and, my lord, the application to answer this question to the best of, what we feel we should be placing. It is respectfully submitted that seniority in the higher judicial service in various states, which comprises of a single cadre of district judges, though further divided into posts of district judge entry level, district judge selection grade, and district judge super time scale, ought to be fixed in a manner that district judges appointed by direct recruitment and promotion from the cadre of civil judges have an equivalence and a balance be struck so that no one category has an advantage over the other in respect of the said cadre, as also for further aspiration to advance to the position of principal district judge, if any, and further to the position of high court judges. I say if any because not all states have principal district judge designation. So that's why if any is mentioned over there. Otherwise, my lord, some states have only district judge super time scale as the highest, and from there they are. My lord, now if your lordship just comes to the first page of the compilation, this is the way I've divided it into various, my lord, submissions. I've just, my lord, read the introduction. I've given a brief background, my lords, then a small discussion on the cadre of district judges, and then, my lords, for me to, or for us to impress upon your lordship that there is a requirement of a quota, some data has to be given. I can't just say have a quota without, so that is, my lords, serial number D, need or requirement for a quota. And then, my lords, fixation of seniority in the higher judiciary that deals with judgments also of your lordships. And finally, a summary of submissions and suggestions. So this is the way I've divided this note into the 4 or 5 minute portions. If your lordship comes back to page 2, Now, this is where, my lord, the issue was first considered. Para 5. The disparity in the cadre was noticed in the first National Judicial Pay Commission, also known as the Justice Shetty Commission, under the chairmanship of Honorable Mr. Justice K.J. Shetty in its report. The Justice Shetty Commission submitted its report on 11/11/99. The commission noted, I've set out some paras, my lord, for your lordship's consideration. The mixed cadre of district judges, consisting of promotees and district recruits in every state judicial service, was intended to promote efficiency in the administration of justice. But the fact remains otherwise. There is a lot of discontentment between direct recruits of district judges on one side and promotees on the other. The two classes are generally not on cordial terms. Nay, in some states, they are not even on talking terms. They are forming separate associations. They are locked in legal battles fighting up the apex court. They made separate representations to this commission. The root cause for all these unfortunate fallout seems to be the mode of direct recruitment followed by high courts and determining the inter se seniority between promotees and direct recruits. The high courts are not unaware of this bitterness and discontentment in the service, yet seems to have done little to improve the method of direct recruitment so as to remove the grievance of promotees. The common grievance of service judges in the lower cadre in all the states, and which grievance is also highlighted in the memorandum of All India Judges Association, is that the hopes and aspirations of judges who have entered the lowest rung of the judicial service have been shattered for want of adequate promotional opportunity. It was explained that the unreasonable quota reserve and unscientific method followed for direct recruitment of district judges have practically driven the service judges to despair and despondency. It was said that they could never think of becoming principal district judge. It was pointed out that advocates are recruited as district judges at a relatively younger age, varying from 32 to 40 years, while service judges would get a chance of promotion as district judges only at their advanced age. Such direct recruits should be ranked above the promotees in the seniority list and occupy all the central posts. They also deprive the promotees the chance to reach the High Court. In the light of the aforesaid, the Justice Shetty Commission recommended the following. It seems to us that it is proper and necessary for all high courts to have a uniform procedure for recruitment of district judges. There should be uniformity as to quota, minimum and maximum age and method of selection. Such uniformity is imperative since district judge cadre is a feeder service to the High Court and in some cases an onward march to the apex court. Since 10.80, since temporary posts are also available for direct recruitment, we consider not exceeding 25% of the posts in the cadre of district judges should be reserved for direct recruitment. This percentage of reservation would not jeopardize the interest of the promotees since we have decided to give them a certain weightage for fixing the inter se seniority, besides providing opportunity to service judges to compete for such direct recruitment. We consider that there should be a minimum age for direct recruitment and it should be not less than 35 years. To put it more explicitly, the minimum age should be 35. Next, my lord, the Shetty Commission further noted that district judge entry level were provided career progression by way of grant of functional scales in the form of district judge selection grade and district judge super time scale, depending on their performance, and recommended that the cadre of district judges should be divided in the following manner. We have carefully considered the representations of High Court, state governments, and state and service associations. In our opinion, it is necessary to bring out uniformity in giving selection grade and super time scale to district judges in all the states. It is also necessary to prescribe the minimum qualification for entitlement to such grade or scale. These two scales are not to be considered as career progression scales. They are functional scales depending on performance. Commission recommends 25% of posts in the cadre of district judge in each state shall carry selection grade. This may be given on the benefit of merit cum seniority, on the basis of merit cum seniority to those who put in minimum experience of 5 years in the cadre. Commission further recommends minimum 10% of the cadre strength in district judges be given super time scale to those who have put in minimum of 3 years in the cadre of selection grade. Now this has become 35 and 15. Latest judgment of your lordships has amended that. Next, recommendation in respect of seniority is at the bottom of the page.
No. Become 25.
Sorry?
They become 25.
No, Milord, I was talking about the selection grade and the super time.
Super time, yes.
Because that is what page 4 is on. Otherwise, the lordships are right. It is 50% for in the cadre. 50% are directly promotees, regular promotees. 25% direct recruits and 25% limited competitive examination.
LCD.
By this one, LC. My lord, may I just continue reading this a little bit?
Yes, yes.
My lord, 12.106 bottom. This is the recommendation in respect to interstate seniority. Bearing in mind the aforesaid perspectives, comments, and suggestions made by High Court, state governments, judges, and service associations, we have made the uniform rules of recruitment and seniority for operation of all the states and union territories. The rules of recruitment inter alia provides as follows. Reservation for direct recruitment from members of the bar to the cadre of district judges should not be more than 25% of the cadre posts. This is a simple rule prescribing the upper limit for direct recruitment without any prescription of rota quota system. Then, my lord, the next is the age is between 35 and 45, and then the examination. And please come, my lords, to Roman 6, which is the rules of seniority. Seniority of the officers appointed by direct recruitment or promotion shall be determined according to the dates on which they report for duty. Where more than one officer is promoted to a cadre at the same time, inter se seniority of the persons who are promoted shall be determined by the inter se seniority in the lower cadre. With regard to direct recruits, inter se seniority is determined on the basis of the rankings in the select list. Weightage for promotees. According to the feedback information which we have received from the high courts regarding average age of promotees and direct recruits made in the last 5 years to the cadre of district judges, the promotees will always be older in age to direct recruits. Reason being, civil judges senior division get promotion as district judges only at their advanced age, while bar members are directly recruited at a younger age. Then, there is a chart appended to the Justice Shetty Commission, which your lordships will see the difference in the various states. In Andhra, for instance, average age of promotee district judge 48, average age of directly recruited 39. Then Assam 51-38, Bihar 54-41. So in virtually every state there is that age disparity. So this is why now this, my lord, is now dealt with at 12.110 and 12.111. It will be seen from the above table that average age of promotees would be about 50 years as against the average age of 42 years of direct recruit. Indeed, the table shows that in a majority of the states, such average age of the promotees would be above 50 years, while that of all direct recruits would be less than 42 years. Just pausing here, I have also compiled my own chart from the affidavits filed by the High Court about the position today, which is later on in the submission. So, lordships may just see, in 1999 itself, the difference was 50 and 42. And now today's position I will be showing to your lordship. 12.111, my lord. This will have an imbalance in the service conditions of promotees and direct recruits, and that is the root cause of frustration amongst the promotees. Apart from the imbalance in service, promotees would be denied of higher pay scales like selection grade, super time scale, etc., since it is given on the basis of merit and seniority of the officers. Promotees will not have any chance to become principal district judges of districts, since such posts are generally occupied by senior judges. They would be wholly denied of opportunity to go side by side with direct recruits in their onward march to reach the High Court. Even if they are elevated to the High Court, they will have hardly 3 or 4 years of service. Such a short period is not sufficient to make any worthwhile contribution to the High Court. The Commission considers that it is imperative to remove the frustration of promotees resulting from the aforesaid imbalance, and the only way we can think of is to give certain weightage to the promotees for the purpose of determining their seniority. The system of giving weightage is not new to service jurisprudence. It has been provided to officers of the state service when they are selected to all India services. The reference may be made to the Indian Administrative Service Rules. Then, 12.119. The Commission recommends that promotees be given a weightage of 1 year for every 5 years of judicial service rendered by them, subject to a maximum of 3 years. So, pausing here, so suppose, a civil judge is recruited and spends, let's say, 15 years in the combined cadre of civil judge, junior division, and then senior division. For those 15 years, if that person gets promoted to a district judge, will get 3 years benefit of seniority. Otherwise, he will start from the bottom. But this is the recommendation that the Justice Shetty Commission said. Sorry. Then, 12.120. Judicial service of officers for providing weightage is the entire service rendered by them as judicial officers, right from the entry into judicial service up to the date of promotion to the cadre of district judges. And so the next, is a summary of the above. And then, what your lordships had held in this very case in 2002 4 SCC 247, while considering the Justice Shetty Commission recommendations, is set out, my lord, at para 10. Experience has shown that there has been a constant discontentment amongst the members of the higher judicial service in regard to the seniority in service. For over 3 decades, a large number of cases has been instituted in order to decide the relative seniority from the officers recruited from the two different sources, namely promotees and direct recruits. As a result of the decision today, there will be, in a way, 3 ways of recruitment to the higher judicial service. The quota for promotion which we have prescribed is 50% by following the principle of merit cum seniority, 25% strictly on the basis of merit by limited departmental competitive examination, and 25% by direct recruitment. Experience has also shown that the least amount of litigation in the country where the quota system of recruitment exists, insofar as seniority is concerned, is where a roster system is followed. For example, there is, as per the rules of central government, a 40-point roster which has been prescribed which deals with quotas for scheduled castes and scheduled tribes. Hardly, if ever, has there been litigation amongst the members of the service after their recruitment as per the quotas. The seniority is fixed by roster points and irrespective of the fact as to when a person is recruited. When roster system is followed, there is no question of any dispute arising. The 40-point roster has been considered and approved by this court in R.K. Sabharwal versus State of Punjab. One of the methods of avoiding any litigation and bringing about certainty in this regard is by specifying quotas in relation to posts and not in relation to vacancies. This is the basic principle on the basis of which the 40-point roster works. We direct the High Courts to suitably amend and promulgate seniority rules on the basis of the roster principle as approved by this court in R.K. Sabharwal case as early as possible. We hope that as a result thereof, there would be no further dispute in the fixation of seniority. It is obvious that this system can only apply prospectively, except that where under the relevant rules, seniority is to be determined on the basis of quota and rotational system, the existing relative seniority of members of the higher judicial service has to be protected, but the roster has to be evolved for the future. Appropriate rules and method will be adopted by the High Courts and approved by the states whenever necessary by so and so. Then, next, we disapprove the recommendation of giving any weightage to the members of the subordinate judicial service in their promotion to the higher judicial service in determining seniority vis-a-vis direct recruits and the promotees. The roster system will ensure fair play to all while improving efficiency in the service. Subject to the other various modifications, all other recommendations of the Justice Shetty Commission are accepted. So, my lord, the weightage system which was then recommended by Justice Shetty Commission was rejected, and the court took the view that you will follow the 40-point roster for appointment as well as seniority. 40 points for roster and seniority. Now, my lord, please see one of the things that has arisen and will come later in the note is that let us say, my lord, the 40-point rosters worked when district judges entry level are appointed. Now, to the next grade, let's call it, my lord, the promotion, because most high courts call it promotion, although it is actually a functional upgradation as per Justice Shetty Commission. But let us call it promotion by merit cum seniority. My lord, there are no seniority rules, so the 40-point roster remains. In other words, what is happening is that people are actually being promoted more on seniority than merit. Otherwise, my lord, if it is merit cum seniority, then there has to be some change in seniority. The roster, 40-point roster will obviously be changed once, my lord, we go from entry level to selection grade, from selection grade to super time scale, if merit cum seniority is being applied. But in almost all states, it is virtually, my lord, the same roster system which is being for the entire card. And one of the reasons for that is, my lord, that the merit, determination of merit, some high courts rules have pointed it out and I'll show it, is basically on ACRs. Now, most people have those ACRs. 2 good, 1 very good, etc. That. So it all comes to seniority. So the criteria for merit is determined in a manner that seniority becomes the main thing. I'll show that in my submission. Would your lordships turn over the page to page 9? Thus, this Honorable Court in terms disapproved the recommendation of the Justice Shetty Commission with respect to determination of inter-se seniority of promotee district judges and direct recruit district judges and did not grant the promotee district judges a weightage of 1 year for every 5 years of judicial service rendered by them, subject to a maximum of 3 years. Instead, this Honorable Court held that inter-se seniority should be determined on the basis of 40-point roster as has been considered and approved in R.K. Sabharwal. In the same judgment, this Honorable Court also held that the cadre of district judges would be divided in the ratio of 50 regular promotion as to 25 accelerated promotion as to 25 direct recruits. Thereafter, in All India Judges Association 2010, 15 SCC 170, this Honorable Court altered the ratio from 50-25-25 to 65-10-25 for appointment to the cadre of District Judge. Recently, this Honorable Court, in All India Judges Association, while relaxing the eligibility conditions for appearing in limited departmental competitive examination, restored the ratio for appointment to the post of District Judge as 50-25-25 in the following manner. We find that if the quota of LDCE is restored to 25%, as originally recommended in the third AIJA case, which was reduced to 10% in the fourth AIJA case, it will provide an incentive amongst officers in the cadre of Civil Judge Senior Division. It will also provide them with an opportunity to get accelerated promotion in the cadre of District Judge if they are meritorious and deserving. Another difficulty that has come to our notice is that sufficient number of candidates are not available for appearing in LDCE on account of requirement of having 5 years experience as Civil Judge Senior Division, which is prescribed as an eligibility criterion for appearing in the LDCE for the higher judiciary. In some of the states, a judicial officer who completes about 5 years service in the cadre of Civil Judge Senior Division in normal course becomes entitled to be promoted in the cadre of District Judge. We have already framed issue 2 dealing with this very conundrum, which we are considering immediately after this issue. We find that in view of the answer that we propose for issue 2, sufficient number of judicial officers from the cadre of Civil Judge Senior Division would be available who would be eligible for appearing in LDCE. If in a particular year sufficient candidates are not selected from LDCE quota, it will be appropriate that such posts would revert back to the regular promotion quota based on merit cum seniority to be filled up in the same year. Therefore, in such a case, we find that no adverse impact on the administration of justice would occur even if LDCE quota is increased to 25%. In our view, this, apart from avoiding any adverse effect on administration of justice due to sufficient number of seats not being filled up, would also ensure that no prejudice would be caused to regular promotees, and at the same time, the said exercise would provide an incentive to meritorious judicial officer if their merit deserves the same. The next paragraph, my lords, your lordships have set out the time it takes. Now, this will also apply to our case that we are presently dealing with here. We find that it will be appropriate to compare the position in some of the states with regard to average time taken by Civil Judge Junior Division to be eligible for LDCE as against average time taken by Civil Judge Junior Division to become a district judge by way of regular promotion. In this respect, a chart was submitted extracted as under. Now, my lord, please see Bihar. Average time taken by Civil Judge Junior Division to be eligible for LDCE is 9 to 10 years. Not very relevant for us, but the next one. Average time taken by Civil Judge Junior Division to become a district judge by regular promotion is 9 to 10 years. If we come to Himachal, my lord, the average time B by a civil judge to become a district judge by regular promotion is 19 to 20 years. In Maharashtra, my lord, it is 13 years. So, the reason I'm pointing this out is now we have seen the 99 position in the Shetty Commission report. This is the 25 position which your lordships have set out. In Maharashtra, my lord, average time taken by Civil Judge Junior Division to become a district judge by regular promotion, 13 years. Next, my lord, Manipur. Average time taken by Civil Judge to become district judge by regular promotion, 11 years. In Punjab, average time by Civil Judge to become district judge regular promotion, 15 years. Haryana, 12 years. Uttar Pradesh, 9 to 10 years. Now, what your lordship said was that in the context of LDCE, the time that you became eligible for LDCE and regular promotions was almost the same. Therefore, there was no need for, people are not appearing in LDCE. So, therefore, your lordship reduced that time. But, my lord, what I am presently placing before your lordships is the time it takes for a civil judge to become a district judge is so long that, again, my lord, the age disparity will remain. And what that age disparity is, I'll show it to your lordship. Then, my lord, if para 42 at the bottom of page 11, as has been discussed herein above, the purpose behind providing a special quota for LDCE is to enable meritorious judicial officers to get accelerated promotion and enter the cadre of district judges at an earlier point of time than other less meritorious candidates. If a judicial officer even otherwise gets an entry in the cadre of district judges after completion of 5 years of service as Civil Judge Senior Division, there will be no incentive available to him or her. As already discussed herein above, in some of the high courts, a judicial officer gets into the cadre of district judge through regular promotion itself after he or she completes 5 years service as Civil Judge Senior Division. Therefore, in our considered view, it will be desirable to modify the requirement to become eligible for LDCE for the higher judicial service and reduce the minimum number of years of service of experience as a civil judge senior division from 5 to 3 years. However, at the same time, we are also of the opinion that, as recommended by some of the states, total number of years of experience for a judicial officer for being eligible for LDCE should be a minimum cumulative of 7 years, including service as civil judge junior and civil judge senior division. So this was in the context of saying that since you're taking the same time either way, you should reduce it. But what I am placing before your lordships is, please see the time taken for regular promotion. We are presently mostly concerned with regular promotion here. That still remains. Now, my lord, the next heading is the cadre of district judges. This very short, my lord, just one page on that. The second National Judicial Pay Commission, in its report dated January 2020, recommended, having regard to the long passage of time since the recommendations were made by FNJPC, an undeniable fact that quite a number of district judges are not reaching higher grades, this commission is of the view that it would be appropriate and proper to increase the percentage of ceiling prescribed by FNJPC to a reasonable extent. Commission recommends that selection grade and super time scale posts shall be increased by 10% and 5% respectively. This means that district judges at entry level shall be 50% selection grade, 35% selection grade 35% and super time scale 15% of the total cadre strength of district judges. Of course, the criterion of merit cum seniority shall continue to be applied for placing the district judges in these two higher grades involving functional as well as financial upgradation. We recommend accordingly. This recommendation, if accepted, may be allowed to come into force from so and so. Next, my lord, para 16 in part 1, volume 4. The posts of district judges selection grade shall be increased to 35% of the cadre strength as against 25%, and district judge super time scale shall be increased to 15% of the cadre strength as against 10%. It will be effective from 1/1/20. Now, this, my lord, these recommendations were considered by your lordships in 2024 1 SCC 526, and at para 74, this is what your lordships had held. This commission has recommended the increase the percentage of district judges who will be entitled to district judge selection grade and district judge super time scale. The reasoning of the commission is that due to limited percentage of district judge super time scale and district judge selection grade, many judges from larger states are unable to reach higher posts before retirement, even though they have spent considerable time in the district judge cadre. It is found that as of October 2019, only 1515 judges out of a cadre strength of 7382 district judges were getting the benefit of selection grade and super time scale. Recommendation of commission that the selection grade and super time scale posts should be increased by 10 and 5% respectively on merits acceptance. Essentially, this would entail that district judges at entry level shall be 50, selection grade 35%, and super time scale 15%. Now, Lord, so this was increased for the reason that judges should get an incentive to be in at least higher pay scales, and from there, Lord, you move to the High Court. Now, it will be worthwhile to see how many of these people, these judges may not reach selection grade and super time scale if you are a regular promotee judge coming from the civil judge senior division and before that from senior judge junior division cadre. That's 50% of the cadre. We are dealing with 50% of the district judge cadre. What are their opportunities to reach these three scales within the district judge cadre? First scale, of course, is entry level, selection grade, and super time scale. Because that, I believe, is at the heart of what we are placing before your lordship. Now, my lord, according to us, the justification for that, we have tried to place, my lord, at page 13 onwards, which is the need and requirement for a quota. We are saying that there should be a quota. What that quota shall be, I'll come to your lordship. So the first is the Justice Shetty Commission, my lord. As mentioned above, Justice Shetty Commission had noted that there was disharmony amongst promotee judges and direct recruit judges in district judge cadre, especially due to different average age at which promotee judges 45 to 50 years and direct recruit judges 35 to 40 years joined the cadre, which left to limited avenues for career advancement of promotee judges due to superannuation before being considered for the post of principal district judge or above. It was specifically for this reason that the Shetty Commission had recommended to grant the promotee judges a weightage of 1 year for every 5 years of judicial service rendered by them, subject to a maximum of 3 years. However, the said recommendation was expressly rejected by this Honorable Court in this 2002 4 SCC 247. The Honorable Court instead recommended adopting 40-point roster to govern the interstate seniority. It is respectfully submitted that the 40-point roster system, while determining the interstate seniority of district judge and promotee judges at the time of joining the cadre, does not remedy the problem of age gap at which the direct recruit judges 35 to 40 years and promotee judges 45 to 50 years join the cadre. The effective result of the 40-point roster system is that once the promoting judges superannuate to the higher age, the district direct recruit judges get clubbed together at the senior most positions in the seniority or gradation list due to the relatively younger age, and this stagnates the career progression of promoting judges. Despite having 20 to 25 years or more of judicial experience, due to seniority as determined by roster point system, promoted judges do not fall within the zone of consideration for being appointed as principal district judge. So what this para is essentially saying is, because they are at a higher age, they'll obviously superannuate much earlier, reach the age of 60 much earlier. So, my lord, because they may be, let us say, senior to a direct recruit judge, but the promoted judge will retire. Then the next promoted judge will also retire. So the top of the cadre will have, my lord, direct recruit, direct recruit, direct recruit, direct recruit. And, my lord, then when the question comes for appointment, if whether to the High Court or even to the next higher grade, it will be those people who will be taken into consideration. I've put a chart on the next page. I'll show that to you. Para 20 minutes. That the post of principal district judge in some states, others only have the post of district judge super time scale. Per se is not a promotional post itself, but an administrative post where a judicial officer from among the senior judges in the district judge cadre is appointed by respective high court for administrative efficiency and management of a judicial district. Promoted district judges with adequate judicial experience may not even fall within the zone of consideration for appointment to the post of principal district judge. Creation of such a quota will not only be beneficial to promoted district judges, but will be equally beneficial to direct recruit judges who in several other states have been found to be not adequately represented at the senior post in the cadre of district judge. Having a quota for promoted judges and direct recruits will ensure that judicial officers coming from both streams have equal opportunity of progressing and gaining career advancement. So, we are saying that 25% plus 50% is the promoted judges, 50% regular and 25% LDCE, and 25% direct recruits. Now, please see the way I put it or tried to put it to see how the quota helps everybody. It's one stream should not get the benefit, but both can get the benefit together is the way I am trying to put it. The next page. The need and requirement of quota in the cadre of district judges may also be examined from the data on record provided by various high courts. So this is today's position. In certain states, it has been noted that an anomalous situation has arisen as per seniority gradation list of district judges, wherein it has been noted that the senior most district judges are found to be mostly direct recruit district judges, thereby leading to a lopsided situation where although the overall cadre strength of district judges is found to be in the ratio of 50:25:25, yet the post of principal district judge / district judge super time scale is occupied mostly by direct recruit district judges, and promoted district judges are not adequately represented at the post of principal district judge. This happens mostly due to average younger age of direct recruit district judges at the time of appointment to the cadre vis-a-vis the age of the promoted district judges. So this is exactly what Justice Shetty pointed out in 1999. Exactly the same. Now please see this chart. The following chart shows the difference in average age at the time of appointment of direct recruit judges and promoted district judges. Now, my lord, your lordships will see 35 in Andhra, 35 to 40. Sorry. Sorry.
Kerala, you have said 49 is the direct entry position.
Sorry, madam.
The direct entry district judges, they get into the service at 49.
Right.
In Kerala, now there are at least 5 High Court judges who are direct entry people,
Right.
who are at this age, 49.
Oh, I see. No, I've just given the average. Maybe.
This is not correct.
So I'll just recheck it. This is my own, my lord.
It must be 39, 40.
Just check out the. My lord, I'll just quickly check. I may have made a.
Same thing with Bihar.
Let us see Bihar. My lord. The Bihar is not.
It's not seen shown here.
So whoever's provided the data, I put it. The rest we have not been able. But my lord, just one thing to be added here. When your lordships are seeing this
This is right. In Bihar, it takes 17 years to become district judge.
For the promotees.
for promoting.
No, I'm
17
talking about the
On direct
recruits. I'm talking about the direct recruits.
My lord, I'm quickly checking the Kerala affidavit. Maybe it's a mistake. But one thing, your lordship will just note one thing here. The figures are, I think, more or less correct. But my lord, when we come to the third, fourth column, average age of appointment to district judge, promoted judges, please add to this 3 years. Because now your lordships have said that you have to have 3 years as an advocate before you even take the examination. This data has come. This data is before this requirement has come into the picture.
53 will become 56.
Now, my lord, you add 3 years to it. Your Lordship's judgment of 2025 May, when it was discussed at great length, and the Bar Council of India also said, and all the High Court said that
Almost all the High Court.
every High Court said that you just, except one or two Sikkim, etc., that you just can't have untrained, people without any advocacy experience becoming civil judge, deciding life and liberty. And so your Lordship then mulled over whether it should be 2 or 3 years, and your Lordship said 3 years. So now in this second last column, you will have to add, my lord, your Lordship will have to add 3 years. What does it say? My lord, I'll just read that affidavit of the Kerala High Court. I'm sorry, I've taken it from here. I'm reading it, my lord, from here, if with your Lordship's permission. Average age of judges presently serving in the cadre of district and sessions appointed by promotion from the cadre of civil judge senior division is 53 years, while the average age of judges directly recruited in the cadre is 49 years. So they've said on affidavit it may be.
Except that average age of judges now serving is 49.
Yes.
Not recruitment.
Correct. Your Lordships are right. That's a mistake, yes.
I would say these aged persons serving as PTG.
Please, we have
Right.
three of them who have first-hand knowledge. One on this
No,
side,
so, my lord,
two on the other side.
Well, I accept my mistake. Going through so many affidavits, sometimes a little bit of. But all I'm saying is for this chart, please, my lord, while considering this, add 3 years in the second last column. That will have to, your Lordship will have to add. Because, and minimum 3. Because we are assuming that a person immediately after 3 years becomes a civil judge junior division. So minimum 3 your Lordship's add. My lord, just coming to the next page 16. My lord, my apologies for that. I'll just correct it. Just check the others if there's any mistake. Affidavits keep coming and you quickly just sometimes write and this doesn't really. Yeah, luckily your Lordships have that experience, your Lordship immediately corrected me. So. But in fact, what your Lordships are saying that the difference would be more than what I've indicated, not less. So, it's, sorry. Meeting number. Let's do it now.
There can't be an entry below 35.
Yes. Minimum is 35. My lord, just see, my lord, may I just, now that we are mulling on this issue.
Both.
Oh, Kerala, there are 42 and 49, no? No. Okay. Yeah, correct. It's a much bigger difference. My lord, one of the examples given by my.
You see, this entire facts which you are referring to, this only highlight the anomalous situation.
Correct.
According to you.
My lord.
That a kind of a explicit discriminatory
That's
or anomalous situation between direct recruits versus promoted.
My lord.
Those who are departmental, this limited
LC.
entry, 25%. So to whom we can, just loosely we can call them semi-direct recruit.
Right. Because they are getting a, yes.
So
advantage.
they still might have an edge or advantage of seniority. Might.
My lord.
Depending upon that what time they compete and what time they get acquire eligibility and enter.
That's right.
Now this entire anomalous situation, what is the ultimate recommendation?
So, would your Lordship want me to come to that first and then come back to it? Very well, I can mention that. But before I could do that, can I just mention two aspects, which, my lord, since your Lordships are on LCE right now, just now, and also, my lord, recently we had a judgment of a constitution bench which says that even, my lord, serving civil judges after 7 years can take the direct recruit examination because the experience there is actually much more than that of an advocate of 7 years. That's what your Lordships have said. So, my lord, one of the points that my learned friends have said, and it's a point worth, my lord, dealing.
Therefore, balancing of seniority
Yes,
is now also important because of that judgment.
right,
If you give so much incentive to the seniority for the direct recruits,
correct.
our junior cadre officer will start only working for
Then-
competing.
And they will not be interested in deciding cases, they will study for the examination.
Have a crisis in junior division level.
Exactly, my lord. So you will spend 7 years preparing for the district judge direct recruit examination rather than doing, because then you are not bothered about your ACRs, etc., because you are only interested in taking the direct recruit examination. But my lord, please see 2 examples that I am giving. My lord, one of the things that has been pointed out, it's certainly something I should mention straight away, is that LCE, which your lordships pointed out, and even the direct recruitment now gives some kind of equivalence to other people, which would include promotee judges. Now, the way they've said is this, that let us say, my lord, the case where a person graduates at the age of 23 years. Let us, my lord, take an example from law college. Then, my lord, that person will spend 3 years practicing as an advocate as per your lordship's judgment, so 26 years. And then, my lord, as per your lordship's judgment, LDC, they can take after 7 years minimum. So, my lord, let us say 26 plus 7, 33. So, they are saying that at the minimum age, if you clear everything in the first round, you will at the age of 33 itself become eligible to become a district judge.
So 35 is the 35.
But so 33, but you take it to, so therefore you have no disadvantage. I was coming to that. 33 through LDCE, 33 to LDCE, but let us say you are appointed at 35 only. So the argument is there is no disadvantage. I am just dealing with that argument. Next is, my lord, let us take a case of a civil judge who after 7 years, as per, my lord, your lordship's judgment in the review in Dheeraj More, takes the examination and clears it. So, my lord, in his case also, he would have joined at the age of 23. Let us say, my lord, finished law at 23, 3 years, my lord, of advocacy practice, and then, my lord, 7 years. So that takes it to 35. So
we have made it, even in their case,
yes,
they can't get in before 35.
they can't get in before 35, but the argument that is being made is that therefore there are enough avenues for you through LDCE or through us for a civil judge to take the direct recruitment examination to come in at the age of 35.
And
Now,
so
the answer to this, let me give the answer. Sorry.
So their condition would be, whoever are meritorious amongst the promotee, they would have already made it by either through LCD or through the direct recruitment.
Right. So that is one of the arguments. Now, but please see the other side of it. 50% of the entire cadre is not promoted district judges. We are dealing with 25% LCE and assuming that the entire 25% is filled up. Your lordships are seeing that in that matter when your lordships heard, hardly anyone was taking LCE. Now they will take because of the incentive. And my lord, you are assuming that every civil judge after 7 years will clear the district judge examination. So for 50%, we are dealing with the 50% of the cadre here. So, my lord, for them, the seniority and, my lord, promotion is a very important aspect. That's what I'm trying to say. So, my lord, to say that they've got opportunities, even after taking those opportunities, 50% of the cadre will still remain regular promoting cadre. So, we have to, so your lordships may think of that that's what I'm trying to say, bro. Now, so, my lord, tell your lordships what my suggestions are and then I'll come back to this. Would your lordships come, my lord, to page 48? I've dealt with the case of the same, 48. I've given 4 suggestions in the alternative, etc. Try to be, my lord, as even-handed and fair as possible. My lord, just have a look at it. My lord, may I read suggestion 1 at page 48, Roman 1? The additional experience as judicial officers constitutes a reasonable and justified classification on the basis of which promoted district judges can be classified as a category who ought to be granted a quota for their effective representation at the post of district judge selection grade, district judge, super time scale, principal district judges. Creation of such a quota satisfies the twin test of classification based on intelligible differential and reasonable nexus of such classification with the object sought to be achieved. Therefore, creation of such quota is permissible in terms of so-and-so. It is thus suggested that for appointment to the post of so-and-so, now, my lord, here, I'll just make there's a nuance here, which I'll just point out, to the post of district judge selection grade, district judge super time scale, principal district judges, a quota of 1:1 for promoted district judges and direct recruit district judges may be created. Principle of merit cum seniority may be, can then be applied within the said quota. So what the suggestion finally is that even for that 25% direct recruitment, you have a 50% quota, and for that 75% entire promoting cadre, you have 50%. That your lordships can of course make it 75, 25, 25. Also, some of the people, my learned friends on this side are arguing that. But here, my lord, your lordship will have to see one nuance, that this district judge cadre has 50% judges at entry level, 35% at selection grade, and 15% at super time scale. So, my lord, if we let us assume for a minute that this 1:1 quota is to be applied, and we apply it to both selection grade and super time scale, then there will be no entry level direct recruit district judge left, because 17.5% plus 7.5% will go into the next two posts. So, my lord, my suggestion here therefore will be to have that at the super time scale.
Only.
I hope I've made myself clear. Let's say there are 100 posts, 100 posts in the cadre. So there will be 50 entry level, there will be 35 selection grade, and 15 super time scale.
Mr. Bhattacharya, that 25% departmental examination,
Yes.
the 25% quota, is only meant for as an incentive
Yes.
for the officers who we suppose that they are meritorious enough, that they can, through competitive exam, they can occupy those 25%.
Right.
What will be the incentive for them left if you apply this ratio in principal district judge or selection grade? And
no, because they will still be they are still promotees. Of course, no, the incentive.
Therefore, within why they should compete for 25%?
No, so
if ultimately this position is to be occupied solely on the basis of length of service, then what is the incentive left for them?
For the LC, yes.
25%.
No, then, my lord, you will be senior to a regular promotee in any case in the seniority list. You will have a quota, yes, but your seniority will be higher.
Then are you conceptualizing a situation where the senior most person in the cadre of district judge, though he is senior most, but he will not get a super time scale or he will not get a selection grade?
No, I'm not visualizing that. In fact, I'm saying the opposite. I'm saying the senior most. Suppose, my lord, the LCE person, let's say, my lord, there are two promotees appointed on the same day. One of them clears LCE at a younger age.
If on the same date they are promoted,
yes,
nothing difficult, because then you can say that promotees will have an edge over the department promoter.
My lord.
Then he can be assigned seniority. You can have kind of a roster point. You give first point to the promoter.
That's right. That's how the roster is also. Yes.
Third maybe to the direct report.
Correct.
That is one possibility. But what will be the incentive left for an officer?
Yes.
He will say, why should I work hard, compete, and try to qualify the exam when eventually, in terms of seniority or in terms of monetary benefit of a higher pay scale, I'm going to lose?
The benefit will be, in my respectful submission, this, that suppose, my lord, there are two civil judges, senior division, one is junior to the other. The junior one passes the LCE examination. He comes directly into the cadre of district judges. He becomes senior to the regular promotee when he comes in. So, my lord, the seniority will be higher in the cadre in any case. The quota doesn't affect seniority. Yes. Right. what I was saying, just, just to come back to what your lordship very rightly put to me. Firstly, at the entry level, we are not fixing a quota. So the LCE will anyway be senior. So entry level, will be as per roster, as my lord said. Only at super time scale will the promotees get. Now, that's one. Secondly, if I have just in fairness mentioned 1:1 as an amicus, but suppose some of my learned friends, etc., are saying the quota should be 2:1:1. That is to say, 2 for regular promotees, 1 for LCE, and 1 for direct recruit. Suppose that is accepted by lordship, then LCE again will get the same.
Ultimately, 2:2 only.
Yes. I'm saying that, but ultimately I'm saying that the regular promotees are the ones who suffer the most because being maximum in the cadre. Coming to suggestion 2, which is the next page, page 49. Now here, it's the same as suggestion 1, except here we are saying something a little different. Alternatively, zone of consideration for appointment to the post of district judge selection. So please read this: zone of consideration for appointment of district judge selection grade and district judge super time scale should comprise of 50% officers from directly recruited district judges and 50% from promoted district judges. Thereafter, appointment would be made on the recommendations of the respective high courts on the basis of merit cum seniority. Thus, in the zone of consideration, 50% shall be senior most promoted district judges and 50% shall be senior most directly recruited judges. Now, suppose there are 10 posts. So most high courts have a system where the zone of consideration is 3 times. So let us say 30 officers, 30 judges will be considered. Now, out of which my suggestion is that in this zone of consideration, you will have 15 from the senior most promotee and 15 from the senior most directly recruited. After that, if the High Court feels that all 10 should be directly recruited judges appointed to the next grade, that is for the High Court to decide on merit cum seniority, or 5:5 or 10:0, whatever. But this is the zone of consideration argument, so that at least somebody comes within the zone of consideration. Otherwise, they are not in the zone of consideration. If it's 3 officers to be considered for 1 post, then obviously because of seniority, etc., they're never in the zone. This will bring them within the zone. This is the second argument. So this can be an alternative to the first in case your lordships feel that this is the better one.
Mr. Marcus, your suggestion, second suggestion, in fact will create a cadre within a cadre.
Why is that? I'm sorry.
Because you are saying that the 50%, let's say there are 10 candidates eligible for a super time or a special selection grade. It would be 5 from the promotees and 5 from the direct recruits. So what would happen is, at the district judge entry level, it's a common cadre.
Yes.
And if the second suggestion is adopted,
My lord.
then we are creating a separate classification, a cadre within the cadre of direct recruit judges as district judges and promotee judges as district
Well,
judges.
with great respect, what I was trying to say is that they'll only be in the zone of consideration for being considered. Appointment can be of either of them, but they'll be the same. It's the cadre remains the same.
But for that, the list of seniority
Yes.
will be a different list of seniority for the district judges as direct recruit district judges and promoted district.
So that
That is your proposal so
No.
far as.
So that is not exactly my proposal. I'm saying that in the same
That will boil down to that.
Correct. Now, but that is exactly what in my fourth suggestion, the High Court of Andhra Pradesh has said exactly this.
We've seen it.
Exactly this,
But the area of consideration would be,
Yes.
do we create a stratification in the district judge cadre, which is an uniform cadre itself? We can definitely consider your first suggestion about quota in
Yes,
respect of the functional
That's the first-
seniority, functional position scales. But to create the cadre as groups will make it not an uniform, but a stratified cadre of district.
No, so I understand exactly what your lordships are saying, because then you are mixing up seniority in that sense. But my suggestion here is this is the only way in which if you are leaving it to the High Court to appoint a person, and
It will also lead to a very anomalous situation.
my lord.
Where a person, because of this cap of 10 picking up from promoted, 10 picking up from direct recruit.
I'm not saying that.
No, zone of consideration.
Zone of
For zone of consideration.
Yes, yes.
10 you pick up from this side, 10 you pick up from this side, you merge them, consider them, and then you promote them directly.
Whoever you want.
Maybe that throughout till the question of designation or promotion as principal district judge comes, an officer who have been throughout junior will become a head of the district judiciary, and all persons who have been throughout senior to him will be under.
No, that may not necessarily be the case, because the High Court will consider it when we're making that appointment.
If you restrict the zone of consideration, then nothing will left for the High Court. Then it depends upon that if he qualifies, then you can't stop him.
I'm saying that presently the zone of consideration is such skewed in the other way. For that, if your lordship just comes to page 16, just have a look at the seniority list.
Probably you want to suggest the High Court will have to then a very adverse responsibility of seeing that in which session division we are posting him and no person junior to him should be posted there. This will
No,
lead to
that I'm not saying. But
chaos.
Milord, eventually, this is so, but Milord, I'll just show to your lordships how it works. In practice, what the problem is. I'll just show that immediately after I finish these suggestions. I'll come to the chart. There's a chart, and I'll just show after this. The reason I've come out with this, that's just a suggestion for your lordship to consider. Milord, sorry. Milord, the third suggestion is in fact what the Justice Shetty Commission had said. So I'll read it out. Alternatively, it is suggested that this Honorable Court may accept the recommendations of the Justice Shetty Commission and grant weightage to promoted district judges for experience in terms of 1 year seniority for every 5 years of judicial service, subject to a maximum of 3 years. It is further submitted that these additional years of seniority may be considered as service in the district judge cadre. Thus, if a promotee district judge has been granted 3 years seniority as per aforesaid criteria, promoted district judge will require only 2 years of service in the district judge cadre for being considered for the grant of selection grade. This is the example I've given. It is stated acceptance of recommendation of Shetty Commission will require modifying or dispensing with 40-point roster system for seniority in so and so. Thus, it was respectfully submitted will address the issue of age disparity and additional experience of promoted district judge vis-a-vis district judge, direct recruit district judge. So this is exactly what Justice Shetty had said in 1999. The next one is what my lord has put to me, so I'll read that also. 4. Alternatively, this Honorable Court may consider the recommendation made by a committee of the Honorable High Court of Andhra Pradesh, which had recommended 3 separate seniority lists in respect of promoted district judges by regular promotion, promoted district judge LDCE plus direct recruit district judge in the ratio of their overall cadre strength of 50:25:25 and the selection of such higher posts in the cadre of district judges be made on basis of such seniority list. So these are the 4. One has come from the Andhra High Court, one is Justice Shetty, 2 I have put in, my lord, as my suggestions. Now, my lord, just to come back to page 16, I wanted to show your lordships a chart as to the what, my lord, the issue comes. My lord, 16. My lord, we have been able to call out the seniority lists of some of the high courts. And here your lordships will see, let's say, my lord, Kerala. This is the seniority list. So Kerala has promoted district judge, promotee. So fair number of promotees at the top. In Patna, if your lordship sees, district direct recruit, then my lord, some promotees, then direct recruit, and then everyone direct recruit. So here we feel that if all these promotees will be older in age, my lord, to the direct recruits, and they will all retire before the other direct recruits, and the entire cadre at the top will become direct recruits. That is one of the things. Similar
in Patna, that happened because 94 district judges were taken at one go.
It is mentioned in the affidavit. I'll show that.
That is why it
So that could be the reason. Yes, the reason is not stated obviously in the affidavit.
For 7 years, there was no recruitment at all.
Yes, ma'am. Right.
In Bombay, I think out of 21 study was happening the other day, 18 or 19 are direct.
Yes. So all I'm trying to say is that this clubbing at the top is the problem. And the clubbing will happen because even if a senior promoted judge is there because of a 10-year age gap, he'll retire earlier. Or a 5-year age gap, he'll retire earlier. So that's the problem. My lord, turning to page 17, my lord, I've just culled out a few, my lord, paragraphs of affidavits on both sides, saying against and for both. Now, if your lordship looks at 17, this is what state of Uttar Pradesh is saying. Para 25, bracket A. In the state of Uttar Pradesh, there are 70 district and sessions judges, of which 58 are direct recruit district judges. So, my lord, these are actually principal district judges. Although they've called them, but these should be principal. 58 are direct recruit district judges, 12 are promoted district judges. High Court of Allahabad in its affidavit stated as follows. Out of 257, 137 officers are promoted judges by regular promotion, 2 officers are promoted judges of LDCE, 118 are direct recruits. Out of 100 senior most officers, 17 are promoted judges, regular promotion, 2 are promoted judges LDC, 81 are direct recruits. Senior most promoted judge features at serial number 29 in the seniority list. Therefore, posts at serial number 1 to 28 are occupied by direct recruits. The High Court is saying. Now, my lord, similarly for Bihar, your lordships had said there's a reason for it, but anyway, I'll place it. Out of 622 occupied posts, 91 judicial officers are working as principal district and session judge, consisting of 5 promotees and 86 direct recruits. As per seniority list and detailed chart, there are 20 direct recruit judicial officers presently below the 91 judicial officers working in the rank of principal district and session judge, meaning thereby that after the retirement of 5 promoting judges in the rank of principal district and session judge, all posts in the said rank will be occupied by direct recruit district judges. This is what this is. Then some others are there. I will not read all of them, but just if your lordship would just come to Andhra, because Andhra gave that suggestion. So let's see what they've said fully. That's at page 19, page para J. The High Court of Andhra has stated in its affidavit as follows: whereas candidates appointed to the post of district judge by direct recruitment are generally in the age group of 35 to 40, thus promoting officers always become juniors of direct recruits. Despite having put in more than 25 years of service, promoting officers retire in the cadre of district judges as they are junior to direct recruits and do not fall in the zone of consideration, and the judiciary is deprived of experience at High Court level. As per present seniority list, first 17 members were selected as district judges by direct recruitment, and considering their age, the promoted district judges will not get the opportunity to be considered for the post of High Court judges, even though they have put in 25 years of service. In the light thereof, the committee has made the following recommendation. Distinct seniority list should be maintained for each category of district judges: 1 direct recruitment, 2 recruitment by LDCE, 3 recruitment by promotion. Recommendations for appointment of High Court judge should be made within these specified categories. Initial appointment ratio for district judges shall be consistently applied for subsequent appointment as principal district judges and further for High Court. The committee unanimously resolved to recommend that that 50% of appointments to the High Court from in-service officers should be drawn from the category of district judges who were initially appointed in the cadre of Civil Judge Junior Division, ensuring adequate representation. This is not the issue today before your lordship, but this is what the High Court has felt. Looking at the skewed ratio there, this is what the High Court committee itself is saying. This is not one of my suggestions, or this is not even the issue here today, but I'm just pointing it out.
You had told that even in state of Tamil Nadu also there is similar.
Tamil Nadu, I'll just show it. That's I think mentioned here. Just 1 minute. Tamil Nadu in their affidavit have said that 37 principal district judges, 27 are promotees and 10 are direct recruits. That they've said. At page 22, I've summarized it. In fact, page 20 onward, this is the view of some of the other states who have said that either the ratio is the same or promotees are more. So that also I put in. So, my lord, Chhattisgarh, Gujarat, Himachal, Jharkhand, Madhya Pradesh, Mizoram, Nagaland, Tamil Nadu, Sikkim, Uttarakhand, West Bengal, Delhi, and my lord, Jammu and Kashmir. So they are saying that in their states there are sufficient number, if not more, promoting judges. They have said that, so I put that also for your lordship consideration. Now, my lord, the other submission which I had made, which has been now set out at page 23, bottom, my lord. I'm just skipping over a few paragraphs because that we've already, my lord, covered that. My lord, para 31 at page 23. However, on account of the age by which promoted district judges are appointed to the post of district judge entry level, they suffer disadvantages in further promotions within the cadre. This is evident from the following. 1. First criteria considered by the High Court for promotion to district judge entry level to district judge selection grade is at least 5 years service as district judge entry level. If a promoted district judge is already appointed at an age far more than direct recruit judge, by the time a promoted district judge completes 5 years to come within the zone of consideration, the direct recruited judge of a similar age would have already completed 5 years and be within the zone of consideration for district judge selection grade or even district judge super time scale. Though selection and promotion in the cadre or oblique promotion in the cadre is on the basis of merit cum seniority, to be within the zone of consideration is also a facet of seniority, since the said zone of consideration depends on a number of vacancies. For instance, with respect to Delhi High Court, the zone of consideration is as follows. Delhi has 1:5. For 1 vacancy, for 2 it is 8, 3, 10, etc. And for Assam, Manipur, Meghalaya, Nagaland and Tripura it is 1:3. The ratios of 1:5 or 1:3. Next, my lord, if your lordship comes to my lord, para 33, which is at page 25. It is respectfully submitted that the benefit of limited departmental competitive examination, which has been given by this Honorable Court as an accelerated promotional avenue for Civil Judge Senior Division, has not led to an equalization in the District Judge cadre. Now, this I am saying before your Lordship May judgment. This is obviously not, that's not taken into account. Limited quota for LDCE was introduced in 2002, but data shows that it has not led to a significant reduction in the average age of promoted district judges vis-a-vis directly recruited district judges, because 50% of the promoted district judges are recruited in the cadre via a regular promotion, and in general, promoted district judges enter the cadre at a higher age. In this respect, paragraph 12.108 of the Justice Shetty Commission and the chart appended thereto becomes relevant, which I have shown it to your Lordship. Since 2002, 75% of the posts in the district judge cadre have been kept for promoted district judges, being 50% by regular promotion and 25% by LDCE. However, the data provided shows no equalization in the higher posts within the cadre of district judges. It is then, my Lord, I have given these examples which I have already given to your Lordships. What is the minimum time that you take as a direct recruit promotee LDC? So that I have already shown to your Lordships. And then, my Lord, there are some paragraphs of this 2025 judgment of your Lordships in, my Lord, in the Dheeraj Moore case, which I have set out at page 26 for your Lordship's consideration. Because to justify this quota, I am saying that there is a classification necessary, and that is a justified classification. One of the grounds will be this. May I read that, note at para 36 at page 26. In a recent judgment, Constitution Bench of this Honorable Court in Rajneesh versus Deepa, in the context of eligibility of a judicial officer to be eligible for appointment as a district judge under Article 233 of the Constitution, held as follows in the majority judgment. Therefore, the question that is required to be considered by us is, if the purpose of recruitment is to get persons of necessary qualification, experience and knowledge of life, then as to whether the judicial officer who is in judicial service could be denied an opportunity to be recruited in the posts meant to be filled by direct recruitment. In that respect, we are of the considered view that it cannot be denied that experience a judicial officer gets by working as a judge can only work to the betterment of the district judiciary. The question that we would have to therefore consider in the present case is to whether such experienced persons having rich judicial experience can be permitted to participate in the process of direct recruitment for the post of district judge. I am using this to say that that rich experience can very well also apply for this the present purpose that we are not arguing before your Lordships. We are therefore in full agreement with those observations made by Shetty Commission, according to which, in order to promote efficiency in the cadre of district judges, young, talented, meritorious judicial officers should not be denied an opportunity. Experience of a judicial officer. As a matter of fact, some of the observations made in the subsequent three-judge bench judgments of this court in the cases of Sushma Suri and Deepak Agarwal would support the view that we have taken. In both cases, this court held that merely because by virtue of being government advocates, the candidates who were in employment, their rich experience of working as a lawyer for government cannot be ignored. It has further been held that they continue to appear for the government side, either on civil or criminal side, the rich experience would benefit the judiciary. As already discussed here and above, the experience the judicial officers gain while working as judges is much greater than the one a person gains while working as an advocate. Apart from that, before commencing the work of judicial officers, judges are also required to undergo rigorous training for at least 1 year. And then, Lord, I'm skipping 147, 148. We therefore see no reason to deny an opportunity to such young, talented judicial officers to compete with advocates and pleaders having 7 years practice in the matter of direct recruitment to the post of district judge. Then, Lord, 157. In that respect, we are of the considered view that for bringing the advocates and in-service candidates at the same level, it will be appropriate that rules provide an in-service candidate should be eligible for recruitment to the post of district judge directly, only if he has a combined experience of 7 years as advocate and judicial officer. Similarly, if an advocate in participating in the selection process and he was a member of judicial service in the past, then his experience as judicial officer also cannot be ignored. His experience as an advocate prior to joining judicial service, his experience as a judicial officer, and his experience as an advocate after leaving judicial service will all have to be taken together. Such candidate will be eligible only if he has a combined experience as an advocate or judicial officer for 7 years. So, my Lord, this judgment is proceeding on the basis, at least from what I've quoted, that judicial experience is very valuable. And according to my submission, which I made subsequently with some cases, that experience of a judicial officer from the civil judge cadre is a valid ground for creating a quota as a valid classification. That's the way I've tried to put it, Lord.
Mr. Michaels,
Well,
when the Suprime scale or the selection grade
Yes.
is done,
yes.
the experience
as a district judge is taken into consideration, which is equal for the direct recruit as it is for the promoting district judge.
Correct, but the rules, sorry.
So the experience that you are talking of, the rich experience which cannot be denied, is equal for all of them.
No, my lord, what I'm trying to say.
You are trying to again add on the experience of a civil judge junior division.
Correct.
Which is a thing which has already been factored in when 50% of the district judge posts have been reserved for the promoted district judge.
No, so that.
So won't it be amounting to a double benefit?
No, my lord, it is not a double benefit for the following reason, that within the cadre, when a district judge, a direct recruit comes in, he's starting from zero. He's starting from zero. A civil judge is coming in, your lordship, it may be a ground for his promotion to the higher cadre, but his experience is not wiped out immediately on promotion, is what I'm trying to say. The experience still remains. It is tantamount to saying that whatever experience of 15 years you've had is wiped out on becoming a district judge. With great respect, my lord, is my submission, ought not to be, my lord, considered in that sense, because a district judge, the direct recruit, has zero experience. So you are in that sense equating zero experience with, let us say, 15, 10, 12 years of experience.
Like something. So Bhatnagar, there is one another issue. Now, with the data you have presented as of now, in the cadre of district judges, all of them were recruited as junior division at the age of 27, 28. Because at that time, there was a prescription of practice. Now, for the last 1 decade, the things have drastically changed. They get into this thing at 23. We cannot go by this data alone. With 35. Last 2 decades. So that is, this data cannot be relied on. Because now the people are entering as a junior division at the age of 23. With the LCE also, at 35, they get a chance to go to the district judge level. The entire data would change.
No, so they get a chance to go into the district judge level by taking the direct recruitment examination. That's what your lordships are saying.
Direct recruit and LCE also.
LCE also, but whatever stage, yes.
Now, when you say that the 50% are there, that is an informed choice they took.
No, my lord,
to join as junior division.
I am saying, no, my lord, of course it's an informed choice, but I am saying that this data is of at least from the year 2002 onwards. This data is not incorrect after that.
No, because the district judge cadre now has people who are recruited at the age of 27, 28 as junior division.
Yes.
That has changed now. For the last 2 decades, it's 23, 24.
No, correct. So in 2002 judgment, your lordships did away with the experience and again reinstated it now.
That is 3 years.
Correct. That's right. So let us say you come in at 23. I'm saying even then, if the disparity is so much, today the disparity will only increase. This data, my lord, whether we take it for 20 years, this data of disparity will coming in at a younger age.
As Justice Bakshi said, you can probably provide a seniority at the time of recruitment. After that, how can it be?
No, but
then you will be creating an artificial division between promotees, LCD, and direct recruits.
No, that artificial division, in my respectful submission, is a valid classification, because you're taking it, as your lordships have held this very judgment that I read out, that judicial experience is important. So if judicial experience is being taken for taking the direct recruit examination as being
Yes, Bakshi said that judicial experience is factored at the time of promotion, LDC and all that. Why should it be considered at the time of super time scale? Because then what is considered is the experience as a district judge.
So that is exactly what Justice Shetty also said. I'm not the only one saying it. Justice Shetty said it slightly differently. He said that you have to give them seniority in the cadre because of the experience. There also they've come into the cadre immediately.
That was not accepted.
Not accepted, but I'm commending it to your lordship. That considers the data of 1999 and came to this. After all, one thing is classification. The other thing is equalization also. If 50% of the cadre finds itself in a position.
Is there any critical analysis by you based upon a comparative examination of the rule regarding determination of seniority in different states or in different high courts?
Yes.
That the anomalous situation between promotees versus direct recruit, is it originating as a result of the seniority rule or as a result of the manner of recruitment?
So it is, yes, I've given a summary of all the rules.
The experience showed that if you go by the ordinary principle of recruitment, there will be no heart burning among the promotees, because as soon as the promotee vacancy become available, the High Court will either go by merit cum seniority or the High Courts will go by this LDCE. Whatever, 10% or now 25%, earlier also 25%. The problem has most of the cases arisen only on account of the direct recruitment taking place, say, after 5 years, and then you are getting the roster points of direct recruit in a presumed either rota quota or implied rota quota, and then you are getting a placement in the seniority list where you are not even born in the cadre, and that has been largely the.
So that is one issue definitely. But the age discrepancy is also a very important issue. Not how do we ignore that? Not let us take the worst case scenario.
Mr. Marcus, one issue also has to be taken into consideration as to why in 2002 judgment of the All India Judicial Association, the lateral entries were permitted. It was to infuse more talent at various levels of judiciary, and the promotion at every level, including the functional scale promotions or upgradations, are essentially on merit and not only seniority, that is age. That cannot be, you have to factor in that.
I'm factoring that in more. And I'm saying to your lordship exactly what Justice Shetty is saying, that although it is merit come seniority, but to come within the zone, you have to be senior enough. You don't even come within the zone.
That is something which is not a classification of an uniform cadre, that is district judge, but giving some more additional handicap or advantage.
Some advantage.
To be promoted. That is well taken.
Correct.
But what is falling from us is that if your suggestion 1 or 2 of a quota in the functional levels are taken, or separate, as Andhra Pradesh has suggested, separate lists are maintained.
Correct.
We are actually creating separate classified stratas in an uniform cadre.
Which
perhaps may be a problematic.
Which I agree with your lordships. If let us assume, my lord, it is.
So if you want that age, there may be an area of exploring as to what additional advantages and weightages can be given to these promotees.
So, my lord, there is only one weightage, which is the weightage that was suggested by Justice Shetty, which is one of my suggestions.
So, Marcus, another issue is, as it is indicated to you by Justice Chandra, that see the evolving nature of the cadre. The cadre essentially started functioning for the last 2.5 decades.
Right.
It definitely gave an advantage to the direct recruits because of the age differential in the initial stages.
That's a submission.
And I can speak from my experience in West Bengal, today there is an equalization in the cadre. And the percentage of recruits from the direct channel and from the promotee channel are almost balancing out. So to make some changes, we must also bear in mind the evolving character.
Correct. So I've placed those states also where there is an equalization, such as West Bengal. But, my lord, please consider, does this quota work against the direct recruits? If they are getting, let us say, 50% quota for 25% of the cadre, that actually works in their favor. Is my great respect.
You are dampening the merit factor. And you please bear in mind that the functional level upgradation is also merit cum seniority. There we are, in fact, in some way restricting the Article 233, 235 powers of the High Court to make a merit-based selection.
It is restricted. That's one of my submissions, because otherwise, my lord, suppose it was not, it was fully being followed on merit cum on the seniority.
Better boy, quota mein.
Have you done any comparative analysis of the
rules?
Seniority?
So, yes, I have. There's a summary chart that is filed at the beginning of a compilation with every single High Court seniority rules, and they're all saying, my lord. Correct. So, there they are saying seniority will be, most of them or all of them, that seniority is determined by the 40-point roster. Now, the problem is that, now let me tell you the problem.
So, the 40-point roster must be creating problem.
It certainly is.
Direct recruitment takes place in 2025.
Yes.
Vacancies of the year 2020.
Correct. So
that person suddenly occupies a place
absolutely
in 2020.
Right. Correct.
And those promotees in 21 to 25, they become junior.
So that is absolutely correct.
Therefore, That's why we are saying.
No. Your lordship's analysis is absolutely correct. That the roster system, in fact, that's why I've said the roster system requires a rework.
हर स्टेट में रूट कॉज होते हैं.
And, my lord,
Roster failed because of internal mismanagement.
that maybe there, my lord, that I
The
can't.
appointments were not regularly made for.
That's
the
right.
captains.
That's right. If it was made, it
You see a situation
correct. my lord.
where unforeseen circumstances, including administrative roadblocks,
Yes.
disable the roster system. That does not mean that the roster system was incorrect.
No, my lord.
There requires some tweaking in the functionality
And
itself.
not only that, so the roster system, the other problem with the roster system is, I find it very hard to believe that we have a situation where the 40-point roster seniority, because seniority is by the roster, continues for all three grades of the district judge cadre. If merit comes seniority,
Creating the district judge cadre, once you come into the district judge cadre, it's an uniform cadre.
It
You
is-
have already been given your advantage in the roster system of 2:1:1, which is the general roster followed in every state.
correct. So that advantage or according to me, it's not an advantage at all, which is what I'm trying to show to your lordships, because the roster is a seniority roster. Anyway, my lord, I will
We
just,
have to conclude because.
yeah, so my lord, I'll just take 10 minutes to show one or two cases. I'm sorry, my lord, I got a little carried away in this. I'm very sorry, my lord.
Yes.
I'm sorry, my lord, I took too much time. Would your lordship just come to page 29? I've set out 3 or 4 judgments, which according to me, my lords, are relevant. My lord, now I will not read all of them, but I'll just, my lord, since time is short, I'm just going to, my lord, summarize them. The first judgment, my lord, which is Mervyn Coutinho versus Collector, and the next judgment, I've set out the paras for your lordships to consider later on, and the other, which is Roshan Lal, my lords, deal with a situation as to whether persons drawn from different sources into one integrated class can be further classified. So that's the question. So now these two judgments, my lord, in the case of one was a customs department case, and the other, my lord, was a train examiner's case, said that you couldn't. I've set out the facts also
According to Mr. Basant, these judgments are against you.
against me. So now, therefore, my lord, I'm requesting your lordship to come to page 33, because this is the judgment which, according to me, another constitution bench, which is what I'm relying on. So for your lordship to consider. My lord, would your lordship later on just have a look at it? I've set out all the paras. If I read it, it will take too much time of both Roshan Lal and Mervyn, my lord. That's against me, correct? So I've placed all the paras. Please come to page 33, para 40. In state of Jammu Kashmir versus Triloki Nath Khosa, a constitution bench of 5 honorable judges considered the question of classification based on certain identified criteria. This honorable court considered both the above judgments, which is Mervyn and Roshan Lal, in the context of the following question. If persons drawn from different sources are integrated into one class, can they be classified for the purpose of promotion on the basis of their educational qualifications? That is the issue for consideration before us. The case involved promotion to the post of executive engineers from assistant engineers. Under the rule in question, it was provided that those assistant engineers would be eligible for promotion who possessed a bachelor's degree in engineering or held the qualification of AIME and had put in at least 7 years service. Honorable Court held that such classification was permissible for first identifying and then distinguishing members of one class from another, as the classification rested on reasonable basis and bore nexus with the object in view. You know, there are some paras, may I just read these? I'm sorry, there are 8 or 9 paras of this judgment. Judicial scrutiny.
You have 5 minutes left.
My lord, then, my lord, then I won't read.
Or the others will have to curtail the time.
One of the most celebrated judges.
So I'm not reading it. I'm not reading it. My lord, just 2 points here on this judgment. I'll just mention the points at least your lordship may permit me. Para 30, page 35, if your lordship just sees, the distinguishing features between the case and Roshan Lal is at para, my lord, 45 onwards.
Yes.
And Mervyn Coutinho is distinguished at para 49. Correct, my lord?
Yes.
Now, please now permit me to read para 41. So, my lord, now because it's saying on a reasonable classification, you can have a promotion within an integrated class. Now, my lord, please let me read para 41.
Para 40.
41. This honorable court in a 7-judge constitution bench, now this is a recent judgment of last year, State of Punjab versus Davinder Singh. So this is not a sub-classification judgment. While distinguishing the judgment in Roshan Lal and held that Trilokinath is the leading judgment for the proposition that the integrated class can be further classified if there is intelligible differentia and if the yardstick used has a nexus to the object of the provision. Reliance in this connection has been placed on paras 88 to 90 and 308 to 310. But 88 to 90 was of the then Chief Justice and 308 to 310 is of my Lord the Chief Justice. And my Lord had in fact agreed and concurred with that.
Yes.
So, my Lord, I am saying 7 judges have now in a sense upheld Triloki. So, there is no question of further reference as was being argued the other day. That's my submission. This is the position. Next, my Lord, there is a judgment that I have cited.
That may not have any application. Look at page 50. That Lokinath Khosa applies this classification only on the basis of educational qualification.
Correct, absolutely right. No. Now I'm saying now experience as a classification. Also, I put a judgment. Experience being a valid ground for classification. For that, I was just coming to that. In fact, my Lord, please come to page 44.
42.
44, para 45.
Yes.
This is now, my Lord, Jagannath versus Union of India. It has been held that classification based on experience is a reasonable classification. In paragraph 7, in so holding, Honorable Court followed the judgment in state of UP versus Chaurasia. This is what Chaurasia says. Article 14 permits reasonable classifications founded on different bases. It is now well established that classification can be based on some qualities or characteristics of persons grouped together and not in others who are left out. These qualities or characteristics must, of course, have a reasonable relation to the object sought to be achieved. In service matters, merit or experience could be the basis for classification to promote efficiency in administration. This is the line I am relying on. Rest, I will not. Just mention one judgment for Lordship's consideration, which is Kuldeep Kumar Gupta. It's a 2-judge bench, but all these aspects have been considered in great detail. It's page 40 onwards of the submission. The paragraphs have been set out.
Paragraph 43.
If I read it, then it will take 10 minutes to do that. These are, my Lord, the points for Lordship's consideration. Oblige.
Thank you. Yes, Mr. Giri. You are next in line. Okay. No, your list shows that you are prior to Mr. Dwivedi. You are applying for Kerala High Court.
Page number.
इसमें भी होगा ना?
Yes.
Is it going to compare it?
We are all interveners, but I am representing promotees from state of Bihar.
Promotees from state of Bihar.
We have filed a separate written submission too.
So is this yours at page 1?
Is it placed where? Volume 1?
Volume 1's Lordship,
Page 100.
169. I understand, sir, this is your
But
page 169.
there is one physical compilation too, where the latest written submission which I could muster, I have submitted. I won't be taking lordships to
On behalf of Rakesh Kumar.
Rakesh Kumar.
That's at page 168 of the.
168 of volume 1.
Right. 168 physical.
But I am not relying on the facts and figures. They have already been disclosed to Lordship's Lord. There's no point in wasting Lordship's time on that. Fact remains, Lord, insofar as state of Bihar is concerned, and along with couple of states from the facts as emerged from Amicus's written submission, Lord, there is a mixed kind of a, not perhaps indication. In certain states, the roster application to seniority has caused a little problem, particularly in my state of UP, and perhaps in certain other states like Andhra Pradesh and all that. But in certain states like Bengal, Madhya Pradesh and all, perhaps the situation has not been that troublesome. It's been quite fluid. So I would not be relying upon the fact that the percentages of posts that have been occupied by the promotees and direct recruits, that may not furnish a very strong ground for perhaps suggesting a rule of seniority. My submission is slightly different in the sense that, Lord, prior to 2002, the rule of seniority invariably and universally followed was the date of substantive appointment with the date of entry into service, and therefore your seniority will count on from that date. That was what was said by the Constitution Bench in direct recruits case. So what your Lordship said, that date of vacancy is not relevant. Retrospectivity cannot be given to the appointment. So the critical factor was date of substantive appointment into service. That would be the commencement of your seniority or the reckoning of seniority. It was in 2003, as a consequence of Shetty Commission's recommendation, Lord, that the Lordships changed the rule of seniority. And perhaps it seems the Lordships were impressed by Sabharwal's case, the enunciation of a roster application, and applied that to seniority. Lord, when this was done, Lord, when this seniority rule was changed, Lord, what was not pointed out to the court was, Lord, that Sabharwal case is a case which is of a single selection. In other words, that was a case where promotees of different castes were vying with each other for, under different quotas, were vying with each other for promotion. So it was a single selection taking place simultaneously for everyone, and therefore adjustments could be made. It could be made through roster also, there was no difficulty. But in our case, tragically, my lord, the selection is threefold. One by direct recruitment, the other by the LCE category, and the third is by promotion. And all the three selections take place at different points of time. Sometimes direct recruitment doesn't take place, sometimes the promotion is delayed and so on and so forth. And consequently, then it becomes difficult to adjust by operation of the same roster. And what I borrow and which fell from Lord Justice Surikant was that the difficulty is arising when you start adjusting people who are promoted in the next calendar year into the roster and allow them to score a march over the others. One factor has to be kept in mind is that date of entry into service cannot be wiped away. We cannot go by the period of selection or the commencement of the selection or the advertisement of vacancy and all. That cannot count for the purposes of seniority, because otherwise we'll be giving retrospectivity to the appointment or promotion. Now, keeping this factor in mind, that retrospectivity beyond the date of a substantive appointment cannot be given, then we must, and we have to consider how to apply the roster. Roster can only be applied, Lord, if Lordship would see the Lordships in Sabharwal in the 2002 case, Lord, followed Sabharwal's case without looking into the fact that it was only single selection, and therefore there was no difficulty in applying the roster. They applied it here.
But the difficulty here was a threefold selection which were not being held simultaneously. And this difficulty was felt by Malik Mazhar Sultan, 2006 and 8. And therefore, their lordships recommended a time schedule simultaneously starting and concluding, so that all the three conclude at the same time, and then the select list is indicated, and then the appointments are made. Therefore, the year of recruitment would always be the same. And then you can adjust it in the roster conveniently without any difficulty. Or the other thing could be perhaps that you hold the separate selections separately and wait the select list till all the three selections are concluded and then issue appointment letters. There may be a gap of 6 months, 5 months, or maybe 10 months between the three categories of selection. And then thereafter appointment letters are issued. That perhaps will reduce the difficulty in fitting it seniority via roster. If this cannot be done, Lord, then the only way possible in my submission, respectful submission, is keeping the first factor in mind that no retrospectivity can be given to the appointments. The only way to adjust seniority via roster is that we have to run the roster year-wise. For instance, supposing selection commences, any selection commences, direct recruitment or promotion or otherwise, and it will always be the effort of the court and lordship that the selection would start, all the three selections should start simultaneously, close by. Now, once the selection starts, the roster revives. So roster comes into being, and roster has to be yearly roster. It can't be roster for n number of years. And that is where the problem which Justice Surikant pointed out will arise. If the roster runs year-wise, then supposing the direct recruitment takes place in 2018, and for some reason or the other, administrative reason or the other, or difficulty, or maybe a challenge, something like that, that they postpone the other tests or other selections are postponed to the next calendar year. Then the person who gets appointed in the next calendar year cannot be fitted into the roster points of this recruitment year. This recruitment year must end by 31st of December if it is calendar year. And the roster can run only till then. Whoever is appointed, direct recruit, promotee, or LCE, whoever it may be, he will be fitted as per the roster and will be there in the cadre of the additional district judges. The others who come later on next year, supposing the exams or the selection of the promotees is perhaps extended to the next calendar year, then the roster of next calendar year will have to be adopted and utilized. It can't be the earlier year, because then otherwise difficulty is, for instance, in the case of Bihar. What happens is the first three posts go to the promotees, the fourth goes to the, as per the roster, to the direct recruit. And then again 5, 6, 7, and so on and so forth. Now, if we, supposing the promotees promotion is not concluded in the calendar year, then the difficulty would be how to fit the direct recruit, because he's at item 4. And the promotees who get selected in the next calendar year or recruitment year, they come and occupy space before the direct recruit, and that can be vice versa also. So what I suggest, with humility, that lordships must look into this aspect, that the roster operation has to be yearly. It cannot extend beyond the calendar year or the recruitment year. Whatever recruitment takes place in any of the categories, they have to be fitted as per the roster.
According to it cannot be carried forward.
You can't be carried. Because the moment you start carrying forward, then the discrepancy and the haphazard allocation would start coming in. For instance, let's take a case, 3 promotees are appointed in 2018. The direct recruit selection couldn't conclude by 2018. Then we can't fit Lord, next year when the promotees come in or the remaining promotees of 2018, they can't be fitted into the roster because Derek Recruit occupies the 4th place. He gets selected in 2018, comes and sits over the other promotee. So that haphazard and perhaps incorrect, inappropriate application should be avoided. And the only way to avoid is to run the roster till the end of the year, and then whoever gets appointed for whatever reason, whoever gets appointed next year, he should come and fit in to the roster of the next year, so that he will always be junior. Not the basic rule is someone who comes into service in the succeeding year cannot not precede the person who's already been appointed substantively on his post in the earlier year. The person in the earlier year will always be senior to the one who's appointed subsequently. So this broad application of roster perhaps would resolve all the controversies with regard to the seniority aspect. Now coming to the other aspect, the promotees, because Your Lordship has seen the difficult position of the promotees, particularly in my state, UP is also, and certain other states, Rajasthan, Gujarat, they all having the same, suffering the same fate. So what I submit with respect is, that there is no doubt that once the selections to the post of additional district judge or district judge entry level, we in UP called it additional district judge, but in perhaps Bihar it is entry level district judge. Once they are appointed, they merge in the common cadre. There can be no dispute about that fact. I am not saying create a class within the class for further promotion. That's not the case. All that I'm saying is that since there are quotas prescribed for district judges level posts, it would be appropriate to facilitate the smoother transition to the higher category of posts by giving separate quotas commensurate to the population of the judge in the cadre. For instance, promotees, they are 50%. So you can give the quota of 50% in the principal district judge category. Likewise, about 25% direct recruits, they can get the quota of 25% in the principal judge category, and so LCE and so forth. What happens here is that we are not categorizing or classifying, or we are not denying anyone the promotion. They're all getting their due chances within their the population which the sphere which they occupy in the post of district.
Would it not be unfair to those coming through limited competitive?
No, they will also get 25%.
They get 25%.
They'll get.
They, on account of their own merit,
No, they
have come earlier in the cadre of district judges.
But can you bear in mind, as pointed out by my friend,
they are again pushed back. So those persons who are enjoying the office without trying for competition to excel themselves, they will get it as a bounty.
No, then they have their own quota in which they can go up. It's not that the quota is not blocked at the top. Quota is open at the top. 25% LCE, that's an incentive given to those who want to get the faster promotion and are meritorious, more meritorious perhaps. Then they have their quota within which they can go 25%. And 25% would be more than adequate to accommodate all the LCEs. The Lordships have seen the data, Lordship has seen. Lordship would not get so many LCEs who can go over 25%. Likewise, on the other hand, look at the promotees. They form the bulk of the population in the cadre of district judge. And yet, from 26. The fact is, from 2026 onwards, there would be no principal district judge in state of Bihar belonging to the promotee cadre, 50% quota. There would be no till 2035. And what will happen thereafter, we don't know. So the question is, at the moment, there are 90 principal district judges, out of which 85 perhaps approximately are the direct recruits, and 4 or 5 I think perhaps are
91, 86 and 5.
Now look at this, there's a skewed consequence. The 50% of the population has only 4 seats, while the 25% of the population.
Because of that anomalous situation. 7 years, no recruitment.
Not that anomalous situation happened. Not that anomalous situation happens even in the promotee cadre, because we got recruited in 2001. We got promoted as civil judge senior division in 2014, and then 2018 as district judge,
Yes.
and entry level. So it has taken nearly 17 years for us to reach that stage. And at every stage, we have been considered to be meritorious to be selected for the higher grade. So it's not that we were worthless kind of, or the deadwood, as the lordships call it. So looking into this, my suggestions are twofold. One, let the seniority be determined on the basis of roster. For instance, in this case, in the state of Bihar, May 2018, direct recruits got recruited into the cadre. And in December 2018, the promotees got recruited into. Now, both came in 2018. So it won't be a very big catastrophic loss to anyone if 4 or 5 months loss here and there, but at the same time, you can adjust them very conveniently into the roster of that year. Now, if we start counting seniority by month and days, perhaps they may have a cause. But the fact remains, it can't be done. Not? We are looking at the overall picture, how to run the system smoothly. So there, some casualty here and there will be there. So, but by and large, this system of running the roster per annum will reduce the friction to the minimum and let the system function smoothly. Add to that the quota for the principal district judge category post. For the separate categories, there is no classification as such. The Lokinath Kosa's rule will not apply here. There the rule was that the person who could have otherwise secured promotion, if there was no rule prescribed for higher education for further promotion, then he would have secured further promotion. So by this prescription of qualification, additional qualification, he got denied the opportunity. But here there is no denial of opportunity. We are giving commensurate quota to each category depending upon what the quota was in the earlier category.
So if the roster is to operate annually, the direct recruitment process starts, let us say in July. In June, July, we issue the advertisement, invite applications, hold preliminary exam, then written main exam, then interviews. And by that time, we are somewhere near end of the December. Someone filed the writ petition in the High Court. The declaration of result is stayed.
That happens.
Right? 31st December passes, New Year comes, writ petition is dismissed, found to be frivolous. What will happen in that case?
No, they are not in that particular list. Your lordship can always grant a decree or an order that can restore the loss.
Deeming fiction will have to be created.
Not
that for
fact remains-
intentional purposes,
Quite.
but for an unforeseen circumstance.
Quite right.
They would have been appointed.
Quite right.
So therefore, you will create a deeming.
That very often lordships do, my lord. If consideration has not been done
So
timely, then lordships direct that they will be considered with effect from that.
The other side argument will be that if you have an annual roster and you fail to hold examination for any reason, not only fail to exam, you hold the exam, but if you fail to make an appointment for any XYZ reason, why eventually the finally selected candidate should suffer?
But may I answer this, bro? We cannot bring about any perfect system. Your lordship would never have that. There will always be a dispute. And people will dispute. We have been seeing it right from the days of Patwardhan Lord till date. Lord. Some dispute or the other comes whenever there are twofold quotas. But the issue and the idea which I am suggesting is to have the minimal friction, minimal disturbance, and minimal heartburning on either side, all the three sides. There would be some, there's no difficulty in that. There would be some which will require resolution, spot resolutions and things like it as and when it is required. But the fact remains, by and large, things should proceed smoothly. As the lordship said, not 2018, if this direct recruitment concludes he will be the direct recruits will be adjusted against the roster of 2018. But on the other hand, the bigger anomaly occurs, as your lordship noticed, not that if we start adjusting people of 2018-19 selection in the year roster of 2018, then it becomes a little more anomalous. So let's see where perhaps the least amount of friction, least amount of heartburn, and least amount of difficulties. Obviously, we cannot have a perfect system. That is what I'm suggesting. And coupled with the quota at the top, perhaps each segment will proceed smoothly in its own. That's my submission.
Yes. Yes, Mr.
I'm grateful, Lord, and that before I end, Lord, there's one apology of mine, Lord. Sincerely, Lord, I must say, because on the last occasion I had mispronounced Lord Justice Chandran's name, Lord.
No.
So I'm extremely sorry for that.
N is an addition we have in South India. No big deal.
Well, that can be sorted out over a cup of tea or coffee also. I'm grateful.
Please, Your Lordships. Your Lordships, I'm appearing for the LCE category, Your Lordships.
For the
LCE category, Your Lordships. Unfortunately, in this whole battle, Your Lordships, we are the grain which has been sandwiched between the two stones. And the benefit which was supposed to come to us as an incentive, Your Lordships, is not coming to us for the basic fallacy of every High Court treating us as a part of the promotee group. Now, Your Lordships, from All India Judges 3 onwards, there are 3 categories.
Belong to which category?
LDC. LDC. Your Lordships, from All India Judges number 3 onwards, 3 streams have been created. So, in terms of considering for making the cadre of district judge, there are 3 streams. There are not 2 streams, direct recruit and promotees. There are 3 streams which are direct recruits, LDCE and promotees, Your Lordships. What has changed over the years, Your Lordships, from the 2002 judgment to 2025 judgment is only the numerical quota of LDCE, which is 25%, then it came down to 20% and now 10%, and now it has gone back to 25%. But the concept with regard to it being a separate and distinct category has not been obliterated since 2002 onwards, Your Lordships. Now, for that purpose, let me just point out, Your Lordships, 2 or 3 concepts which are required for the purposes of clarity, Your Lordships, how the seniority list must operate. First of all, Your Lordships, the feeder cadre for the post of district judge entry level is what has to be taken as a unit. The unit is not the further promotional posts in the district judge cadre. So when we are looking at the cadre, as per all the High Court rules, which I will show to Your Lordships, the cadre is of higher judicial services cadre. And it is the post of the entry level that we have to look at, where the seniority and gradation list will be made. Thereafter, Your Lordships, it will move in accordance with that basic entry level seniority list. The further promotions will be on basis of that. So that is the first thing, Your Lordships, that the cadre has to be at the entry level. The second aspect that, Your Lordships, is that how do we rationalize and ensure that no category out of these 3 categories steal a march or are left behind for certain administrative exigencies. As we have discussed, Your Lordships, it just fell from Lordship, that for some reason, suppose a promotion DPC doesn't happen. If there is no promotion which is done for the next 3 to 4 years, as what happened during COVID period, Your Lordships, there were promotions which were due but could not be given because of the administrative purposes, then at whose peril will that period, which has a valuable period, which we have lost, Your Lordships, at whose peril will that period go? So that anomaly has to be adjusted. And how that has to be adjusted, your lordships, is my learned friend, learned amicus, has suggested 4 alternatives, your lordships. In my respectful submission, your lordship, each of the alternative is I'm sorry to say, a half measure. It is not a complete solution to the problem that we are facing. Many high courts have rules, and I'll just point out to your lordships, where the rules are on basis of cadre, rules are on basis of roster. However, they have not been applied consistently by the high courts. It fell from Justice Bagchi that the problem that is arising is not the methodology, but it is the application of the methodology, and I will show that also, your lordships. So the third aspect is this aspect, your lordships, that how is the quota to be worked out? Next aspect, your lordships, is whether it has to be worked out on the basis of post or vacancy. This is also a well conceptualized legal concept, your lordships. I'll give those judgments. That the roster has to operate on basis of post, which your lordship has also taken in account in the 2025 judgment of all India judges, that the vacancy will be filled up from the same category where the vacancy arises, your lordships. Like we just discussed, your lordships, if there is a retirement, suppose there is a death, suppose there is no further promotion, then those vacant posts on the roster points arise. Those will be filled according to the category to which the roster point belongs. Next aspect, your lordships, is All India Judges 3. The basis of All India Judges 3, your lordships, for adopting R.K. Sabharwal was that in R.K. Sabharwal, which is the locus classicus, the caste-based roster was the workable method by which now, as per the experience, your lordships, has not been faulted at all. The method of the roster is working perfectly. And in that also, your lordships, we have multi-layered quotas. One will go to the general category. Next will go to SC, ST, OBC. So these are four broad categories in which the roster works, your lordships. So the roster system, by administrative experience, has been working very efficiently in that caste-based reservation. And that is why lordships imported the roster system by All India judges, the third 2002 judgment, your lordships. That having been imported, your lordships, the rules were made by various high courts after 2002. However, now the problem that has arisen is whether continuity in service is to be the criteria for the seniority to be adjudged. Some high courts do prescribe continuity of service. Some high court says that it shall be irrespective of continuity of service. So length of service in the feeder post, some high courts have said that it will be considered to put you in the seniority list. In some high courts, they have said that it will depend on the roster point, irrespective of the dates that you come into the position. The argument that is raised against this by direct recruit, your lordships, is that you are not even born in the cadre. So continuity of service is the best method to adjudge your inter se seniority. If you are not born in the cadre, you have not been appointed to the post of district judge, you cannot seek seniority over a previously appointed direct recruit. Suppose I am a promotee, your lordships. My promotion batch comes in 3 batches delayed, your lordships. But direct recruitment has taken place, the advertisement has gone out, and the appointments are made. I am due for promotion, say, in 2000, your lordships, but my selection process does not take place in 2000, it takes place in 2003. So the 3-year gap, then I come under the rank of the direct recruit person who has come in 2000. So what lordships have said is that the period of continuous officiation will not be the criteria. Your seniority in the cadre will come according to your roster point. So if a promotee came at roster point 10, then even if I have come in 3 years later, I come in point number 10. And direct recruit comes under point number 11, then even if he has come in 2000, he comes at point number 11. This is the inter-se seniority roster, which has been, the mechanism has been devised, your lordships, and also has been followed in various rules. Now, the second, another aspect of this, your lordships, is that with regard to LCE particularly, there are 4 judgments I want to show to your lordships, where there have been conflicting aspects which have been considered by lordships, and there is no clarity. Therefore, your lordships will be required to give us clarity as to which of the 3 options is the correct option, which must be followed, which will be the most efficient option, your lordships. So I will just point those 3 judgments out to your lordships. Then comes the aspect, your lordships, within, now these are three categories at the same level. Now, within the promotees itself, what will be the seniority? What will be the basis of seniority? Now, between these 3 categories, your lordships, merit is the basic criteria, is the primary criteria, and that is why it is being incentivized for the LCE category. So when the merit is incentivized, your lordships, how is it incentivized on ground, your lordships? It can be incentivized only by me climbing the ladder higher, faster. But if I take the exam, I do very well in the exam or do badly also, but I clear the exam, your lordships, and I remain at the same position in the promotee list, your lordships, then there is no incentive for me to better my skills, your lordships. And from practical state-wise aspects, I can show to your lordships that promotees who took LCE exam, they are actually coming lower in seniority than higher in seniority. And I'll show from UP, because I'm appearing in the UP matter, your lordships, that they have come down in seniority. So many of them, what your lordships have found, that people are not taking LCE exam. They are not taking it for the purpose because in promotion they are rising faster.
But that now we have resolved.
No, your lordships.
Yes, because earlier they could not appear before completion of 10 years.
Correct.
Now we are reducing to 7 years.
That is one aspect. The second aspect, your lordships, is that despite my being eligible for taking the LCE exam, despite that, your lordships, now age, etc., has been resolved. But where do I fall on the seniority list? I'm still at the bottom of the seniority list. The pool, your lordships, have resolved that the pool will become bigger.
If somebody, suppose A passes LCD.
Yes, your lordship.
And gets promoted in 2020.
Yes.
The juniors will be, who are promoted subsequently from the promoting cadre will be always junior to him.
Your lordships, I'll show from the actual application, your lordships, that is not what is taking place on ground. Your lordships have set it out. Lordships have said that the rules will be formulated. Rules are formulated, but what is happening, your lordships, that the High Court are now using the roster year-wise or recruitment-wise.
This must be happening on account of the perceived strict observance to the roster point. That irrespective of you, as Honorable CJ pointed out, that irrespective of you qualifying in 2020.
Please, your lordship.
And at, say, particular roster point, say, for example, you are 12.
Yes, your lordship.
And the ordinary promotees, merit cum seniority promotees, if they have a roster point number 10 and 11.
Please, your lordship.
So even if they are promoted in 2023, they are being placed at 10 and 11, and resultantly you are stuck at number 12. That might be happening only because of misconstruction or misapplication of the roster.
I'm most grateful, your lordships. That is one of the reasons. And the other reason also, your lordships, is
so most of the cases, the seniority is being rostered by this roster.
Your lordships,
take it back to the date of vacancy.
Your lordships is absolutely right. Why that is happening is because it is controlled, the roster is not controlled as a running account on the basis of cadre strength, but it is controlled by recruitment. So the roster breaks. In the first year, suppose there are 20 recruitments, your lordships. After number 20, it restarts from number 1. Whereas it has to continue with number 21. So that is where the breakdown is happening. That it is selection wise or year wise that the roster is again put into play. So therefore, lordships will notice that normally in all high courts, I'll show the appendix, in the roster you have first 3 direct appointments, next 2 promotees, and the last, your lordship, LCA. So, or it varies from different, the numerical or the this thing, but usually direct promotee is the number 1 in most of the rosters which have been prescribed. Now, unfortunately, what is happening is that suppose 10 people have been selected in a particular year, your lordships, again direct recruitment come in the roster, higher in the roster, the next selection. So the breakdown is happening at that particular point. The breakdown, it is not that the rule is not providing. The rule is providing, but the way it has been applied, your lordships, at least in Uttar Pradesh, your lordships, is for this reason that it is applied on basis of continuity of service and it is applied selection-wise. It is not applied cadre-wise. Then the last thing that I want to bring your notice and attention to your lordships is, which is where there'll be some guidance which will be required by your lordships, is with regard to the selections which have taken place post 2002. Now, in 2002, your lordships had given them time to implement it, to amend the rules. The rules got amended. But again, our complaint is this, that the rules were not being followed as per the amended aspects, your lordships. So what about the selections which have taken place after 2002? Because in 2002 itself, it was mandated by this honorable court that this will now apply prospectively. Then from 2002 onwards, your lordships, my humble submission is that all selections which have taken place post 2002 have to be in accordance with the guidelines which have been given by your lordships in all India judges and what your lordships will decide today, your lordships. So that date, cutoff date, on basis of which the seniority must be drawn in the cadre, your lordships will have to consider and give that guidance. That what will be the date from which, because your lordships have, in all orders and judgments, even in 2025, your lordships have said that this will apply prospectively, the 25%. Then lordships have also said we'll amend the rules. The shortfall is not amendment of the rules. The shortfall, your lordships, is the application of the rules. Now, your lordships, shortly, I will just point out, if your lordships will just take R.K. Sabharwal for a moment, your lordships. Lordships will find it. Volume. Your lordships, volume 5A, page 360. Lordships, it's a short, concise judgment which is holding forth even today, your lordships. It has withstood the test of time.
It's 360.
360, your lordships. Volume 5A.
Not the volume you provided just now. No.
No, your lordships, that's 6. That's volume 6. This is the nodal council. This is the nodal council's volume 5A, your lordships. Yes. Page 360.
Which judgment?
R.K. Sabharwal, your lordships.
Yes.
Now, my submission, your lordships, with regard to R.K. Sabharwal is that, your lordships, this lays good law and it is a 5-judge bench judgment, your lordships, and that must be followed again and has been followed, and there is no cause to differ from this, your lordships. Lordships may kindly come to paragraph number 5. This was with regard to the Punjab Engineering Services, your lordships. And here the dispute was with regard to interstate dispute between promotees and direct recruits. The lordships have the SCR copies. Yeah. What is this? we'll see considerable force. Your Lordships will come to page 369, placitum D.
369.
Please, Your Lordships.
So I have a suggestion. Volume 3R has the SEC volume of Sabharwal, because I think if Ms. Makija is referring to para numbers, that may be more helpful. R3.
Thanks. Lordships may, I'm just reading the portion which is relevant. Your Lordships may mark it, it's para 5 in the SCC, and it is placitum D at page 44. Internal 44, placitum D in the SCR. We see considerable force in the second contention raised by the Learned Counsel for petitioners. The reservations provided under the impugned government instructions are to be operated in accordance with the roster to be maintained in each department. The roster is implemented in form of running account from year to year. The purpose for running account is to make sure that SC, ST, and OBCs get their percentage of reserved posts. The concept of running account in the impugned instructions has to be so interpreted that it does not result in excessive reservation. Then your Lordships will skip a bit and come to the middle of the paragraph where it is said, we see no justification. Lordships, then an example is given. And then if your Lordships will come to...
370.
Yes, your Lordships, page 370 top. We see no justification. We see no justification to operate the roster thereafter. The running account is to operate only till the quota provided under impugned instructions.
This is once that is complete.
Yes.
Then the person, the vacancy filing will be filled in from that category alone.
Please, Your Lordships. That is the principle. That's the clear-cut principle. And one more aspect which is clear from here, Your Lordships, is whether it has to be according to the post or the vacancy. If Your Lordships comes to the last portion of this paragraph, it says, the vacancies arising in the cadre after the initial posts are filled will pose no difficulty as and when there is a vacancy, whether permanent or temporary, in a particular post, the same has to be filled from amongst the category to which the post belonged in the roster. For example, SC persons holding the post at roster point 1715 retire, then these slots are to be filled from amongst the persons belonging to the SCs itself. Similarly, if persons holding the post at point 8 to 14 or 23 to 29 retire from these slots, are to be filled from among the general category. By following this procedure, there shall neither be shortfall nor excess in the percentage of reservation. Then, Your Lordships, next paragraph is with regard to the basis. What is the total strength on basis of which it will be calculated? It is the cadre strength and not the recruitment strength. The expression posts and vacancies, often used in the executive instructions providing for reservations, are rather problematic. The word post means an appointment, job, or employment, a position in which a person is appointed. Vacancy means an unoccupied post or office. The plain meaning of the two expressions make it clear that there must be a post in existence to enable the vacancy to occur. The cadre strength is always measured by number of posts comprising the cadre. Right to be considered for appointment can only be claimed in respect to a post in a cadre. As a consequence, the percentage of reservation has to be worked out in relation to the number of posts which forms the cadre strength. Now, under the UP rules, Your Lordships, the cadre is defined under Rule 2, I think, where it says that the service will be a single cadre called the Higher Judiciary Service cadre. So the cadre is the entry-level post that we are talking about. Then, Your Lordships, this has been now consistently followed. And if Your Lordships will take 3 particular judgments with regard to LCE, where in my humble submission, 2 judgments are in conflict with each other, therefore Lordships will be required to resolve that conflict. Your Lordships will kindly take Punjab and Haryana High Court versus State of Punjab, Your Lordships, volume 6, which we've just handed over, Your Lordships. At page 288. Lordships, on a lighter side, when I was preparing for this, Your Lordships, Punjab seems to be having the supremacy in service law, Your Lordships. R.K. Sabharwal also, Your Lordships, this judgment also, which is the correct.
By supremacy, why only service law? Service jurisprudence is all given by Punjab.
Yes, Your Lordships. That,
Why are you leaving Haryana?
Your Lordships, I'm just sharing an observation that I had.
Great go. You have to conclude.
Yes, Your Lordships. I-
Was kind permission. I was slated to address the bench on behalf of the ITAT Bar Association. Was in fact that application is slightly different. Because may just detect that because the issue seems to be there. Was the issue what we had flagged in our IA. Although
But that we are
yes,
saying
that's
Madras-
different. That's what I'm saying.
Madras Bar
Yes, Manoj, that's what I'm saying. Manoj, I don't wish to take Manoj's time on that today. Manoj, may not. That's IA 264842.
delete kar
Yes, Manoj. I'm sorry.
tag it with Madras Bar Association. That is kept on, I think, next Monday.
Next Monday, Manoj, third Manoj, the AG member. I'm so very good. Because I was serial number 7.
Yeah, so your time is saved.
Yes, Manoj, that's
We can rise early today.
grateful.
My lords, for mentioning, if I may, we have filed an IA for impleadment on behalf of a Pramoti district judge from Kerala. So kindly.
Yeah, Bob?
For Pramoti district judge from Kerala, my lords. So we have filed on
Yes,
24.
we are hearing.
Yes.
Mr. Dwivedi's arguments might take care.
Yes, just for mentioning, yes.
Yes, Ms. Pakila.
Please, Your Lordships. Lordships, I was referring to the two conflicting judgments on LC matter, Your Lordships. May I kindly take volume 6, page 288. This is the Punjab and Haryana High Court judgment.
Yes.
Lordships, here the issue was again with regard to the inter se seniority between the three categories, Your Lordships. And if Your Lordships just comes to paragraph 2 for a moment. I can read that, Your Lordships. The questions which have arisen for determination in this batch of appeals relate to inter se seniority dispute between three streams of Punjab Superior Judicial Service, that is, officers promoted on basis of merit cum seniority 50%, direct recruits 25%, and LCE 25%, Your Lordships. Then Your Lordships will come to para 7, where Rule 12 has been produced. And earlier, Your Lordships, the seniority rule provided from respective dates of their confirmation. If I can just read para 7. Rule 12 dealt with seniority, which provided that seniority inter se of the substantive members of the service, whether direct recruits or promotee officers, shall be determined with reference to respective dates of their confirmation. On 31st December 76, Rule 12 was amended, providing that seniority inter se of members of service will be determined by length of continuous service on the post in the service, irrespective of the date of confirmation. So here the length of service was decided to, was a part of the rule. Then Your Lordships will see issue number 1 is discussed, and Lordships will come to paragraph 44. Lordships, I'll just read this. A three-judge bench of this court in Srikant Roy versus Jharkhand, while determining question of number of vacancies in respect of LCE exam of Jharkhand, as in Jharkhand Superior Judicial Service, has held that cadre strength is always measured by number of posts comprising the cadre, and the percentage of quota has to be worked out in relation to the number of posts which forms the cadre and has no relevance to the vacancy that would occur. And then the following was laid down in para 24. And your lordships will then come to para 48, which is with regard to from what date, your lordships, the principle must apply, which your lordships I just made a brief reference to with regard to prospective application of the principles of all India judges. If your lordships will kindly take para 48. This court in All India Judges case number 3 in para 29 has clearly directed that the system which was directed to be put in place by this court-wide paras 27, 28 and 29 was to apply prospectively. This court had directed that appropriate methods will be adopted by high courts and approved by states wherever necessary by 31st March 2003. Up to 2004, the quota for promotion on basis of merit cum seniority was 75%. Cadre strength as on 13/9/2007 was 89, which was increased in 2007 as 107. After the amendment of the rules in 2004, promotion of 10 officers was made. It is mentioned in Civil Appeal of High Court that the cadre strength of Punjab Superior Judicial Services before 2004 was 88. Thus, in the year 2004, when the cadre strength was 88, 75% posts were to be manned by promotees under merit cum seniority, that is 66 were to be manned by promotee officers. The judgment of this court in All India Judges being prospective, the ratio of officers as existing before unamended rules cannot be adversely affected. A promotee before the amendment of 2004 rules who was well within their quota suddenly cannot go out of the quota and become an excess merely on the strength of amendment of rules which are prospective in nature. For determining the quota, the cadre strength which existed prior to amended rules and subsequent to amended rules have to be treated differently. Promotees quota, which was 75% prior to 2004, make 66 posts in their quota as before amendment in 2004, where cadre strength has been increased to 107. 18 posts have been further added to the cadre. This increase having been made after the amendment on cadre strength, the rules as amended will be applied for bifurcation of quota. On 18 newly created posts, 50% comes to 9. For the out-of-turn promotees, 4.5 and direct recruits, 4.5. Thus, promotee officers on or after the increase of cadre will have to be 66 plus 9, that is 75. In the appeal filed by the High Court, it is also indicated that 10 promotees were affected in 2004 under 50% quota of merit cum seniority. Rules providing for 25% quota for out-of-turn promotion being in place, at least few vacancies ought to have been given to the out-of-turn promotees. There is no detail of further information. So, your lordships, they have held that from 2002 onwards, whenever the rule was amended, the selections thereafter will have to go by the principles of All India Judges number 3, your lordships. So, my humble submission before your lordships is that post 2002, state-wise, High Court-wise, your lordships, whenever the first recruitment is pursuant to the amended rules, your lordships, it has to be then obviously will have to be seen by the different benches whether they are in compliance with these principles or whether the rules and all India principles have been violated in the process of selection. Because our complaint before your lordships is that our rule provides for a particular aspect, there is an ambiguity with regard to another aspect, and the rule has been wrongly applied in violation of all India 3 judges matter. So our humble submission, your lordships, will be that after principles are laid down, then every selection will have to be tested against that. Now, your lordships will kindly come to a judgment where the conflict is there, which your lordships will find at page 223 of the same volume. This, Your Lordships, pertain to Rajasthan High Court. And in this, Your Lordships, there was a cycle which was given in the Rajasthan rules, which was akin to a roster. But what the Rajasthan High Court was doing, Your Lordships, was placing them en bloc. So if there is a selection of direct recruits, then en bloc, Your Lordships, they would come in that cycle. Then if there is a subsequent or a later selection of LCE, then en bloc, they will come under the direct recruits. Then whenever the selection happens of the promotees, then en bloc, they were brought in. And in my humble submission, Your Lordships, this is in conflict with this principle which has been followed and laid down and approved in this judgment, Your Lordships, is in conflict with all the previous judgments which I have just shown to Your Lordships. And here on this bench, Your Lordships, has approved the en bloc aspect. Against the principle, which is very clear, is that wherever the position is, the person will come against the post. So here, Your Lordships, they are coming in order of continuous officiation so as to speak and in length of service, rather than against the post which is marked on the roster. Lordships will kindly come to para 1.1. And Your Lordships, there was also an aspect of fast track court. The ad hoc judges who were appointed again, the ad hoc posts of fast track courts, that Your Lordships had already held. So it follows Brij Mohan Singh saying that as far as that is concerned, seniority cannot be given in the cadre. That has to go according to your parent cadre. So that aspect I'm not touching, Your Lordships. I'm just touching the aspect with regard to LCA. Writ petition filed by 4 petitioners prays for appropriate directions that after promulgation of Rajasthan Judicial Service Rules 2010, all appointments ought to be in conformity with 2000 rules and allocation of seniority must be in accordance with the cyclic order provided in Schedule 7 to the 2010 rules. In terms of 2010 rules, post of cadre of district judges and higher judicial services in state of Rajasthan was required to be filled up according to All India judges. This writ petition filed by candidates who were successful in LCE prays that they be allocated seniority in terms of the cyclical order in Schedule 7. In this group falls writ petition so-and-so and so-and-so. Then the rules are from paragraph 13 onwards, Your Lordships, where a combined select list and seniority is given in Rule 42 and 47. Lordships will find it under para 13.6. And then, Your Lordships, para 40 onwards. And I will not bother to read much of it. I'll just enunciate the principle which was set out over here in my humble submission, wrongly so, is that they accept the fact that it has to be in cyclical order. But in that cycle, they say you have to place them en bloc according to the selection. So it is not relatable to roster point, but it is relatable to the date of selection. And para 47.3, Your Lordships, I would like to invite Your Lordship's attention. In the premise, the conclusion is inescapable that candidates selected through LCE and direct recruitment while order dated 2013 cannot claim to be clubbed, and 47 judicial officers promoted in substantive capacity on 21/4 in accordance with the cyclical order. We accordingly answer question 40.3C and find that 47 judicial officers are rightly placed en bloc senior to the candidates selected through process initiated pursuant to notification of 2011. Then, Your Lordships, another point which has been discussed over here is that merit is the primary criteria in LCE seniority list. So within the LCE seniority list, this conflict has again arisen, whether it has to be seniority come merit or merit come seniority. And in para 48, in my humble submission, correctly held so, which has also been subsequently held in Lordships 2025 All India Judges Judgment also, that within the LCE group, the list will be made in the order of merit. The persons who have qualified in the...
Yes, whatever is their ranking as per the examination.
But, your lordships, this principle does not apply to the promotees list. That, your lordships, is Justice Pardiwala's judgment, which is the next judgment that I'm citing to lordships. That is Ravi Kumar Dhansuklal. That is, your lordships, at page 982, volume 5A.
Volume?
5A. So I'm just, your lordships, bringing to lordships notice the principles and then how we will consolidate all the principles, your lordships, to come to a, what should one say?
What is the name of the judgment?
Ravi Kumar.
Ravi Kumar Dhansuklal versus
That Gujarat matter.
High Court of Gujarat. Yes, your lordships.
Page 9.
Page 982 of volume 5A.
Last patrol.
982.
Ravi Kumar Dhansuklal Mehta.
Please, your lordship.
Mehta.
Mehta. Now, in this, your lordships, the whole concept of seniority come merit and merit come seniority was discussed, your lordships, in great detail. And here the question that had arisen for lordship's consideration before that bench, your lordship, was that within the seniority list of the promotees, which now is 50%, was earlier 65%, within that list, will the seniority come according to the qualifying exam that they hold, or whether it will come according to their date of officiation? So in this, they have held, your lordships, that the primary criteria in the promotees list, the exam is only a qualifying exam. The exam is not testing your exact merit, but it is only a qualifying exam to take you to the next position. And therefore, here the consideration is of seniority in promotees. Therefore, the person who's senior most, who has qualified, the number of marks will be irrelevant as long as you are above the benchmark of the passing mark.
Cut-off mark, yes.
Yes, your lordship.
Limited competition.
Limited company.
Yes, your lordship. No, this is with regard to promotees, your lordships. Suitability test, I'm grateful.
50%.
Yes, suitability.
Suitability test.
Yes, yes, I'm grateful.
But that's for promotees.
Yes, your lordships.
No, not for LCs.
No, this judgment, I'm drawing a distinction with regard to LCA. Within the LCA category, the merit list will be drawn according to the mark.
Marking, yeah, because it's an examination.
Yes,
And so far as promotees are concerned, it is only to find out whether they are suitable. Once they are found suitable, then their seniority would.
Yes, your lordships. Absolutely.
So,
So suitability test is not a test of merit.
it's a test of by finding your fitness.
That's right, your lordships. So that's what has been held in this judgment, and correctly so, your lordships.
This is, I think, considering Gujarat rules.
Yes, your lordships. This is concerning Gujarat rules. But again, in Gujarat rules, your lordships, while this portion has been clarified, however, your
I've given some advice also as to what rules should be.
yes, your lordships, because your lordships.
Gujarat, there was no written test for promotion. There was no written test prescribed.
So LCA exam, your lordships, is of 5 papers, which is the same as the direct recruit exam, and it is held simultaneously. It is the same paper, except LCA is exempted from English and general knowledge. For a direct recruit, your lordships, you have to take 3 law papers, English and general knowledge. It is the same law exam, your lordships, and your merit list is drawn according to your marks in that examination. But the suitability test is a separate and distinct test.
There was no suitability test in Gujarat.
Yes, your lord.
For promotion. I don't know if they have made it now. Till 2021, it was never there.
Well, your lordship, of course, has personal experience.
The court has advised
to frame that.
Your lordships obviously has first-hand experience. So this is the distinction I'm drawing, that within the category, your lordships, also there is a method in that entire madness, your lordships, which has to be followed. And this judgment, your lordships, was followed also thereafter by Justice Nagaratna and Justice Satish Sharma's bench, your lordships, which your lordships will just note the citation is 2025 6 SCC 460. Lordships will not find it in any of the compilations. It's a recent judgment.
Why do we need that judgment? Only follows it, that's all.
Your Lordships, I'm just giving the citation.
Unnecessary adding burden to our.
Now, Your Lordships, two things I just want to show. Lordships had asked for the comparative rules of the various high courts. Just pass these. Just my associates have extracted the relevant rules of various high courts as just illustrative, Your Lordships. And Your Lordships, the rules will show the root of the problem that every high court is grappling with. Lordships will recollect the second line of para 27 of All India Judges 3, that there are three streams for this cadre, Your Lordships, and those three streams, Your Lordships, promotion, LCE.
The officers you are presenting belong to which
LCE cadre, Your Lordships. LCE cadre.
Capital competition.
No, but which state?
Please, to Uttar Pradesh, Your Lordships.
So let us see Uttar Pradesh rule.
Yes, Your Lordships, I've extracted these. If Your Lordship just sees the first serial number itself, it is the Uttar Pradesh rules. Now, Your Lordships, rule number 6 prescribes the quota, and Lordships, all these rules will be prior to the 25 judgments, so they'll all be 10% instead of 20.
So that will have to be changed now.
But that will be changed accordingly. Your Lordships, rule 22 is the methodology of appointment. Now, in this, Your Lordships will see, subject to provisions of sub-rule 2, the governor shall, on receipt from court of the list mentioned in rules 18, 20, and 21, make appointments to the service on occurrence of substantive vacancies by taking candidates from the list in order in which they stand in the respective list in accordance with roster. So this is with regard to the civil judge, how they stand in that roster. Appointments to the service shall be made on the basis of roster system. The first post shall be filled from the list of promotees. Second post shall be filled by direct recruit. Third and fourth post shall be filled up from list of promotees. And fifth post will be filled up by candidates selected strictly on merit through LDCE according to roster as prescribed in Appendix 1, which will cease to become operative on the date of respective three streams achieving their full allotted vacancies. Thereafter, on account of arising of any vacancy in quota of respective stream, the same should be filled up from the stream where the vacancy arises. So here Your Lordships will see an Appendix 1. Your Lordships have produced Appendix 1, the last sheet in this set of papers. Here is a 100-point roster which has been prescribed as per Appendix 1. Then Your Lordships will see proviso that while following the roster, at no point of time the respective percentage of posts filled from direct recruit and LDCE shall exceed 25% and 10% of the strength of service. In case the percentage is exceeding the allotted quota, in such eventuality, promotee shall occupy the vacancy, which would have gone to direct recruit or LDCE had not the same been in excess of 25% and 10% respectively, either of the two. Again, on the principle to be filled up, the percentage cannot go beyond. So there should not be over-representation or under-representation, so that adjustment is to be made. Now, Your Lordships, subsection 3 is a little bit of a thing which needs some focus. In the eventuality of delay in making appointment under sub-rule 1, and further if exigency of service so requires, the governor may, in consultation with court, make short-term appointment as a stopgap arrangement from among the promotees in vacancy in those services till appointments are made in sub-rule 1 and 2, provided that period of service spent by promotees on short-term appointment to service as stopgap arrangement shall not be computed under Rule 26. So seniority will not be computed by officers. It will be computed according to your number on the roster. Rule 26, your lordships, deals with seniority. Seniority of officers appointed in the service, here it is AJS service, shall be determined in accordance with the order of appointment in service under sub-rule 1 and 2 of sub-rule 22 of these rules. Seniority of members of service who have been confirmed in the service prior to commencement of these rules shall be as has been determined by the order of government as amended from time to time. Now, your lordships, this rule is perfect on paper, but in application, and I will show from my application, the manner in which it is being applied is that instead of the roster starting as a running account, unfortunately, it is being applied selection to selection. So instead of cadre, the roster should be strictly applied to the cadre, but it is being applied to selections. So that is the reason why this anomaly is existing. If the roster is strictly followed, which your lordships have said in the Gujarat judgment, that it must be strictly followed in accordance with all India judges, then that anomaly would not arise. And I can directly, your lordship, show that if your lordship takes my written submission, volume 6.
Why we are not considering individual seniority?
Yes, your lordships. I'm
presenting 2-3 officers, we don't know how many officers you want.
Yes, your lordship. So only by way of example, as a
But
principle.
only argue general principle that what
Yes.
should be the.
My petition in the High Court, which was considered and dismissed, they have filed an SLP which is pending before Justice Datta, Pankaj Datta. So now they are raising all of these issues.
No, I'm not raising, I am showing by example, your lordships. I'm not raising that issue.
You can say
I'm
rule is
stating.
bad, you can say rule is bad, or you can say rule is good, it should be followed on a uniform basis.
Yes, your
But
lordship.
how the rule has been interpreted in a particular case, or how the High Court has determined that, we can't go into individual High Court's claims.
Now, your lordships, in accordance with the 25 judgment, the only High Court which has come with the 10% with regard to civil judges, your lordships, is Bihar. And they have notified these, your lordships, in, I think, 4th of October 2025. At number 2, your lordships have extracted these rules. And the point I'm drawing your lordships' attention to is the proviso, which says that the date of appointment and officiation will not be the determining factor. On that aspect, most of the rules are silent. So therefore, the high courts are applying them in different ways. And in comparison, your lordships may see at number 3, West Bengal rules. And rule 26(2). I'm sorry, rule 31 regarding seniority is with the method that is provided is continuous officiation. So there is great variety and variation amongst all the high courts. And in my humble submission, your lordships, this uniformity is the guidance which your lordships, we desire from your lordships. Just one more aspect, your lordships, I wanted to point out to your lordships is with regard to the All India Judges 25 judgment. Your lordships may find that at volume 5A, page 873. Because in my humble submission, your lordships, the 25 judgment reiterates each and every principle which I have just placed before your lordships. The only change being the numerical aspect and introduction of LCE with regard to civil judges, 10%. Lordships, the conclusions in para 89. And each one of them are important, your lordships, because each one of them is with regard to every aspect. May I just read para 85, subpara 1. In view of the above discussion, we issue the following.
903.
I'm sorry. Page 903, Your Lordships, 903. Volume 5. Please, Your Lordships. Para 89.
Yes.
In view of the above aforesaid discussion, we issue the following directions. Number 1, all the high courts and state governments in the country shall amend the relevant service routes to the effect that the quota for reservation of LDCE for promotion from cadre of civil judge senior division to higher judicial service is increased to 25%. So, Your Lordships, in conclusion, from 2002 to 2010, which is when Justice Balakrishnan's judgment came, the quota was 25. From 2010 to 2025, the numerical will change to 10%. Prior to 2002 to 2010, the numerical remains, to 2010 to 2025, numerical remains 25 and will now continue to be 25. Number 2, all the high courts and the state governments in this country shall amend the relevant service rules to the effect that the minimum qualifying service required to appear is 3 years. So now, Your Lordships, that qualifying service aspect. Number 3, Your Lordships have introduced 10% LCE with regard to civil judge, senior division. And in my humble submission, this will also take color from how the LCE of 25% is affected, Your Lordships. So the manner in which LCE of 25% with regard to district judges is affected, the same way the LCE with regard to civil judges will be affected. Then, Your Lordships, number 4 is a little significant. Needless to say that if any post reserved for LDC for either civil judge or of the higher judiciary remains vacant, the same shall be filled through regular promotion on basis of merit cum seniority in that particular year. Filling up the vacant post in the ratio considered for LDCE will have to be carried out from simultaneous selection process carried out for regular promotions in the same year. This might need a little clarification, Your Lordships, because this is now with regard to vacancy. So, in compliance with Mazhar Malik, Lordships have said that every year all the vacancies must be completed. So if you don't find sufficient number of LCA candidates, then you fill it up by regular promotees. But Your Lordships, the seniority list will not be affected by this. So even if a promotee has come up earlier because no LCE 25% were there, Your Lordships, then the seniority will be worked out according to the roster point again. So a promotee which has come in, say in 2010, because 10% LCE persons were not there, only say 3% came in. Then 7% had to be filled up by promotees. But the seniority, Your Lordships, the person who comes in the next selection in LCE will go higher than the promotee, because the roster point is higher.
No, but then we are arguing contrary to what Mr. Dwivedi just now argued.
Your Lordships, that's the dichotomy between the promotees and the LCE persons, because promotees are saying club us all together. So whether an LCE, and that is the whole disincentive aspect. As far as an LCE is concerned, Your Lordships, if I am coming in the order as a promotee.
So you want a total separate cadre of LCE?
It is already provided.
Whichever year you are selected, you will get into that position. How can you jump over all those who have been promoted earlier?
I'm just explaining, your lordships. Here.
Clearly, because in the previous year, LC quota was not filled up.
Yes, your lordships. Then
The full extent.
because, your lordships, if I'm coming along with my promotees, suppose my promotion is happening along with, in the same order, your lordships, then I don't even have a jump.
Then it's different. But somebody who was promoted previous year in a regular promotion, you want to sit over them.
You don't have a jump because you did not clear it earlier.
No, your lordships, that's the problem. The problem is this, the incentive, what is the incentive with which lordship provides? The incentive that lordship has provided.
Incentive is that with lesser number of years, you are now in the high judicial service.
That's why I wanted to show my selection list of LC.
We are not going to the facts of the case.
I'm putting that aspect before your lordships, because in fact, this does not happen, and the numbers and the data have established that the LCE persons are not going higher in seniority. They are still coming behind the promotees. And in fact, if I'm coming.
If that would have been so, then they would not even opt for going to LCD. If they are going below the regular promotees, why would a person go and opt for the examination?
The aspect that I'm clarifying here, your lordships, is that suppose it is a 2010 vacancy.
There are four more councils up to.
Your lordships, this is a little tricky aspect, so just 2 minutes I'll take on it. If it is a 2010 vacancy, your lordships, so and 10% LCE vacancies and 50% promotee vacancies. Now LCE, your lordships, 10% don't get selected in 2010. Only 2% get selected. Then when the next selection takes place, say in 2012, and an LCE gets selected, your lordships, so that LCE will still steal a march over the promotees, will have to come higher than the promotees. This is what I'm saying.
So irrespective of the promotees having been promoted earlier, you want a notion, you want a seniority to be given to you above them.
Your lordships, according to the roster post. Because if in the roster, if your lordship.
So in a nutshell, Mr. Dwivedi opposes the roster system. He says that the roster has to come to an end at the end of the recruitment process. And you are supporting the roster
running account, which
so you want it to continue endlessly.
Your lordships, that's what Sabharwal says. Sabharwal, which has been consistently followed, says whenever there is a debit, then you credit it from that category. What is the point?
Suppose a person who is promoted 3 years earlier.
Yes, your
as a district judge.
Yes, your lordships.
On account of his seniority.
Yes.
And if you get selected through LCD,
yes, your
LDC,
yes,
then you will be shown senior to him, though he has more.
Because that roster point was left vacant at that time. No, you can't.
That is only my incentive. Otherwise, then I'll come by promotion. That is what the whole thing is. If your lordships will just give me a second, and lordships will see this roster for a moment, just to explain it, your lordships. Lordship sees that the first is a promotee, next is a direct recruit, 2 promotees, and then LDCE. Now, suppose the LDCE post doesn't get.
That is where all selections are taking place at the same time and they are coming. This is how it will be filled up.
Please.
But if you are coming subsequently after 3 years, 4 years, or 2 years,
please, your lordship,
then you are there to fill up that post, but you cannot get that seniority.
Because
fall in that LCD quota, only if the quota is available, posts are vacant for LCD, you can be taken up. But you cannot get that seniority, backdated seniority. No?
If your lordship sees that suppose this LDCE post is not filled up. Suppose in this election, this doesn't get filled up. So lordships have said that the vacancy should be filled up by a promotee.
Correct.
So does that promotee steal a march over the other persons? He then steals a march.
Stealing a march, he comes through regular promotion.
Your lordships, then again the same thing is happening.
But this appears to be totally hypothetical because nobody, if you are in a normal mode of promotion, is entitled to be there. Why would you go for LTC, prepare for the examination, do studies?
Precisely, that is the point I'm saying, your lordships. If I'm not getting a high,
if
I'm not getting high priority, what's my?
We will examine your.
Don't appear for that.
That's why your lordships, people were not appearing. Though lordships.
No. People were not appearing because they would otherwise be promoted. In the normal course, by the time they are entitled for, they are eligible for LDC.
Please.
Therefore, we reduce that 10 years to 7 years.
Pointing out, there are two aspects. One is increase of the pool. There was not a sufficient pool for persons to take the exam.
Now there is.
Now there is.
Then your argument is totally contrary.
No.
You are saying that there were not a sufficient pool. And then you are also saying that out of 10% only 3 posts were filled and 7 were vacant.
No, your lordships, for the reason that people did not qualify. So the people who have qualified must be.
Anyway, you must give time to others also.
Yes, your lordship. So that is the point that I'm making. And your lordships, with regard to the rest of the 3 points in the 25 judgment, your lordships, the
There are 5 more councils.
yes, your lordships. So
You are almost taken an hour, more than an hour.
yes, your lordships, and then on the prospectivity aspect, which I've just explained to your lordships, that from which date the selections have to be considered, your lordships. Grateful. Yeah, just shifted on that side.
Wait, please, Lord. I beg to appear for the Kerala High Court. I am not getting into, my lord, the manner in which the LC will have to be promoted, the date on which they should be assigned seniority, or the promotees will have to be. Question which has been referred to your lordships is only this. Therefore, I make limited submissions, my lord. The High Court cannot be seen as taking sides with one group, and I have not done so in my written submissions also. That's why, my lord, I preferred to, though in the sequence, my lord, I had to come immediately after the amicus. I thought, let the contesting parties, my lord, make their submissions. And I will only place before your lordships, my lord, where probably the High Court could do with some guidance from your lordships court in this. What should be the criteria for determining seniority in the cadre of higher judicial service? My lord, the rules have been placed on record. And the rules, my lord, your lordships get it at it. It's at 105 or
Volume 5.
volume.
It's a volume 4A.
My lords, our written submissions of the High Court starts at page 100
Of
volume 1. I have given a point-wise submission at page 101. It starts at page 100. At 101, my lord, I have given a point-wise submissions. My lord, the legal submissions have been given at page 102. I'll just take your lordships to.
page 102.
But give the rules. The rules are at volume 3A. But if your lordships have the affidavit filed by the High Court earlier, in IA 230675 of 25.
So the rules are at page 418 of the compilation, volume 4A, 418.
Volume 4A, page 418.
Volume 4A, page
418. Got it. My lord, rule 1.3.
418. It is PDF page 428.
The PDF page number.
PDF page 428.
PDF page 428.
PDF page is 428.
428. My lords got it. My lord, rule 1.3, 15% of the posts in the service shall be in super time scale and 35% of the posts in the service shall be selection grade. My lord,
You are reading rule 1.3.
sorry.
Rule 2.1.
2.1.
Rule 1, sub rule 3.
Huh? Rule 1, sub rule 3.
Sub rule 3.
15% of posts.
Yes, my lord. 15% of the posts in the service shall be in super time scale, and 35% of the posts in the service shall be in selection grade. If your lordships kindly come to next page, sub rule 2 of rule 2.
Appointment to 35%.
Appointment to 35% selection grade posts in the service shall be made by the High Court with effect from 1st of January 20 from amongst the members of the service on the basis of merit and ability. Seniority being considered only where merit and ability are equal. Only approved probationers with 5-year service shall be eligible for being considered for promotion to the selection grade. Appointment to 15% super time scale posts in the service shall be made by the High Court with effect from 1st of January 20 from amongst the members of the service holding selection grade posts on the basis of merit and ability, seniority being considered only where merit and ability are equal. No person promoted to selection grade shall be eligible for appointment to super time scale unless he has completed 3 years in selection grade. And then, my lords, the Rule 5, appointing authority. Five 1, all appointments to the service referred to in item A, B, and C of sub rule 1 of rule 2, which is, my lord, that 50%, 25%, and now 25% recruitment to the higher judicial service shall be made by the governor in consultation with the High Court. Therefore, the High Court conducts the selection, and then, my lord, the order of appointment is issued by the governor. Then 2, all appointments to the selection grade and super time scale posts shall be made by the High Court. Therefore, my lord, once you are in service, then, my lord, the question of appointment to selection grade and super time scale, which is, my lord, the same higher judicial service itself, is made by the High Court. Rule 3, my lord, captures the roster system. Appointments to the service shall be made on basis of roster system. The first post shall be filled from the list of promotees. Second post shall be filled by direct recruitment. Third and fourth from the list of promotees. And fifth post shall be filled by the candidate selected strictly on merit through limited competitive examination and so on. According to the roster as prescribed in the appendix, I have given the appendix, my lord, it's a 40-point roster. To these rules which will cease to operate on the day the respective 3 streams achieve their full allotted vacancies. Therefore, on account of arising any vacancy in the quota of the respective stream, the same shall be filled from the same stream of which vacancies arise, provided that while following the roster, at no point of time the respective percentage of posts filled by direct recruitment in limited competitive examination shall exceed 25% and 10%. Now it must be 25% and 25% of the cadre strength of service. In case a percentage is exceeding the allotted quota, the promotee shall occupy the vacancy which would have gone to the direct recruit or limited competitive examination. My lord, the rules do not provide for a post of principal district judge. And therefore, my lord, I have made it clear in my affidavit and the written submissions that is an administrative assignment of work and fixation and by the High Court. Generally, my lord, though ability is also taken into account, seniority is also taken into account, and therefore, my lord, one amongst the district judges will have to be posted as a principal district judge. Generally, my lord, it goes by the seniority also, but ability and merit are also looked into. And, my lord, the one question on which, my lord, we have tried to make a submission is this: when it comes to the question of assignment of seniority amongst the district judges in the higher judicial service, which is a question, my lord, which your lordships are grappling with. My lord, promotees come in, LCE comes in. Direct recruitment, my lord, is supposed to be made every year. But as your lordships would have noted, and your lordships would have observed, my lord, innumerable times with your lordship's rich experience, it would have been very good, my lord, if the direct recruitment takes place every year, depending upon the number of vacancies which are notified. But the selection starts from the 1st of January. But unfortunately, my lord, more often than not, my lord, it gets grappled in either some litigation or, my lord, the selection gets dragged along, with the net result that the vacancies which are to be filled up by direct recruitment in a particular year, for example, 23, may get filled up only in the year 24. My lord, it has happened in the Kerala High Court, my lord, more than once. And the matter has reached up to this honorable court also, my lord. I also had occasion to appear for the High Court in more than one case. But point is this, my lord. Therefore, this 25%, my lord, vacancies in the post of district judges in the higher judicial service, which has to be filled up by direct recruitment, may not get filled up, my lord, in the same year, calendar year as such. But vacancies, my lord, in the post of vacancies which have to be filled up by promotees and LDC, my lord, in Kerala, more often than not, we actually get enough number of candidates, my lord, to fill up the 10% and fill up the 25% and definitely the 10%. That has hitherto, my lord, been the experience. Now, my lord, once they come in, now, my lord, the question of seniority, interstate seniority amongst them, suppose we go by the principle that it is from the date on which they come into the cadre, then, my lord, there cannot be any confusion regarding that. But what happens, my lord, in a case where direct recruits who are recruited against vacancies that are notified in 22 actually come into the service in 23 or actually are appointed in 23? Do they get seniority from 22 or do they get seniority only from 23? One. Secondly, my lord, insofar as promotees are concerned, it can happen the other way also. Promotees are concerned, my lord. If promotions are delayed for one reason or the other, and promotions, my lord, the vacancies that are arisen in 22, but the promotees are actually, they enter the cadre, they are appointed only in 23. Do they go by the date on which, my lord, the vacancies had arisen? It happens, my lord, in the case of LDCEO. Now, my lord, one aspect, my lord, on which we have made a submission, and I confine myself only to that. My lord, see, higher judicial service, my lord, discharge of duties in the higher judicial service, my lord, would take in not only discharge of judicial functions, but it also, my lord, concerns itself with certain categories of certain aspects of administrative experience as well. My lord, if somebody, my lord, in the higher judicial service is being groomed for higher duties as such, therefore, my lord, there is a legitimate aspiration that is felt by the members of the higher judicial service. And there's nothing wrong in that. My lord, the recent judgment whereby your lordships have reviewed Dheeraj Moore, that is Rajanish, what your lordships have said is that 1 year of, or 4 years, 1 year of judicial service or experience, my lord, which a person acquires, my lord, after serving as a civil judge junior division or a civil judge junior division, senior division, can be taken into account for a multiple years, my lord, of bar experience for the purpose of calculating the requisite years of service under 233. Principle would apply. Even when it comes to the question of, my lord, assignment of seniority interstate amongst the members of the judicial service. My lord, this, my lord, I say, my lord, with great respect, from the context of, from the perspective of the High Court, my lord, when we have to consider as a High Court, my lord, on the administrative side, we also consider, my lord, how to place persons who have, those persons, my lord, who have rendered, say, 15 years, 20 years, or 25 years. This is not for the purpose of creating a cadre in the cadre. That is not what is contemplated, and then rules do not provide for anything. But in posting a person as a principal district judge or assigning him seniority, my lord, for higher functions as such, without there being any support from the statutory rules as such, and the rules, my lord, are a product of successive directions that your lordships have issued in the All India Judges Association case, and in some cases, my lord, in Malik Mazhar also. Would your lordships consider it appropriate to give guidelines as to whether it is permissible for the High Court to say that after persons have come, my lord, into the higher judicial service, that some weightage could be given to those persons who have rendered, my lord, service in the subordinate judiciary for 15 years, 20 years, or whatever it is. Some weightage could be given over and above, my lord, the roster which is reflected, my lord, in 5.3, which your lordships have seen. My lord, 5.3, the roster, and this, my lord, we say with some trepidation, that it has not been possible, my lord, for uniformly implementing the roster over these years, though it has been introduced, my lord, in 2020. That's a default. But that is how it has happened. Therefore, to some extent, if your lordships find it permissible, that some weightage could be given to length of service by, or my lord, rendered by promotees, then my lord, your lordships could direct the High Court, your lordships could direct all the High Courts, my lord, across the board to consider whether it could be taken into account. It should be left to the discretion of the High Court, my lord, on the question of assessment of merit and suitability. But when it comes to the question of, my lord, there could be an objective criteria that is drawn up for the purpose of giving a weightage on for service rendered by them, my lord, the service rendered prior to coming into the higher judicial service. It is not to create the cadre. It is only to see, my lord, that rich experience that these persons have gained do not go unnoticed. And this is for the simple reason that generally persons in the age group of 35 to 37 become district judges, my lord, on direct recruitment. LDC, my lord, probably stands on a slightly different footing. But promotees are concerned, even when they start service now, my lord, during the last few years, at the age of 23 or 24, because an bar experience is not considered to be mandatory, even then, my lord, persons get into civil judicial service round about the age of 28, 29, 30. That is how it happened, my lord, when there is high competition that is felt at the stage of recruitment into the entry cadre. And definitely, my lord, they could come into the higher judicial service only, and that's what, my lord, we have stated in the affidavit, around the age of 48. Whereas in the case of direct recruitment, the average age is 42. And therefore, my lord, as an administrative institution,
Average age is 42, entry point.
Entry point. Direct recruits. Average age for direct recruits. The other one is 48. I put it on affidavit also. This is the data, my lord, that we have compiled, and this is the data that we have placed before your lordship. Average, my lord, age during the last 5 years. Principal district judge is not a post, my lord, which is covered by the rules, but it is required. And therefore, my lord, when we choose that, we normally, therefore, we go by the seniority. If merit and suitability, my lord, are equal as such. Therefore, we go by seniority. But in that, is it possible, my lord, that your lordships could lay down some guidelines which would still, my lord, retain with the High Court a modicum of discretion, my lord, in the question of giving some weightage to those persons, my lord, who have come through the promotee channel when it comes to the question of assignment of responsibilities as a principal district judge. This is all, my lord, what we have sought for some guidance from your lordships. And my lord, one submission is, none of the judgments, my lord, of this honorable court say that a valid criteria cannot be adopted for the purpose of, my lord, assignment of an advantage, my lord, or an advantage to a person, my lord, within the cadre. For example, my lord, higher educational qualification can be taken note of in Khosla's judgment. It has been mentioned. Cannot be, in such circumstances, it is found to be not violative of 14 and 16. Lengthier service, my lord, in judicial service can also therefore be taken note of for the purpose of giving some weightage, my lord, in accordance with objective criteria. In accordance with objective criteria. If your lordships lay down that principle, and that is, my lord, an answer to the question that is referred to your lordships, it would not in any manner violate 14 and 16. None of the judgments of this honorable court would say that that would amount to a creation of a cadre within the cadre. No, that is not what it is meant for. It is not for the purpose of, my lord, creating a sub-cadre. It is only for the purpose of, my lord, taking note of a valid criteria for the purpose of assigning seniority within the high judicial service. Because anyway, my lord, it is not on seniority that elevation, my lord, to the High Court is determined on. Therefore, it's only for the purpose of determining whether a higher responsibility can be assigned to those persons who are serving in the higher judicial service, namely, my lord, principal district judge, essentially, of a selection grade, of a super time scale as such. My lord, it is only for that purpose, my lord, that we have ventured to make the submissions before your lordships, my lord. We obviously cannot say that this should be giving an advantage, my lord, either to the promotees or to the direct recruits or to the LDCs. As such. My written submissions are also confined only to that. Great.
The advantage of coming, my lord, in the end is that, my lord, most of what I had to argue has already been argued. And therefore, my lord, I'll limit my submission, my lords. I, my lords, appear for the promotees, my lords, in the state of Punjab. That's the category, my lord, that I represent. And my lord, just like the amicus curiae, my lords, had given three alternative suggestions, my lord. One is, my lord, he said parallel stream. Second, he said weightage. And my lord, third he said was reservation of 50-50, my lord. My lord, we don't agree with that, my lords, 50-50 reservation, my lord. The lords have already, my lords, in the third All India case said 75, 25, 25. It got reduced to 65, but now it's restored to 75, 25, 25. Therefore, my lords, I'll cut short my submission, my lords. As far as weightage is concerned, my lord, I adopt the submission made by the amicus curiae as well as what Mr. Giri has said right now. Weightage, my lord, we are agreeable formula. Okay, that will at least allow us some better opportunities at the time when the promotion happens. The second, my lord, submission which I make is that there could possibly be three parallel streams. One stream for 75%, one stream for 25%, and one stream for 50%, 25%, and 25%. Three parallel streams, my lords. And all of those streams, my lords, the inter-se seniority of the persons in those streams, my lords, should be maintained separately, my lords. And my lord, they will compete at the time when they will actually just come into the zone of consideration based on their inter-se seniority. And out of the persons in the zone of consideration, each one of the lists, my lords, whoever is appointed in accordance with the rules, my lords, will go. Lord, that is the submission that I'm making. Lord, I have filed a written submission. Page 113, my lord.
111.
111 is my written submission. Lord, at 113.
You want to read at 113? Yes.
Yes, I want to read at 113, para 8.
Table 2.
Table 2. Because it shows the poor representation of promotees as compared to their total induction strength.
160 only 11.
Table 1.
You can see this.
Usually please open.
To review the earlier judgment.
Lord, I'm not asking your lordships to review the earlier judgment. Lord, to the extent of para 20, para 29, yes, my lord. To that extent, yes, my lord.
That's why we are indicating.
Correct, my lord. To that extent, yes. But my lord, your lordship sees, my lord, para 8. The total strength is 202 of the out of that, my lords, 160 are promotees. I put that in a table, my lords. And my lords, in the top 30 bracket, only 11 managed to get through, my lords. As against 160, which works out to 6.87%. And direct recruits, total strength is 37, out of which 12 managed to get through, which is 32.4%. And out of turn promotion, my lords, 5 out of 5, so 100%. Lord, I'm told, my lord, that in the last 14 years, my lord, there's been no out of turn promotion. The reason may be, as their lordship said, my lord, they may be thinking that they will get the promotion faster in the normal stream. That may be the reason, my lord. But out of turn promotions have not been there. And if your lordships also sees, my lord, table 1, which is at para 6 in the earlier page. This is a projection. Today and in 2026 up to 2029. Now the projection shows that promotee judges will be 11, out of turn will be 5, and direct will be 14. So therefore, my lords, and by 2029, the promotee judges get reduced to 11, Out of turn promotee judges gets reduced to 1 and direct recruits gets reduced to 22. Lord, I was showing that table, my lords. Even a future projection, today 11 promotee judges, by 2029 it's reduced to 7, and out of turn promotees 5 gets reduced to 1, and direct recruits 14 has increased to 22 by 2029. So, Lord, this disparity, my lords, has not been considered by the 2002 judgment, and therefore, my lord, I'm asking your lordships to reconsider that para 29. My lords. Now, my lords, if your lordships also sees, my lord, the propositions that I have, suggestions that I have made, I have summarized them at page 46, para 47.
Interest 37 is page PDF 119 printed 170.
There are 3 models. Which is the page?
Page 7.
Page 7. I'm sorry, my lords. Page 11, PDF 117.
Yes. Solution suggested by applicant.
That's right. Correct.
Basically saying the same thing what the amicus was saying.
Yes. And as far as the weightage is concerned, same submission as Mr. Giri, my lord. I'll skip my detailed submission. I'll just come to what is the para number? The lordship sees para 37, benefits of the first model, which means 3 parallel streams. Age-related disadvantage stands automatically redressed as neither stream can encroach upon the legitimate share of the other in any circumstances. It shall ensure that best of both streams occupy leadership roles, and each stream as a class receives fair and equitable representation in accordance with the intended policy. This model also overcomes all recruitment-related challenges, including administrative delays in filling up posts and ill effect of block filling of multiple posts in a single year, thereby preventing any distortion in seniority or imbalance. Entrants of each stream will have absolute clarity and certainty regarding their future career prospects from the very inception. Model will be eliminating all litigation trends normally possible between 2 streams. Even randomness in the seniority process where unintended benefit accrues is likely to be eradicated. Now, second model, that is weightage. Another fairly workable model to overcome age imbalance challenge worth consideration would be the weightage formula of past service suggested by Shetty Commission. This honorable court may appreciate that this system is still in force and functioning effectively in IAS service, successfully neutralizing any age-related advantage. This hybrid model perfectly fits into Prayer CF amicus with a possible solution, as it also applies rota and quota rule in addition to.
Yes, we'll go through it, Mr.
Very well, very well. There's just one other data, my lord, which the amicus himself had produced as far as Punjab is concerned. I'll just show those 2 pages. That's all, my lord. Volume 1 में क्या है? In fact, the amicus had read it, my lords. Volume amicus is volume 1.
Same volume 1.
Page.
It starts from page 1, sir. And to
Page 15. Page 15 of volume 1. Para 23. Yes.
So this table is page 617.
Page 15 of volume
17.
17.
Para 23.
PDF 19.
PDF 19.
Yes. The table is there.
Table that I am just showing item number 9, Punjab. Average age at the time of appointment of district judge is 40. At the time of appointment of promotee judge is 46, and the difference is 6 years. So even the amicus has highlighted.
Learned amicus has given the data of all.
All the data has been given, and that includes data of Punjab. I'm obliged.
Thank you.
Keep you.
Yes, Mr. Dharekar.
The State Judges Association.
Yes.
This association represents all the three classes of district judges.
All the three classes.
Promoted. But we are taking
Yes,
balanced
association is
approach.
all the three classes of judges.
Yes, Manoj.
Direct of.
But we are taking a very balanced approach, which would be
Obviously,
in the best
yeah,
interest of
because
administration of justice, which would be in the best interest of administration of justice, which would go to eliminate disparities, remove discrimination.
Is Mr. Gumra still the president?
No, it's Mr. Patil. Sachin Patil is the president. Recently, there were elections 2 years back. The stand of the association is how best discrimination can be removed.
What are your suggestions? You are saying that you want a most balanced approach. So what is the balanced
I'll
approach?
first, my lords, placed on record, my lords, certain data in a tabular form. First, my eye is, my lords, at volume 3, page 55. It's in volume 3, page 55 to 88.
No, your written submissions are in volume 1 only.
Yes, written submissions are there, but before that, my lords, I'll point out, my lords, some official data
Achha.
to show that how this, my lords, roster system does not work well.
Yes. PDF page 89.
Let's kindly turn to my lords, page 89. PDF 94.
Volume 3A.
Yes, ma'am. P4, my lords, annexure P4.
83.
Page 83, my lords.
PDF page 89.
IA number? Yes.
Sir, IA number?
IA number, my lords,
24809.
24849.
8309.
49. 248349. There are two IAs, one for intervention, one for
Yes.
48349.
Lords, it is annexure P4.
Yes.
Lords, this is a list of, my lords, 19 judges of the Bombay High Court who are elevated after 2020.
Page number?
My lords, 89.
112, PDF 118.
180.
The IA starts at 248,309.
Its title is, my lords, annexure P4.
Yes. Except P4 page 83. PDF page.
PDF 118, ma'am. PDF 118.
IA starts.
It is actually
No, 89 is their list, annexure P4.
IA starts at page 55 of the.
और running page 83 है, PDF page 89.
confusion would be I have filed two IA. Lords, I'm referring to, my lords, IA 248349.
Yes, we have that at page 83.
Yes, ma'am. Its title is annexure P4. A list of, my lords,
High Court judges.
yes, my lords, which are elevated after 2020. My lords, out of 19, my lords, judges, serial number 1, 2, and 10.
Yeah.
Serial number 1, 2, and 10.
There is none then.
They are retired, my lords.
All three of them are retired now.
Yes, my lords. So, and thereafter, my lords, during last 5 years, today, whatever 16 judges we have from this category, they all belong to my lords direct district judges category. They are drawn from direct district judges category. And then my lords may kindly turn to next page. That's 1, 2, and 11, they are retired. So these are 16 my lords who were drawn from direct district judges. The next page is my lords 3, which are again retired. They were drawn from promoted district judges cadre. Would my lords kindly turn to my lords earlier annexure P3. My lords, turn to page 83.
Oh,
My lords, page 83.
no, director has also retired. Mr. Mere has retired.
Yes.
Mr. Sanap has retired.
Yes. So today there is no, my lords, judge on the bench who is drawn from my lords promoted district judges cadre.
So therefore, what is your suggestion? You say that you have some balanced approach.
No, my lords, kindly turn to my lords page 83. And this I have taken it from my lords official website of the High Court.
We know that, and at least as far as I am concerned, I know what is actually positioned there.
Lords, I have
You
taken.
are saying that you are appearing for all the three. Three categories.
I'm not taking partisan approach.
So therefore, what is your suggestion?
My suggestion, I'll come to suggestion. Before that, I just want to point out, my lords, a list of my lords district judges which are there on 1st January 2025. First, my lords 25, they are all my lords from
the district judges.
direct
From
district
the
judges cadre. So tomorrow, if my lords posts are to be filled in, my lords, not a single candidate from my lords promoted district judges cadre will be considered. Because my lord, the zone of consideration, they consider 1:3. So today there are, my lords, about 9 vacancies, my lords, in district judges cadre, who can be, my lords, elevated. Now, even if those 9 are to be filled in today, my lords, they are to be filled in from the zone of consideration. And first 27 candidates, they are all, my lords, direct district judges. Kindly turn to my lords page 83. I'll point out. 78, I'm sorry.
79, 78. So first.
Lords, all these
25
1, 23 and even 24 and 25, they're all, my lords, direct district judges. And then, my lords, even on the next page, and by the time, my lords, the earlier list is exhausted and the other candidates are come in the zone of consideration, all these, my lords, promoted district judges, they'll retire by that time. And they'll be only, my lord, direct district judges. So, my lords, elevations hereinafter, even in future, would be done only from direct district judges, my lords, cadre. And this is how, my lord, this is working to disadvantage. And then, my lords, page, my lords, 82, 82, page 82. Lords, out of 125, first 125, we have about, my lords, 525 district judges in Maharashtra. I have taken, my lords, only first 125. Out of 125, my lords, 74 belong to direct district judges cadre, and 51 would be from promoted district judges cadre. And even these 51, by the time their turn comes, they must have retired. So, my lords, only direct district judges would be available for consideration, or they would come in the zone of consideration. This is how it works to the, my lords, disadvantage of. Then, my lords, my written submissions are in volume 1, page 120. Once I'll come to the, my lords, suggestions. My lord, they are at page 13. I'll first, my lords, point out, my lord, 2, 3 charts. The first chart is, my lords, at page 122, volume 1. My written submission start at page 120. Its PDF page is 122. Starts it. We compiled, my lord, the data and put it in a tabular form. Lords, in 2021, Lords, 6 judges were elevated from district judges cadre. All 6.
That is the page number?
122.
PDF page 122.
It's a table, my lords, colored.
Giving the average age. The average age.
No, it's not average age, my lord. This is about, my lords, from elevation of High Court judges. Colored, my lords, table.
Colored chart. Yes.
In 2021, my
2020.
lords, 6 judges were elevated, and they all belong to, my lords, direct district judges cadre. Then, my lords, in 2022, my lords, 2 on the first page.
We understand the position you have already pointed out at page 83 of the IA. You say that you are applying for all the 3 categories. So what is your solution?
The solution is, my lords, if we have to improve the efficiency of judicial administration, solution would be, my lords, we'll have to give, my lords, adequate representation to the, my lords, promoted district judges.
Yes, yes.
My lords, my suggestions are, my lords, kindly turn to, my lords, page 13. This is
The way forward.
PDF
Yes.
132, my lords, PDF 132.
The way forward.
My lords, before way forward, my lords, there is need to review All India Judges Case 2002. I'll read just one paragraph, my lords. The Honorable Court in All India Judges Association had prescribed the roster system, hoping against hope that the problem faced by the district judges would stand alleviated. However, since the roster system has been ineffective in addressing the problems of disparity between the promotions and direct recruits, it would be necessary to review the procedure of fixing inter-se seniority and quotas for further promotion, if necessary by reviewing the judgment in the case of All India Judges Association. Third, in the light of directions contained in 1993-4 SEC, my lords, All India Judges Association 2, there was a direction that there has to be periodical review of service conditions of, my lord, district judges. Now, this was done in 1999, and that was considered, my lords, in 2002. Most of the recommendations were accepted, approved. Some recommendations were disapproved. Lords, thereafter, no periodical review has been done, perhaps because this court had put a, my lord, seal by accepting, my lord, some of the recommendations, by rejecting some of the recommendations. So, my lords, commission did not, my lords, go in for reconsideration or review of, my lord, service conditions after, my lord, 2002. And this is, my lords, para 11 of, my lords, All India Judges, my lord, that judgment. Para 11, my lords, there is a direction that there has to be periodical review of service conditions by the commission. Then, my lords, I'll read, my lords, suggestions. The way forward, proposed reforms. The above backdrop, lords, I have considered everything earlier, and with a view to addressing the long-standing imbalance between promotee and direct district judges, the following reforms are proposed for consideration of this Honorable Court. 1. Introduction of weightage system for promotee district judges while fixing their seniority vis-a-vis direct recruits. My lord, the commission, Justice Shetty Commission, had devoted about 11 pages, my lords, so as to introduce, my lords, weightage system. Before recommendations were made, my lord, discussion, my lords, goes on for 11 pages, and then there are recommendations. And those recommendations are ultimately brushed aside just in one line, para 30 of All India Judges Case. I'll read, my lords, that, and that is not approved only because they said the judgment of Supreme Court in, my lord, Sabharwal will take care of everything. And the judgment of, my lord, Sabharwal, that was designed or that was intended to give effect to, my lord's, reservation policy. That was not, my lord, to get over, my lord, this seniority or promotions. And, my lords, this Honorable Court has, my lords, expressed doubt as to whether, my lords, this roster system, my lords, introduced in Sabharwal can be applied in, my lords, in case of seniority and that is in Ajit Singh 2, 1999. So, my lords, the time has come to reconsider, my lord, the earlier directions. My lords, I'll read only, my lord, 3 paragraphs. Of course, this has been read by my 1990. I'll read, my lords, Sabarbal's judgment. It's, my lords, 1995 too. And first, my lords, read para 30.
Mr. Dwivedi has already read those paragraphs.
Yes, my lords.
So you can just address your subject.
My lords, few more things, my lords, I will point out, my lords. Questions, my lord, they are also, my lords, at page 23 and 24. 5 weightage system would be.
Yes, you have said that it is also applicable to IS, IPS.
Yes. My lords, those rules were considered by the commission. And my lord, there are judgments of this court where, my lords, this weightage system had, my lords, not only applied, but that had worked well, very successfully. And therefore, my lords, commission had recommended to apply. My lords, kindly turn to my lords, page 23. 142, my lords. PDF 142. That's paragraph 10. While adopting the weightage system, certain practical concerns must be addressed to ensure that the mechanism achieves its intended purpose without giving rise to new anomalies of disputes. First, the Honorable Shetty Pay Commission had suggested granting 1 year of weightage for every 5 years of judicial service rendered before promotion, subject to a maximum of 3 years. However, in view of the significantly delayed promotions in most states and the steep disparity in the average age of entry, it would be appropriate to grant 1 year of weightage for every 3 years of service, subject to maximum ceiling of 5 years. This would more meaningfully recognize the long and valuable judicial experience of promotee officers while maintaining parity with direct recruits and bringing about harmony, justice, and complete fusion of district judges received from 2 different sources. Second, it's possible that a junior officer may receive accelerated promotion through limited competitive examination, 25% quota, strictly on the basis of merit. Such officers should not be unfairly placed below their seniors in the final seniority list solely because they have fewer years of prior service. The object of the weightage system is to restore fairness, not to penalize merit or efficiency. Third situation may arise where a comparatively junior officer receives promotion earlier than a senior due merit and performance as the criterion for regular promotion is merit cum seniority and not seniority cum merit. In such a case, the senior officer, though promoted later, should not automatically be placed above the junior in seniority merely because he has rendered a greater number of years in the lower cadre. To address these complexities and maintain uniformity across states, it would be desirable either to, 1, incorporate specific safeguards in service rules, clarifying how much contingencies would be addressed. B, as a similar and more uniform measure, grant a fixed 5 years weightage to all promoted district judges, irrespective of their total years of prior service or the mode of their promotion. Well, when discretion was given by your lordships in my lords, all India judges. Third, that High Court shall, my lords, make the rules. My lords, while making the rules, my lords, certain instructions, certain principles which are, my lords, there in the, my lords, lords, in Sabarbal's case, they have not been, my lords, followed by many high courts. As a result, my lord, the rules framed, they are not only different from each other, but my lord, there is no consistency and they are operating to disadvantage of, my lords, several promoted district judges. That is a problem.
I'm sorry.
Yes, Mr. Pradhan.
Comparing of the direct district judges from Maharashtra, it might have a slightly different point.
Wait, please, my lords. My lords, I appear for the All India Judges Association in the matter, and my submissions are I have 4 submissions. First and foremost, my lords, I'm requesting that my lords may review the judgment and to an extent that provide weightage to these judicial to the promotee officers on the basis of length of service, accepting the recommendation that of Shetty Commission. And my reasons are twofold. First, post, my lords, the requirement of the practice, the age disparity would increase further. Secondly, when the Shetty Commission made that recommendation, it was to overcome the age disparity. However, the 2002 judgment fell into an error when it says that roster would remedy that problem. Now, that was roster would really not do that. Lastly, my lords, pursuant to Rajneesh's order, this one, of course, the weightage is not alien to service jurisprudence. It is there with the IS also. And secondly, post Rajneesh, my lords, this really is justified because on the basis of length of service, such a weightage would be reasonable. So it would be in line with my lord's earlier order, which of course that benefit was not there in 2002, but that is now here today. So therefore, I'm requesting my lords to review that to this extent. One. Second, my lords, the roster system has failed. It has failed for three reasons. One, my lords, it does not remedy the age gap. Secondly, because of the roster system, what happens is that the direct recruits get clubbed at the top. So they may at the entry level, it may so appear that there is a division, that there is 50% promote officers, 25% direct recruit and 25% accelerated promote officers. But in the end, when they come at the higher bracket, it gets clubbed together as direct recruits are the one who remain standing because they have an age benefit. Now, my lords, my request is that this roster system may kindly be done away with because it presumes that all three different modes of appointment can happen simultaneously. Now, they are all elaborate processes, whether it is for the 25% accelerated promotion or direct recruit or the promotion by regular promotion by way of 50%. Now, it may be difficult for a high court to do all these things simultaneously. But in the end, so what happens is the promoting officer is available. He's working. In some places like UP, there is a rule which says that you can make him you can appoint him against a vacancy by way of a short gap. But that appointment will not be carried towards his length of service, which means that he is virtually discharging his function as an additional district judge. He is doing all the judicial duties of an additional district judge, but for the purposes of his seniority, he's a phantom. He doesn't exist because his seniority will only be counted once he is appointed. His appointment is made under Rule 22(1). Now, when that 22(1) will happen? When the roster would be applied. So he is there, he is working, but he is waiting for all the administrative things to function while he is working, but he is phantom for that particular period. So, my lords, for any reason, it could be because there is an administrative exigency. It could be because there has been an incorrect determination of vacancy and High Court is continuing that exercise. It could be for number of reasons. But if we wait, if the officer has to wait for his turn to put in the roster when all three modes of appointments can happen simultaneously, it leads to a delay. So that's one reason, my lords. Secondly, my lords, post Rajneesh judgment, where my lords have said that a judicial experience is more than that of experience as an advocate. Then in a roster system where a person who has already worked as a judge in the judicial services is put below a person who makes a entry at the direct level, that would be contrary to this, because if seniority has to be looked at, he has, as a judge, he definitely has more experience. The direct recruits, on the other hand, have an advantage of age. The accelerated officers have an advantage of age plus also experience, whereas these promoting officers have an advantage of experience. Now, all these three sources can be merged together and equalized if instead of applying a roster, one, weightage is given to them, and two, if their seniority is reckoned for the promoting officers from the date of availability of the vacancy for them and their suitability.
Availability of vacancies, then it goes back to the roster system.
No, my lords, it would not. Because if we look at the earlier principle, for example, in BL Goel or OP Garg, which had been followed and that has been noted down in the first National Judicial Shetty Commission report also. What they say is that so far as the direct recruits are concerned, they cannot claim seniority from any date anterior to their appointment. But in case of a promoting officer, he is there, he is in the service, this vacancy is also there, he is also found suitable So which means his promotability is not in question. The availability of vacancy is not in question, then why should his seniority be delayed for no fault of his own? Therefore, there are line of judgments, my lord, and for example, O.P. Garg is actually quoted in Shetty Commission, where they've said that so far as the promoting officers are concerned, the criteria has to be promotability and whether there is a vacancy available for you or not. So if these two things are available, then simply because there have been an administrative delay for any XYZ reason, the seniority of that officer must not get suffered. So because today, my lords, a number of these promoting officers are losing on the seniority, it's because the promotions are not being made. And this problem is more in states which have a larger number of officers. So because the more the officers, the more difficult it would be for the High Court to realign and compute the vacancies. Lastly, my lords, how they make an entry into the system. So if the promotion from the civil judge cadre to the ADJ cadre is smooth, the problem today, my lords, is this, that in 2002, when my lord said that now there will be 3 modes of recruitment: one by promotion, one by way of accelerated promotion, and one by way of direct recruitment. Even for the purposes, paragraph 29 of the 2002 uses the term merit cum seniority. Now, in Gujarat judgment by my lords have held that that is not a straitjacket formula. But there, my lords have taken clue from the Malik Mazhar judgment. Now, Malik Mazhar very clearly says that even the 2002, so far as that 65% promotion quota is concerned, you are going to not deny a promotion to a civil judge until he is found unsuitable. So it's rather the other way around. If a person is unsuitable, then you don't promote him. But what happens in practice, my lords, is this, that the word used in most of the rules that are placed on record, and because Learned Amicus has actually created a table summary of the rules in the first page of the volume. I'm not going there. In all of them, they use the word merit cum seniority. And this is because the 2002 judgment says so. And the method of promotion under this 50% quota is not very clear. So, for example, whether there would be a written suitability test or not, how do you actually assess the suitability of an officer? For example, if suppose an officer has an integrity issue, then he's unsuitable. He's found unsuitable by the High Court for promotion. Then with passage of time, let's say in the next recruitment year, he may not become suitable because the unsuitability is of a nature that can't be overcome. But let's say, suppose in a batch of 100 civil judges, they pick up that these 20 are most suitable and ought to be promoted. Then those 80 who are superseded, would those 80 be then considered again in the next round? If that is the case, then it means that in the additional district judge cadre, while a junior may become senior even under that 50% quota, so it's not happened in a sequence, in a smooth sequence. The promotion, the civil judge who was senior in the civil judge cadre, when that officer will go in the edges, under the 50% quota, may also lose his seniority and may become junior to the promotion cadre. Now, the rules are absolutely silent there. 2002 judgment only says that you have to consider merit. If an officer is found suitable, then apply the principle of merit cum seniority, and all high courts have framed their rules in that fashion. But how that would actually be put into practice, the rules are silent there. Now, my lords, if I may just point out, in the R.D. Mehta's, Ravidhan Suklal Mehta's case, the decision of my lords in Malik Mazhar was quoted. And if I may just request my lords to have volume 5A, PDF 1060, 1060, and the printed page is 1056. I'm just quoting the relevant paragraph, my lords, paragraph 139. This is where Malik Mazhar is quoted. Printed is 1057.
Paragraph 139.
139, my lord. So 139 quotes Malik Mazhar, and it says what my lords had held in Malik Mazhar is this, that until and unless an officer is found unsuitable, please do not deny that officer a promotion. Now, looking at this, then my lords had actually looked at all the rules in the other states also and said what we hold is that one must have an objective assessment of suitability. But in practice, because the rules are silent, there are no guidelines from my lords there, it says the assessment becomes subjective. For example, I may be in several of the cases, like in Gujarat, it has happened that a bunch of officers who had been found suitable, they cleared the suitability test, but because they were lower down in the list, they were not promoted because there were limited vacancies. Now, in the next recruitment year, the expectation would be naturally that, okay, I was found suitable, so my turn did not come last time, now my turn has come. Now I'm relatively senior, now with this vacancy, I'll be promoted. But this time, he is held unsuitable. As a matter of fact, some officers who were the top scorers have been found unsuitable this year. So now the question is, I was suitable then, but there was no vacancy. Now with time, now this time I'm not suitable. So the assessment of suitability is also subjective. Whereas my lords have directed the high courts to frame rules and have an objective assessment. So therefore, my lords, if the assessment, the suitability assessment is objective, if a method is ensured that the civil judges under the 50% quota are promoted until and unless they are not found unsuitable, and with passage of time, because they are not competing inter se, they are not making an accelerated jump like the 25% competitive exam. So there, this hard burning would be really mitigated to a large extent. Secondly, this will not really have an adverse effect on the direct recruits also, because direct recruits anyway have an advantage of the age. So they have actually hopped into the cadre. So even if the roster is not applied to them, they are accorded seniority from the date on which they are born in the cadre, that is the date of their substantive appointment. Even then, they will have the benefit of being young in age. The age would work to their advantage. The same advantage would work for the limited competitive departmental exam also, because they get into the cadre much earlier than their counterparts who were there in the civil judge cadre. So even if the roster is not applied and he's not put at serial number 5 there, even then he will have the advantage because he will still be the youngest in the cadre. He'll still be the youngest. So my lords, with this, of course, we are in alternative. The All India Judges is supporting the prayer of the learned amicus for the quota. That is what we are. But primarily, we are requesting.
You are on weightage.
Yes, primarily, my lords, one on weightage, and secondly, the roster has to go, and third, the suitability has to come with a object. My lords may kindly lay down guidelines so that the suitability test which is done for promotion from civil judge to the ADJ, that becomes objective, and that doesn't remain objective because
that we have already issued directions in the All India.
my lords, what is happening is that in practice there are still some gap. For example,
the judgment which I delivered in
yes,
May,
yes,
Bhattagar.
Yes.
So as suitability test is concerned, we have issued certain directions in that judgment.
Yes, Manoj. So suitability test for
For promotion from the civil judge senior division to the district.
Yes, so correct, Manoj, because earlier the 2002 judgment had used the word merit cum seniority. So your lordship took the view there can't be merit at two stages, merit for LDCE also and merit for the civil judge with senior division to the ADJ also. So therefore your lordship says suitability.
No, and we have issued certain directions as to what should be the suitability test.
Yes, my lords.
Because some high courts were not having the suitability test, they were doing it on basis of ACR, that's it.
My lords, additionally, the only thing I'm requesting is in additional to those guidelines is this: suppose an officer is found suitable, he qualifies the suitability test in, let's say, the current recruitment year, but he is not promoted because he is lower down in the seniority list.
And there are no vacancies for.
Because so does he has to give that suitability test again?
Why not? If he has spoiled his career in that 1 year, he can be stopped again.
My lord,
He's to be tested at the time when he's being promoted.
Considered.
so that's exactly what my point is. So if he has done something
You
that
can't say that once you have qualified, then you are qualified for all time. Whenever vacancy comes, you should be promoted.
I leave it.
Your work
Yes,
that will also be considered.
yes, I leave it there. I'm most grateful, my lords, for the audience.
Thank you for your, on both the sides in Odal Council, you have done voluminous work.
Grateful, my lords. I'm very grateful.
Yes, Mr. Dr. Vivek Sharma.
Yeah, Lordship, I will start my proposition. By the virtue of Article 233, Clause 1 and Article 235, the issue of promotions of the district judges is exclusively in the domain of the High Courts. So this Honorable Court should only decide the guiding basic principles for the promotion of the district judges, and the concerned High Court should be at the liberty in formulating detailed rules and regulations for the promotion of the district judges. Now, Lordship, here are mainly the two issues. First is framed by the Honorable Court, what should be the criteria for determining seniority in the cadre of the higher judicial services. And the second issue is in the prayer of the amicus that the promotee judges should get the extra advantage to you can say for the appointment of the post of the principal district judges. So, Lordship, I will starting my submission from the prayer of the amicus first, and after that the issue framed by the Honorable Court on the second one. I am supporting the prayer of the amicus that the promotee judges should get some extra advantage in the appointment for the post of principal district judges. But the way and the manner and to the extent how can it be done and to what extent it can be done, it is totally different in my submission. First, it is my duty to bring in the notice of the Honorable Court that what are the concerned laws and the constitutional provisions relating to reach at that issue or the solution of that particular problem to get the, you can say the, for the post of principal district judges, the opportunity to the promotee judges. In Roshanlal Tandon versus Union of India in 1967, which is against all of us, we know.
Against all of us?
No. In you can say of our side, Lord say. And my proposition that the second issue the proposition that the for the post of principal district judges, the promotee judges should be considered in the extra advantage must be given to the higher strength of bench. Why? Lordship, let me complete it. I am speaking on this side and I know this. Because in state of Punjab versus Davinder Singh, in morning the amicus is saying that is superseding the Roshanlal Tandon versus Union of India. It is not. Because I also argued in that.
You are arguing in every constitutional bench.
No, Lordship, in that particular bench. So that's why I am.
You have surpassed Mr. Tushar Mehta also in arguing in constitutional benches.
No, Lordship, it is just I am saying 2 or 3 points which are favorable to us.
Shankar Narayanan. So yes.
Lordship.
Today he is not here.
I am grateful, Lordship.
He was here.
I said.
In the first half.
Yeah, Lordship. In the state of Punjab versus Davinder Singh, we are discussing the sub-quota and quota. And that was only given by the state only after the empirical data. And that was for the creamy layer purpose in the SC/ST category.
So
And
one line, why don't you tell us how do you want to
yeah. So,
prepared?
Lordship, I am coming on.
Give your position and tell us.
I am, Lordship, coming on that point.
So there are only 2 minutes.
Yeah. Lordship, within 5 minutes I will go.
No, 2 minutes. We are granted 10 minutes. So as per your chart.
Lordship, I asked for the 30 minutes, but the time is reduced.
7 minutes are over. Yes.
For that, you will complain to the amicus or the nodal council. Yes.
Lordship, so please. So this provision that the how much quota should be given to the promoting judges must be considered by the bench of the higher strength, because the state of Punjab versus Davinder Singh.
Should have been on this side.
No. Lordship, they are different things. They are saying that the promoting judges should not get any extra benefit. But I am saying they should get. But
also refer to 7 judges. Yes.
Yeah, that is the difference in both. And Lordship, also one more thing. If we compile the total LCDE and total promoting judges in the one cadre and the direct recruits in the second cadre, and 1:3, the 25% from the promoted judges, whether it is from the time scale or the selection grade or from the LCD, and the 75% from the direct recruits. That is my proposition.
Yes, thank you.
Grateful to
Just to, sorry, my lord, apropos the question of my lord, the Chief Justice.
Yes.
My lord, all the suitability test, my lord, the Chief Justice's question, that is, my lord, decided as issue 6 in that 20.
In that matter. So that's
and it's at page 891, volume.
And we have also let down certain.
Absolutely.
We have also referred to their Gujarat judgment.
Page 891 of volume 5.
Let down certain guidelines as to what should form the suitability.
What should form the suitability? Absolutely.
Tomorrow.
Lordship,
Yes,
in
yes,
that,
thank you, Mr.
okay. Merit cum seniority must be considered in that.
Yes. Tomorrow we'll be sitting in the first half because I have some difficulty in the second half. So we'll give some more time on the
if required.
If there are so many on the other side. Yes.
Still, they all collapse. Different. So they'll all be saying the same thing.
Mr. Rahul is also
Just
there.
because there are 9 councils doesn't mean that you will all repeat the same thing again and again.
You are from Punjab or Haryana, Mr. Rahul? Kerala?
Kerala has benefited.
Yes,
a lot of practice from Kerala. The other day in my court also, he was a Kerala.
So Mr. Basant will have some competitor. So if it goes on, we will continue on Tuesday.
Thank God it doesn't say north to south.
Great.
Because there, yesterday Justice Nath was wishing you.
Yes. No, missing every day.
Special bench.
Not only yesterday.
Special bench at 3:30.
Yes,
you have been placed in a category with somebody, you know.
I heard about
it.
Just gonna share the joke with us too.
That's not.
He doesn't want to take it any further.
May it please. Look, there's a problem in this matter, your lordships have appointed one amicus first. There should have been at least 2 amicus first.
One for direct and one for properties. Three, sorry. The third for the LDC.
One for the High Court, my lords.
For the High Court.
Because the High Courts, my lords, are very reluctant, my lord, to provide data, to speak up what they desire, my lords.
That is the whole difficulty, Mr. Dwivedi.
Yes.
The High Court registry controls everything so strongly. Same as Supreme Court also. Registry is very powerful everywhere. So High Court also, the registry, if they are direct recruits, they will make sure that the promotees don't get their due benefits. And if the promotees are in majority there, they will hold back. That's the whole difficulty.
Because not only the registry, but even the judges, my lords.
I will not talk about judges. But I know definitely for it, they will not provide you the data, they will not place the file at the appropriate time, you keep asking them, the file is lost, they are searching, this, that, everything keeps happening. Until you have a very good administrator at the helm.
So there are issues which can be raised factually, constitutionally. They do not, and unless my lord, the data, as my lord Justice Chandran observed, my lord, unless the data is accurately presented before a lordship, there is a grave danger. There is a grave danger of doing something, my lord, which may cause serious imbalance rather than arriving at a proper balance. We create a situation that where there is balance already existing, an imbalance creeps in there. My lord. So that data, with great respects, is not there, my lords. One, my lord.
The high courts are before us.
No, high courts are there, but the data.
You are for the high court, so you should have placed the data on record.
So that's what I started. That has to be an amicus, my lord, who can pressurize.
Like Mr. Tadekar placed the data yesterday.
Yes.
So in the last so many years.
No, it's not. Your lordships want to lay down a uniform rule.
Yes, therefore so.
Therefore,
you are appearing for the high court.
So I'm appearing for one high court.
You are appearing for Allahabad High Court.
Allahabad High Court. I'm not appearing for all the high courts, my lords.
There are only three.
And most of the high courts are not represented, my lords.
They have been noticed.
No, legally speaking, I'm not saying that adjourn the matter. I'm not saying that.
The high courts, all the high courts as well as all the state governments,
but they
all have been duly served.
I'm saying the data, therefore, is not before your lordship. And whatever data has been picked up, my lords, by the learned amicus, and I must say, my lord, he has faithfully reproduced from the various affidavits. But they are scanty, incomplete, and based on pre-existing, my lord, legal positions. We still don't know, my lords, your lordships have brought.
That's what Justice Vegan said yesterday. Now, these two judgments, the dynamics may change.
Yes. So therefore, my lords, I stand up, my lords, on behalf of Allahabad High Court to dissuade your lordships from issuing any directions, because it will create imbalance, and high courts are in the best position. I will show from the learned amicus. And my dissuasion is firstly based on the constitutional plank. That's chapter 6 of part 6, Lord vests exclusive control in matters of appointment, promotion, postings, and control in the high courts. There may be some situations, I'm not saying that the Supreme Court should keep its hands off completely, Lord. There may be situations, Lord, where a lordship's interventions are required. But generally, Lord, the high courts are seized with the data and facts, and therefore, they are in a position to deal with the situation which prevails in the high court in the particular state.
That's the reason, because every high court is taking different stance. The practices adopted in every high court are different, and therefore some uniformity has to be there.
There cannot be. There cannot be. I'll show from the amicus's affidavit itself. Kindly have that affidavit. Look at the situation, how drastically it is varying. How do you bring about uniformity by a particular? It's not a question whether we should have quota. Next question will be, what should be the quota? Merely saying that there should be some quota is not enough. Where to have the quota? Where not to have? Whether to have? To what extent the quota should be? Should it be 10%, 20%, 50%? So, if the situation is varying, for example, my lord, in West Bengal, as my lord pointed out on the last occasion, there is a fair balance today existing. Now, any quota is bound to disrupt that balance. In Allahabad High Court, the age gap, which was 10 years, in the last 3 years has come down, Lord, is varying between 4 months to 3 years now. Because of the roster system and the holding of the examinations regularly in time and simultaneously every year in recruitment year, it has come down. Now to introduce, my lords, a quota system, A is unnecessary and B can create another balance. My lord, look at the situation, Lord. Your Lordships introduced a quota in 2002, 50, 25, 25. In 2010, within 8 years, Your Lordship thought, my lord, people are not coming, therefore 65, 25, 10. Another 10 years, my lords, again we say that it should be 50, 25, 25. So within a span of 18 years, 3 uniformities. So let the high courts deal with the situation. This is not that kind of a problem which is uniformly existing in the same manner in every high court. Now see, look at their amicus's affidavit. Written submission, sorry. And your Lordships have made some good changes because in the previous judgment, your Lordships have opened up the direct recruitment also. So therefore, Lord, now the whole 100% field is open, Lord, for the civil judge junior division to walk into the higher judicial service. If they are keen, if they are intelligent, if they believe in themselves, they should appear at the earliest, Lord, in that examination, directly to examinations, and they will be at par, Lord. But if they are diffident and if they feel that it's better to walk the longer route, as we know, Lord, that if you go to Amarnath, Lord, there are one short route, Lord, which is much more steep and risky, and the other through Pahalgam, Lord, and the other is through Sonmarg, Lord, which is a longer route and less.
Longer route, but reaches the destination.
Yes, you reach the destination. And unfortunately, that's the problem.
Here the difficulty would be if you take other route, you will be lost.
No, here the destination is not selection grade, not super time. Here the Amarnath is the judgeship, my lord, of the High Court. These are not problems. Yesterday's argument, my lord, then I again obtained more data from the Allahabad High Court and I find that in the selection grade also the promotees are much more than the direct recruits. I'll show that. So selection grade is also not an issue. Issue is the High Court judgeship. Because there, my lord, your lordships have some unwritten rules, what will be the zone of consideration, etc. And your lordship knows better than me, my lords, how, my lord, from the judicial service, they are picked up. My lord. If your lordship opens it up, my lord, to the entire zone of consideration is made the whole of this super time scale or the district judgeship. Every lawyer doesn't become a judge, my lords. That is heart-burning. Heart is a very
No, many lawyers refuse to become judge.
Many refuse to become judge, my lords. So maybe there is heart-burning also. Why A is selected, why B is not selected, all those keeps on happening, my lords, everywhere. And there is no system of selection, my lord, that a lawyer who is more aged, my lord, he'll be selected and who is less aged will not be selected. So these kind of heart burnings are normal. Heart is such a fickle thing, my lord, that is very easily burns, my lord. Even if the neighbor, my lord, is having a better car or a better fridge or something, it will burn. So we can't take care of heartburns. And your lordship, my lord, since O.P. Garg's case, have been saying, my lord, that now we hope it will come to a rest. It will not rest. Whatever a lordship provides quota, this promotee versus direct recruit will go on. And it lingers, my lord, after becoming judge.
That has been a wishful thinking in many judgments, and still it's like that.
Yes.
It's not, this judgment will not be an end of the country.
Not,
that,
my lord, right?
That Both sides should.
Our effort is, my lord, to improve it. That's about all. Whether that improvement becomes, my lord, a deterioration, we don't know.
It's always trial and error.
Therefore, leave it to the High Court, my lords. That's what I'm saying. If it is trial and error, my lord, it's let that authority which is constitutionally constituted, capacitated to do it, my lords. Force them to do it. As in the last case of age, your lordships passed an interim order saying let the High Court first consider whether age should be 61 instead of 60. Why should the High Court be bypassed? Then why should this be divested of their authority, power, and duty? It's a constitutional duty of the High Court. Not only authority and entitlement, it's a duty, my lords. And it's time to strengthen the High Courts, not to weaken the High Courts. With great respect, my lord, your lordship may condone, my lords, my expressions. But things are gone a little too far. In this very court, a petition was filed, which is still pending. One of 2017. In re-concept note.
In
concept note. On the basis of some letter from the government, a committee was constituted, and that committee was tasked to determine, my lord, whether this court should hold the selections and create a pool for recruitment to the office of district judge. That was the concept note. And that...
The issue with regarding All India Judicial Services on the pattern of IAS and IPS is always alive.
That authority, that's another grave breach of, kindly have a look at, let me complete this story, my lord, first before going to 312 All India Judicial Service, what it is. That committee, headed by Justice Goel, approved that concept note, amicus was appointed, and the matter was listed in the concept note in the court. So the whole selection will be done by the Supreme Court, and High Courts will now, my lord, just pick up. What remains of Chapter 6, my lord? It's dead.
But we are not inclined to do anything of that sort.
No, it's pending.
No, not even remotely.
After our resistance, the bench was disbanded. After hearing the matter for 2 days, bench of Chief Justice Kehar, Justice Goel, it was disbanded. We said, please, it's a destruction of the High Court. It's an elimination of Chapter 6. Now, my lords, what should be the qualification?
Even if we recommend to the collegium some of the lawyers practicing here, you only suggest the names and leave it to the discretion of the High Court entirely.
But here
we call upon those candidates, go and argue before the Chief Justice and the collegium judges, and only after they find suitable, the names have been recommended even from the lawyers of practicing.
That's good. That's very good, my lords. That's how it should. That's how it should be.
We thought that there has to be some opening to the lawyers practicing here from different states.
Mr. Dwivedi, the instance which you are quoting.
Yes.
I am quite sure that you must be aware that what were the reactions by some of the High Courts.
I appeared for the High Court, my lords, for 3 High Courts.
And I wish if a day comes when you display the online discussion, when the opinion of the High Court was sought, how some of the judges of the High Courts reacted, including me.
Yes.
So if there is an issue, there is a point, if there is a need to take a stand, we do take a stand.
That's right.
And I wish if that is displayed, and what I said.
It should be displayed. But therefore, I am saying, Lord, today we are fixing the age of retirement, we are fixing the quota, we are fixing the criteria, we are fixing, Lord, what should be the quota of the various sources, what should be the age at which there will be eligibility. Then if you allow that petition also, Lord, concept note petition is still pending. Unfortunately, though it was adjourned, it was tagged with Malik Mazhar and it is still pending. So someday, Lord, somebody may feel, Lord, that it's time now to...
He has already hinted, it's, the purpose is not to usurp the power of anyone. That
No, sir,
constitutional
but
power.
ultimately to introduce whether your lordship weightage or quota, that's the two broad suggestions. Your lordship will have to issue a mandamus, my lords. And mandamus for what? To make a legislation. The rule of the High Court is legislation at par with parliaments and state legislatures' law, my lords. It's not a subordinate legislation. In some cases, they refer to it as subordinate. It's not subordinate. So you will have to issue a mandamus.
It will be only, so, as already hinted, for uniform guidelines, for a kind of an infusement of the strength and for betterment of the
Not betterment and enhancing the efficiency. That's the only.
So what will the High Court do? High Court has to follow it.
Suppose even.
And High Court can't amend it.
We don't know what we are going to do.
No, I'm dissuading.
If we accept any of the suggestions given by the learned amicus, even if quota is provided, it's not necessarily go by seniority.
No, I'm not on what your lordship will do. I'm trying to dissuade your lordship.
We also don't know what we are going to do. That's what we are saying. But even if we do something of that sort, we will not be taking away the discretion of the High Court in recommending the names.
No, if
names would be recommended by the High Court solely on the basis of their satisfaction with regard to the suitability of a candidate to be elevated.
If the discretion is of the High Court is not to be taken away, leave it to the High Court.
But why are you averse to having some uniform policy throughout the country?
No, uniform.
Why should there be some different policy in the Bombay High Court and something?
Because in all aspects, with great respects, in all aspects, there cannot be uniformity, and uniformity is the wrong goal to say.
100% uniformity. Aren't there promoting judges in the every High Court? Aren't there direct district judges in the every High Court? Is there any distinction that say Madras High Court, 50% are district judges, direct district judges and 50% are promoted? When there is a uniformity in all that aspect.
So uniformity in this matter, my lord.
Rest assured, we do not even indirectly, remotely intend to take away the discretion of the High Court.
Lord, uniformity in this respect, my lord, will be disastrous.
Mr. Dwivedi, you also please keep in.
Yes.
We are quite sure you are aware. Some of the judgments have been cited. This court has already intermittently and in one or the 2, 3, 4, 5, 7 high courts, on the criteria or formulation of seniority has already interfered, leaving no scope for the high courts, leaving no scope for the discretion of the high courts. The full court decisions of the high court have been set aside here. And if a particular way of directions have been issued, in some of the cases, even ignoring the statutory rules, what to do? Are we not required to, in sitting in larger benches, to rectify our own mistakes?
Once the High Court makes a rule, if your lordship and matter comes before lordships in an appeal, my lord, the lordship certainly can issue directions. But today, my lord, here is an IA moved by an amicus seeking a direction to protect the promotees.
That's only everybody is giving their viewpoint. It's not that necessarily that we will follow that.
No, but this methodology, my lords, I'm with great respect.
Evaluation of the best of the possibilities that what can be.
Well, it's my humble submission, my lords, your lordships.
All right,
because
we've taken note of the submission.
Yes,
that we need not do anything. All right. Yes. Now you proceed whatever you wish to say on the submission.
On the submissions made on the other side, including Vakeja's, that there has to be a separate court of our LCD for elevation.
Your lordship will take note, do whatever your lordship feels. I am trying to I said.
No, we have recorded your submission. We have recorded your submission, as Justice Raj has rightly pointed out. We should adopt the practice of hands-off.
A hands-off, and B, my lords, even if your lordship has to issue some guidelines or directions, it should be general, so that High Court's discretion.
How many times have we been telling you that we don't even remotely intend to take away any discretion vested in the High Court?
That's my humble submission.
That's right. It's only going to be a general direction. There is nothing like that inter-seniority. We have already indicated to the other side also. There is no question of entertaining inter-seniority dispute by us.
Now kindly have, my lords, the second plank, my lord, for dissuasion is The great divergence. हो कहाँ तक है? Amicus का note. Amicus का note. और नहीं amicus नहीं. ये amicus. Which page?
23.
Come to paragraph 23. Kindly come to paragraph 23, Milords. Amicus written statement.
Yes.
Paragraph 23.
Yes.
Yes, the chart.
Now kindly see, Milord, different states. What is the age gap difference? Andhra, Chhattisgarh, Milord, happens to be on the higher side. Gujarat is somewhere in the middle. Now see Haryana, only 2. This is not something abnormal, Milords. 2 years gap. Kerala is 4, Madhya Pradesh is 2. And next page.
Rajasthan 42 against 13.
Yes. Barring the first 2, the rests are between 2 to 6. And if your lordship comes to Sikkim and Uttarakhand,
Yes, reverse.
Reverse.
Sikkim, what was the strength of judiciary?
Now kindly have a look at paragraph 27. However, the situation is quite different in several other states, where promotee district judges are much more in number than direct recruit district judges at the post of principal district and session judge, district judge super time scale, as is evident from the following. In state of Chhattisgarh, as per the seniority gradation list of the cadre of district judges, out of 23 principal district session judge, 14 are promotee district judges. In state of Gujarat, as per seniority gradation list, out of 33, 24 are promotee. So whole list of high courts, which runs through at least 12 high courts, include 13 high courts, including state of West Bengal, which is at K, and Tamil Nadu is H. Delhi High Court is there. So where is the need, Milord, for?
Even for uniformity. No, it will also be in the interest of the direct.
No,
where their position is.
No, this will keep on varying. It's not a question that this is a data based on the pre-existing rules. Now, with your lordships opening the doors of direct recruit, many of these promotees will get an opportunity to.
If the dynamics change, the law will change. Where 4 of us would not be here.
That's not the point, Milord. To us, your lordships are lordships. We don't look at the faces.
You also don't, in the latter way.
Your lordship will have to look at the faces.
2010 changes.
For us, your lordships are all judges.
2010
so it doesn't matter who is there.
2010 changes, 2002 changes in 2010, depending upon the circumstances existing there.
What?
25 24, 25, many of the high courts feel that the changes made in 25, in 2010 need to be relooked into.
No, therefore let them, therefore I'm saying that such is the variance that therefore there should be no uniform guideline, my lord, directed to the high courts because there is
On
so
the
much of
contrary,
variance. Leave it to the,
if this variance is removed,
it cannot.
It will balance the rights of all the stakeholders.
It's because my lord, there is lot of other factors in play. Let me come to the other factor based on what is happening with us.
I'm sorry to interrupt, my friend. Para 25 goes one way, para 27 goes the other way. So there's a whole set of states in para 25 where the district direct recruits are more. Para 27 is what my friend said. So there's no uniformity there in
That's what we are saying.
whichever way you correct it, it's very difficult to create.
After 7-8 years, you are right, the dynamics will change. Now with the 3 years practice at the bar, joining the service, judicial service, as rightly pointed out, part of eligibility for direct recruitment. So after 7-8 years, the judicial officers will be eligible to compete not only for 25% LDC, but for 25% direct recruitment also. So there can be a possibility that suppose you have a cadre of 100 officers, junior division, out of them, 25 are selected in LDC, 25% are selected in directly, hypothetically, and only 50% are left.
But I appreciate.
Completely a new dynamics for
So,
seniority determination.
no, so,
We are right.
The latest judgment of 25, your lordships have proved the concept of LDC even at that level. So that will further give a fitting to the writer of the. I'm sorry.
But the impact of it will be only after 7-8, maybe 10 years that somebody will be able to
We
evaluate.
will not be there. All of you will be there after 7-8 years, and again, take up that issue.
No,
get it modified.
No, there's something much more than this.
Yes.
Look at the various other factors. Your lordship may have quota if your lordship wants. Put weightage, whatever.
We are telling you, we don't know what we are going to decide.
No, I'm saying
at the threshold, one argument we have obviously we understood. So you tell us what are your oppositions to the submissions made by us, so that we can consider. We are not going to decide only on the.
No, I'm not proposing anything. I'm saying don't do anything.
That's all. Then let the
I have to. No, it's not simply by saying ipse dixi that I say don't do. Why you should not do it? That's the reasons I'm.
Come to the other factors now.
So now, there are various. There are
for applying the doctrine.
There are various imponderable factors which operate, my lords, in determining whether there should be a quota, weightage, or not neither of them, or leave it as it is to the high courts. There are various factors. First is, my lord, why is there this age gap, my lords? None of the petitions, affidavits are throwing any light as to why, my lord, the judicial officers in the civil divisions, civil judge junior division, are reaching late, my lords. If a lawyer gets an LLB degree at 22 or 23, before your lordship's judgment, there was no bar, my lords, in appearing in the examinations for the junior division, but lawyers were not appearing at 26. The average age of the lawyers appearing in the examination is the most important factor, which get. In Allahabad High Court, it is 28. Now, please get this data from all the high courts. This is very important. They are all crying about the age gap, increasing age gap. Even Shetty Commission emphasizes. The reason is that lawyers are appearing in this examination at a late stage. Your lordships have not barred the door. It's their choice. I have a choice to carry on with my practice. I have a choice to refuse judgeship. I have a choice to appear, my lords, in the 7 years examination upon reaching 35 years and go straight to high HJS. And I have a choice, my lord, to go at the earliest, at the lowest rung and take the long route. So an individual lawyer is exercising his choice. And if I exercise my choice at the age of 30 and 32, I'm bound to be there, my lord, the age gap will be there. And in the examination experience in the Allahabad High Court is that the average age is 28 years. We have mentioned in our affidavit, if your lordship has that affidavit.
This is volume 3, R1, page 1.
Volume 3, R1. हमारा affidavit. Now, if average age is 28, which shows, my lord, that the large number of people are appearing in the examinations beyond the age of 30 years. And none of the promotees are giving your lordships a data, my lord, from different high courts as to what is the average age. Now, if I choose to appear at the age of 35 and become a munsif, my lord, and then I complain, my lord, that I don't get a fast track. So these are the problems which are existing there, my lord, and these facts are not before your lordships. Whatever solution your lordship will find will be in the absence of material data. Kindly have paragraph 7 of my affidavit. And now your lordships have put a 3 years bar of experience. So they will appear naturally, my lord, at a later stage. That's a further. Earlier there was no bar. Now, in the interest of efficiency of service, my lords have rightly put that bar. So therefore, my lords, it's not a question of a difference of age gap between the two groups and who is reaching and who is more or who is less. You have to keep in mind the whole overall efficiency of the judicial system, my lord. That's the most important thing. And that's why, my lord, this 3 years bar has been put, notwithstanding the consequence being that they will be delayed. However, even if 3 years is taken to 23 to 3, 26 and 26, because before 35, nobody can appear. So they complete 7 years also for directly appearing. So who prevents, Lord, this judicial officers, now that your lordships have opened the door, they should compete, Lord, and whoever is confident about himself, he will come, Lord, then in the direct recruit, your lordship will find that half of the direct recruits will be, Lord, the promotees. So let us see the fallout of what your lordships have already provided.
They would not be promotees, they would be appointees.
Sorry?
How would they be promoted?
No.
If they are selected, they will be direct recruits.
No.
They will be promoting.
No, from their group, I'm not, they are from the judicial.
It is not as if that their initial service will be counted and they will get a retrospective or something.
No, I'm
It
saying.
will be a fresh appointment.
Of course it will be fresh, but the civil judge junior division by this route comes faster into the district judge. That's the important. So therefore, this permutation and combination which your lordships have now produced, let us see, my lord, we are, my lord, sort of hastily, my lord, moving ahead.
What is the next
another?
Mr. Dwivedi, what is the next point now?
So lordship may kindly note, my lord, I have indicated at paragraph 7, the minimum age 28. Now, there is a small note, my lord, which I have prepared. If the lordship has that note, allows me to, my lord, place it.
What is it called?
May I quickly just take your lordship through this note, just a small note. The submissions of the learned amicus are founded on the factual premise of increasing age gap between the direct recruits and promotees in the HAS cadre. As per para 23 of his note, it appears that there is no uniformity as regards age gap in different states. In West Bengal, Chhattisgarh and Madhya Pradesh, there is broad equivalence between the two categories. And in Sikkim and Uttarakhand, the promotees are younger in age. In Haryana and Madhya Pradesh, the gap is a negligible 2 years. Even in Jharkhand and Kerala, the gap is only 5 years. Further, in para 27, it is pointed out that there is not much difference in the average age of promotees and direct recruits. Reverting to the additional affidavit of the Allahabad High Court dated 25/10/25, it would appear that from the year 2012 onwards, the age gap has come down drastically from 10 years to between 4 months and 3 years. There is some variation on account of different factors. One of the factors for the relatively higher age for the recruitment of HJS is that several of the candidates appear in the civil junior division examinations when they are 28 years of age or above. Ordinarily, a lawyer would be eligible to appear in the examination at the age of 22-23 years, as earlier there was no limitation of 3 years practice at the bar for appearing in the examination. Even after the stipulation of 3 years practice requirements, they will be eligible to appear in the age of 25-26. Ordinarily, the civil judge junior division takes 10 to 12 years of service before being considered for promotion to HJS. Since the minimum age for HJS is 35 years, normally there should not be occasion for substantial age gap between the two categories. In para 7 of the High Court affidavit, it has been stated that the year 2022, the average age of selected candidates for civil judge junior division was 28 years. This indicates that a sizable number of candidates were above 30 years. In para 9 of the aforesaid affidavit, a chart is included which shows that from the year 2008 to 25, the promotees are occupying 75% or more of the post in the HJS cadre. So far as the post of district judge stroke equivalent posts are concerned, it is stated that there are in all 268 posts, of which 75 posts in 75 districts are of district judge. The rest are equivalent posts. Out of 268 posts at present, there are 103 direct recruits and 148 are promotee officers. At present, there are 70 district judges, of which 12 are promotee officers. According to the information obtained from the High Court on 28/12/25, there are 233 posts in the district judge selection grade, which constitutes 35% as per Rule 27 of the UP HJS rules. Out of these 233 posts, only 34 are direct recruit officers and 198 are promotee officers. So even in the selection grade, they are in large numbers, much larger than the direct recruits. Out of these 233 posts, only 34 are direct recruits and 198 are promotee officers. One officer is from LCDE. There are 78 posts of district judge super time pay scale. Out of these, 65 are direct recruits and 12 are promotee officers. The letter from the High Court is enclosed. I have a next verse. Yesterday, I got this information, which is at the end of this note. Apparently, the situation is not at all alarming as has been projected. Moreover, the inter-C configuration at different levels is a fluctuating phenomena and would vary from time to time. Para 16 of the additional affidavit, it has been stated that since the year 1990, a total of 200 officers from HJS have been elevated to the High Court. Out of these, 133 officers were promotees and 67 were direct recruits. Considering the elevation at different points of time, it is apparent that from the chart that up till the year 2009, the promotees elevated in the Judge of High Court were far more than the direct recruits. Between 2010 and 2019, 32 direct recruits were elevated, and while 27 promotees had been elevated. It's almost a fair balance. After 219, the promoting officers is 11, while the direct recruits are 26. The fluctuation is on account of more than one reason, my lord, which is happening. So when a crop of younger civil judge division are there, my lord, they will remain and get a longer term. But if
You must also keep in mind that the direct recruits quota is much bigger than the direct, the promotees quota is much bigger than the direct recruits, and see the numbers.
So therefore, I said in the beginning, my lord, the target is that, then it is there, my lord, that some internally some changes should be there, so that the whole of this is.
That is actually to be examined whether or not to do anything.
Yes. But that has been prevailing since long. That's up to, my lord, that's not the issue, my lord, before your lordship. That's entirely within your lordship's domain, my lord, what to do or not to do. It is submitted that according to the written submission of the learned amicus, in several states, the promotees are much more than direct recruits at the post of principal, district judge Suprime, see para 27. States mentioned are so and so. There is no similarity in the position of different states. In most states, either there exists a broad equivalence or the promoting officers are larger in number. This is apart from the fact that the numerical interrelationship is of a dynamic nature and is variable. Therefore, the prayer sought for ought not to be accepted, and the matter should be left to the High Court to tackle any imbalance which may exist. Now, my lord, I may just inform your lordship, my lord, that it has also happened in the Allahabad High Court, and my lord Justice Nath must be knowing, my lord, that sometimes, my lord, there are vacancies in the civil judge senior division level, and enough candidates are not available because of the eligibility requirement. So the High Court has been granting relaxations, my lord.
That's right.
Lordships are aware. So it's not that the High Court is, my lords, closed its eyes and doing nothing, my lords. So whenever a situation requires in the interest of judicial efficiency, administrative efficiency, the High Courts have been, my lord, alive to the situation.
Many times that is necessitated because of the jurisdictional issue, like in a monetary suit or even in.
We don't have the specific number of minimum officers to be placed in every district.
Yes. So that relaxation is always in public interest.
Yes.
That is done. Most of many high courts do.
I have mentioned about it. I have quoted your lordship's orders, my lords. I'm not reading them, recent judgments. And my plea is, my lords, that please wait and watch and see, my lords, what is the fallout of these judgments. Maybe, my lords, in a year or 2 years' time, my lords, we'll have fresh data, my lords, as to what is the fallout, what is the imbalance.
Yes, sir, that is
but
already,
exact equality, my lord,
that has already been argued.
exact, lordship, may pardon me for repetition.
This was with the 8th or 10th time that you are arguing the same point.
But the point is,
it's not like hammer that if you do it 12 times, then it will have more impact.
We don't know, my lords, what will have impact. My lords. We argue in a state of uncertainty, my lords, and not knowing what is impacting. My lords.
Correct.
So therefore, your lordships, and my lords, so far as the position of the Allahabad High Court, something was said by two learned counsels, my lords, that the promotees and the direct recruits are not being, my lord, recruited in the same recruitment year. And if the promotees are recruited in year A and year 1 and the direct recruits in year 2, so they can't then be, my lord, put in through the roster system above. But that's not the position. After 2012, earlier, my lord, there was a problem, number of litigations which came up to this court, my lord, where vacancy determination and other aspects, promotees versus direct recruits, because of which, my lord, the recruitments were held up. But after 2012, every recruitment, the recruitment year is same. The advertisement, my lords, for selections and appointments and all the 3 grades are being issued simultaneously. The letters of appointment are being issued simultaneously. So it's not a case where, my lord, there is a different recruitment year. So I agree, my lord, that there should be the same recruitment year, at least in this court. I don't know about Bihar, but in Allahabad High Court, my lord, this is happening. And in fact, in the previous year, When we sent the notification to the state government, they issued for the direct recruit first. We sent it back to them. No, all three should be issued simultaneously. So all those issues don't arise. Which Ms. Mayuri Milord and Dinesh Trivedi, they were pressing about the roster being same. So far as Allahabad is concerned.
So you agree with Mr. Dinesh Trivedi on one aspect at least. That the quota should exist only.
I really disagree, Milord.
No. You also said that you agree that the quota should be only the recruitment only for the recruitment year.
No, I'm not saying anything. I'm only saying that in Allahabad this problem doesn't exist.
Because Allahabad has been regularly holding these elections.
And we are filing the affidavit in that Malik Mazhar case also.
We have already clarified, it's not Allahabad High Court or Punjab Haryana High Court.
Because unfortunately, I can explain my position. I don't know the data of other high courts. There must be some problems in some courts.
General principle. So
Yes.
when you are saying 1 year roster points, are you also agreeing to that the direct recruits, say on hypothetical basis, if people recruited in 2020, 2025, and occupying a roster point which will remain unfilled in 2019 or 2018?
So, my lords, your lordships have in such cases taken a view that if the roster system has broken down, the authority concerned, either the High Court or the Supreme Court, should come to a conclusion that the roster system has broken down. For example, but in Justice Rohinton
That is,
Nariman's,
wherever it is broken down, continuous length of service, that is a settled
then that roster will not apply. But if merely because, my lord, one selection happens in December 2018 and the other happens, my lord, in February 2019, one can't say that the rule has broken down. So it all depends, my lord, whether your lordships on facts can conclude because of the long gap. For example, was in 2018, 15 SCC 439 in the Allahabad High Court, this problem was there. Between 2002 and 2009, when there were litigations because of which so lordships were not said that we will not apply the rota system.
But must have been broken
That's
down.
how lordships have done. I'm not citing that. The judgments were not which I've,
in all services.
some of the judgments which I mentioned in my petition are contained in this compilation for convenience. So that's my submission, my lords. I have cited judgments also. For example, my lord, in one of the cases which came before your lordships in Asia resurfacing, a direction had been issued by this court, my lord, Justice Nariman, that since they, in criminal petitions of quashing, interim orders are granted by the High Court and then that matter doesn't come up. So the order had been passed by this court that if within 6 months the High Court doesn't decide, then the stay will be vacated.
That was rectified.
Yes, so I filed a petition on behalf of the. So we have been trying to get these things rectified.
Right.
So I'm only saying, Lord, that
If errors are there, they are bound to be corrected.
yes. So these things, Lord, that will keep on happening, and as a part of the system. That, in my humble submission, Lord, is one that on account of the exclusive competence which Constitution has reposed, Lord, in the High Court, Lord, its discretion ought not to be curbed, at least not curbed drastically, Lord. Second, I submit, Lord, that there is so much divergence, so much variations, and it is dynamic. Whatever the Lordship will do tomorrow, rest assured, Lord, the Lordship will find that this one-to-one will never come across, Lord. This age gap disappearance will never happen. There will be this gap because of the fact, the manner in which the lawyers exercise their choice. So for all these reasons, please leave it to the High Court, Lord, at least with some minimal guidance, and that's my humble submission. I'm grateful. Volume 2, R1 is my main written submission.
Thank you.
Please, Your Lordships.
Yes.
Your Lordships, I appear for the Honorable High Court of Punjab and Haryana.
I wanted to get All India Judicial Service, which your Lordship mentioned.
Yes.
Would your lordship just look at Article 312?
This provision, Mr. Yogi?
Of course, All India Judicial Service is the best solution. I'm sorry,
This provision are you referring?
Article 312. I'm sorry.
No, High Court is willing for that.
No, I don't know whether Supreme Court will be willing, my lords, unless, my lord, we don't know. Just look at this. It's a very dangerous provision, my lords, introduced during emergency. And I'll be filing a PIL, my lords. Just look at it. This is surprising. It's on many basic features are being violated by this. Notwithstanding anything in Chapter 6 of Part 6 of Part 11 of the Council, if the Council of States has declared, see, only Rajya Sabha, by a resolution supported by not less than 2/3 of the members present and voting, that it is necessary or expedient in the national interest so to do, Parliament may by law provide for the creation of one or more All India services, including an All India Judicial Service. Note the number, my lords. 1976.
1976, yes.
317. Common to the Union and the states, and the subject to other provisions of this chapter, regulate the recruitment and the conditions of service of persons appointed to any such service. The services known at the commencement of this constitution shall be deemed to be services created by Parliament under this. We are not concerned. 3. The All India Judicial Service referred to in Clause 1 shall not include any post inferior to that of District Judge as defined in Article 236. So District Judge goes out of Chapter 6 if this happens. The rest remains. Now this is the most objectionable. The law providing for the creation of the All India Judicial Service aforesaid may contain such provisions for the amendment of Chapter 6 of Part 6 as may be necessary for giving effect to the provisions of that law, and no such law shall be deemed to be an amendment of this Constitution for the purposes. So now you bypass 368 and amend, my lord, Chapter 6, which has been held to be basic part of the basic feature and independence of judiciary. 368 itself is basic feature, that's also bypassed. And resolution is only of Rajya Sabha which is required. Of course, Parliament comes in later on.
Parliament comes to.
Yes, Parliament will make
the bill has to be by both the houses.
by ordinary laws. Just as the law was in
When they say.
fortunately, no party had 2/3 majority in Rajya Sabha, so that resolution is not coming.
So after the golden jubilee of that amendment, you want to challenge it?
Sorry.
Yes,
Please, Your Lordships. Your Lordships, I appear for Honorable High Court of Punjab and Haryana. I filed my written submissions, but before, my lords, they are short submissions. Before I take Your Lordships to the submissions, my lords, I would like Your Lordships to look at the rules very quickly, which, my lords, are at page 721, volume 4A. PDF 721, volume 4A. Your Lordships may kindly have page 723. I'm sorry.
723 of what, madam?
Of volume.
Volume 4A.
Roman 4A.
Soft copy uploaded. Is at PDF page 721.
My lords, it starts at 721. Your Lordships may kindly have at page 723.
Page 711, 713.
723, my lords, I would like to show Rule 7. PDF 723.
Yes. Method of appointment.
Yes, my lords. So, my lords, I am not reading the whole thing. Your
Yes,
Lordships
page
can see.
720. Volume 4 मिल गया?
Please, Your Lordship. Your Lordships, I'm not reading the whole rule. The percentage, my lords, is based on All India Judges Association's ratio, my lords. At that time, it was 65% by promotion, 10% by LDCE, and 25%, my lords, by direct recruitment. Now, my lords, of course, we are pursuant to the latest judgment, my lords, we are in the process of restoring 25%, my lords, to the LDCE. Then, Your Lordships may kindly have so I have seven subsection rules, sub-rule 4. Sub-rule 4. These posts shall be filled in accordance with the roster attached as Annexure B. I'll be taking Your Lordships through that roster. That, Your Lordships, thereafter Rule 8 is assessment of merit, because arguments were raised yesterday that there is no subjective assessment of merit, my lords, when for the promotees, when they are promoted. So, my lords, the rule says for assessing and testing the merit and the suitability of the member of Punjab Civil Services Judicial Branch for promotion under clauses of sub-rule of 3 of Rule 7 of these rules, the High Court may hold a written objective test of 75 marks and viva voice of 25 marks, and then take into consideration the ACR. So, my lords, this is the process for them. For the limited written competitive examination, Rule 9 applies, my lords, where there is a written examination which is much more elaborate and which is for 600 marks, and assessment of record 150 marks, and viva is for 250 marks. Then, Your Lordships, I'll request Your Lordships to have a look at Rule
It comes seniority recruitment.
Yes, my lords, I'm coming.
There is a written examination.
Yes, my lords, I'm coming. So Rule 12 deals with the seniority. And Your Lordships, the Rule 12 in crux says that the seniority after the appointment to the cadre from all sources will be as per the roster. That's what it says, my lords. And so it will be as per the roster 12D. The inter se seniority position of the officers appointed in the services under Rule 7 shall be as given in the roster annexed. Now, yes. Your Lordships, also 12 sub-rule 2, a person recruited to the service under clauses A, B, C by all the sources, my lords, 3 sources of Rule 7 shall take his position in the seniority list as shown in the roster attached as Annexure B, irrespective of the date on which he is actually joining the service. So, my lords, it's not the date of appointment, but it is the roster. Now, Your Lordships may kindly have the roster. Roster is, my lords, at page 730.
It has been introduced when?
My lords, these rules, my lords, they have been amended various times though, Your Lordships, but the rules are of 2007.
Rules are of 2007.
Yes,
but
my
when this rule was...
Roster is, my lords, after the All India Judges Association's second case, my lords.
This roster system has been introduced when?
2007, my lords.
By the order of.
Now,
2024. Rule 12 has been substituted by notification number so and so, dated 19th of August 2024.
No.
The footnote.
My lords, Rule 12 was amended post the judgment.
Substituted, yeah.
Yes, my lords, post the judgment. And that is why it says 2024. Only Rule 12. The rules have been there with effect from 2007. Now, Your Lordships may kindly have roster. My lords may kindly have roster, my lords, is at page 732. And that is under sub-rule 4 of Rule 7. So it has been prior to, since 2007 only. 732.
Your running page is 722.
732.
That's the PDF page.
Please, my lords, PDF page.
The running page which you have
Running
mentioned.
page is 722.
722.
Yes, my lords. I thought, my lords, PDF will be more convenient for your lords.
The running pages are there straight away. Why?
Please, your lords, I'll use. Now, your lordships may see there are first 3 points on the roster which go to promotees. The 4th point goes to the direct recruits. Then again 3 points, wave 5, 6, 7 go to the promotees. 8 goes to the direct recruit. then Milos 9, 10, 11, and Milos
10 goes
through the limited competitive examination.
That is because of the 10% trigger.
Yes, Milos. Because of the weightage, Milos. Because 65% promotees are there. So they have, that's why the roster starts with them. And Milos, only 10% limited departmental examination are there.
This will have to be changed now.
This will now be changed because your lordships have restored it to 25%. Now, your lordships, so these are the rules and this is the roster. And so, Milos, after the additional district judges are appointed by various three sources, my submission is that they lose their birthmark, they become one cadre, and their seniority is decided by the roster. I would humbly submit, Milos, that the roster has worked for us. Now, your lordships, I will show the data. Now, your lordships may see, and Milos, the apprehension of the learned amicus that promotees are lagging behind, both in terms of designation, elevation, and age, doesn't hold true, Milos, in our High Court. So, Milos, I will show the data. My submissions, Milos, my written submissions are there, Milos. I'll show two, Milos. I'll show my written submissions, and then I'll also show my reply affidavit. So, Milos,
Madam, you should be correct on record.
Please, Milos.
The roster has come into force only in 2024 after the decision of this court in relation to an interstate seniority dispute. The original rule 12 did not contemplate any roster system.
Milos, maybe we are wrong, but our instructions are that
you are wrong.
Please, Milos, your lordships would know better. Your lordships would know better, Milos. Milos, I can't contest that. I can't contest.
There's not any dispute on facts.
Yes, yes. So, Milos, may kindly see volume 2. Volume 2, Milos, the written submissions are there, and running page R2, Milos, volume 2 R2, and page number 1, Milos. Your lordship has it. So, your lordships, first is the issue framed by your lordships in your lordship's earlier order as to what should be the criteria for determining seniority in the higher judicial services. Then, Milos, I have reproduced the rules, etc. That I won't bother your lordships with. And at para 4, page 3, is the criteria for designation as the district judge from the cadre of additional district judge. So, your lordships, para 4, thereafter for the ADJs to be promoted and designated as district and session judge, the following criteria has been framed by the High Court. He has earned at least 2 good reports during the last 3 years preceding the year of his consideration. An officer with good record of service and whose latest grading is B+ or above shall only be entitled to be considered for designation as district and session judge. 3, he has not been assessed C below average during the last 5 years preceding the years of his consideration. 4, he has not been assessed C integrity doubtful during the last 10 years of his tenure in the superior judicial services. An officer undergoing punishment awarded by the full court shall not be considered for designation as district and session judge during currency of the punishment. The zone of consideration shall be 3 times the number of vacancies up to 5, and if the vacancies are more than 5, then twice the number of such vacancies, subject to the minimum of 15 officers in the later eventuality. The cases of additional district and session judge in the consideration zone be placed before the Honorable Screening Committee with a view to examine the suitability of the officers for designation as district and session judge before placing the same for consideration of honorable judges. Now, Milos, for the interstate seniority, Milos, besides the issue framed by your lordships, the apprehension of the learned amicus are, as expressed in his application, that promotees are lagging behind, or if they are being designated or elevated to the Honorable High Court also, the age that they get is they reach there very late. So, my lords, these are the, and the another, so therefore, my lords, it has been prayed by the learned amicus that para 29 of All India Judges Association, where the roster system vis-a-vis weightage was examined, and the recommendation of Shetty Commission regarding the weightage was not accepted, and what was accepted was roster on two grounds: that it gives to less disputes, it gives rise to the lesser disputes, lesser inter-seniority disputes, and it is a fairer method. And also, my lords, the Honorable Court relied upon the earlier judgments relating to other quotas, my lords, and said that those 40-point rosters have worked. So, my lords, these are the prayers that my learned friend is asking. Now, my lords, let us examine, my lords, our data in the light of, my lords, what has been submitted. So, my lords, may kindly have the running page 11 of my submissions, where I've given a table. If your lordship permits, I'll read para 14 along with the table, which is at page 10 bottom. Para 14 starts at page 10 bottom. Your lordships have it?
Yes.
Yes. So the state of Punjab and Haryana, the apprehension expressed in the state of Punjab and Haryana, the apprehension expressed by the learned amicus in the application does not exist, as the ratio of promotees and direct recruits promoted to the post of district and session judges 2:1 and 3:2. In the states of 2 is promotees, promotees versus vis-a-vis direct recruits. In the states of Punjab and Haryana, respectively, that the roster system appended in the service rules of the respective states itself ensures that the promotees who make up for the 75% of the superior judicial services have proportionate opportunity for promotion. Further, the data in the last 10 years shows that the ratio of promotees and direct recruits who have been elevated to High Court is 13:3. 13 promotees and 3 direct recruits, and 12:4 in the states of Punjab and Haryana, respectively. Detailed breakup of the data is as under. So, your lordships, in the table, these are the number of the judicial officers. This is total number, who form the ratio of promotees and direct recruitees of 5:1 entering the higher judicial services. So, promotees are 240 in number in Punjab, and direct recruits are 47 in Punjab. Similarly, in Haryana, promotees are 239, while there are 47 direct recruits. Similarly, on the next point, number of the judicial officers who form the ratio of 29:15 and 31:21 promoted to principal district judges. So the learned ADJs who have been promoted as district judges, they are 29 from amongst the promotees and 15 from amongst the direct recruits in Punjab, and 31 from amongst the promotees and 21 from amongst the direct recruits in Haryana. Then number of judicial officers who have been elevated to the High Court in the last 10 years are 16 in total in Punjab, out of which there are 13 promotees and there are 3 direct recruits. In Haryana, there are 12 promotees and 4 direct recruits. Now, your lordships, I am not taking your lordships through the Haryana rules because they are same. Now, your lordships may kindly also see I will request your lordships to have a look at my affidavit by Honorable High Court of Punjab and Haryana. Page. Volume 3, your lordships.
Volume 3.
Volume 3.
3A.
3A.
142. 1360. 1428.
Volume 3, 3A, 3A.1.
1428. Actually, we need to go to 1446. It starts at 1431, your lordships. I'm sorry. It starts at 1431. 31.
Just show me that.
It's an affidavit of one Mr. Jaspinder Singh.
3-1.
Yes, Mr. Your Lordships, along with this affidavit, we have also annexed the gradation and the seniority list of judges in the district judge cadre, and also, my lords, the ratio of judges promoted, which is the same, which I have taken your Lordships through it. So your Lordships may kindly have page 1433, and there is a table there in para 5. 1433. May I, your Lordships?
Running page 1421.
14, Milos, I'm requesting your Lordships to have a look at para 5, 1433.
Yes.
Yes, Milos. So,
Running page 1433.
Milos, running page is Milos
1433 is all right, yes.
Yes, Milos. Para 5. Deponent is placing on record the information sought in paragraph 5 of the application. So the gradation seniority list of judges in the district judge cadre, I have annexed as annexure R1 for Punjab and annexure R2 for Haryana. Then the ratio, Milos, I have already taken your Lordships through in my submissions, is 5:1 total ratio of the total promotees and direct recruits. And then, Milos, the average age of judges promoted through the civil judge cadre as compared to the direct recruits in the district judge cadre. So promotee officers, the average age is 46 years, and direct recruits is 40 years in Punjab. And Milos, in Haryana, it is 43 vis-a-vis 1. 43 for promotees and direct recruits 41 years. Then Milos, ratio of promoted district judges and direct recruits who have been appointed as principal district judges, 29:15, 31:12. This I mentioned in my submissions also. Now, Milos, my submissions are that my learned friends, my learned amicus prayers, that para 29 of the All India Judges Association, wherein, Milos, the Shetty Commission's recommendation regarding the weightage was rejected and roster was accepted, should be modified, or in the alternative, 50:50 or 1:1 should be done. Milos, my submission is that once, Milos, all the officers are appointed as additional district judges from these three sources, then they lose their birthmark. And Milos, they become one cadre and they are all equal. So equals should be treated as equal and there should not be any quota provided. This submission is, Milos, dehors the fact that in the data of the Honorable High Court of Punjab and Haryana, in fact, Milos, promotees are more than the district direct recruits, both in the cases of Milos elevation to the Honorable High Court and also Milos as having been Milos designated as district judges. So on both the counts, promotees are more. But despite that, Milos, in law, Milos, my submission is that Roshan Lal Tandon, I squarely applies to my case, and your Lordships are very well aware, I'm not reading it. And so, Milos, therein also the birthmark is lost. They are all one cadre, they all must be treated equally. The other judgment is, Milos, Atul Shukla, I mentioned all these judgments in my submissions, wherein, Milos, the different age of superannuation was provided for two sets, depending upon the source they came from. So, Milos, therein also it was held that they are all equal and they must be treated as equal. Milos, I'm sorry, I may be wrong, but we called the High Court and the instructions that we got was that the roster has been under Milos in operation since 2007. Milos, subject to correction, these are our instructions, Milos.
Not in Rule 12, it was in Rule 7.
Rule 7, because Rule 7 says the seniority will be as per the roster.
But you are referring to 12.
Rule 7.
Rule 12, it has been introduced in 2024.
Because 12 was later on amended.
7 only pertaining to the determination of ratio in recruitment, where most was there.
Your Lordship's roster is also there in Rule 7.
You are right.
And seniority, in relation to seniority.
Seniority rule is.
Your Lordships, may I read may I read?
12 has been amended only in 24.
12 is amended in 24. Your Lordships is right. And my Lords, may kindly have Rule 7 once more, my Lords. Your Lordships may have 7, sub-rule 1, sub-rule 4, Your Lordships. These posts shall be filled in accordance with, it doesn't use the word seniority, they shall be filled in accordance with the roster attached as Appendix B. But my Lords, our instructions are that after these appointments were made through different 3 sources, they have been placed in these sources, in this roster for the purpose of seniority since 2007. So all this data, my Lords, I have given. My instructions, my Lords, are that this data is the result of the roster system. And so therefore, my Lords, the roster system has proved to be successful in the Honorable High Court of Punjab and Haryana. And my Lords, there is no such discrimination, both in terms of age or designation as district judges or, my Lords, this elevation to the High Court. And Your Lordships, there is one more chart which I would like Your Lordships to see. This is, my Lords, in the last 10 years. We also wanted to test it, my Lords, independently. So we called for this. In the last 10 years, my Lords, this is the data for with effect from 15 to 2025.
Of elevation.
Please, my Lords. Of elevation to the High Court. Total judicial officers elevated as honorable judges, 16, 13 promotee officers in Punjab and 3 direct recruits. And average age on elevation was promotee officers 57 years and direct recruits 55 years. Because I would say, Milos, it can't be exact.
Up to which date?
Milos, this is up to 1/1/2000, from 1/1/2015 till date.
Till date?
Till date.
So in 10 years, only 16 judicial officers have been.
13 plus 3, 16, Milos. Only 16.
I think the last college we have.
Milos, in between there was COVID years also.
32.
Milos, 3 years were COVID years.
3 years were COVID years.
3 years were COVID years.
Can't be only 32 in 10 years.
1/3 of the sanction stream, that is 90. 90 ka 30.
No, High Court judges.
94 is Punjab, Haryana.
Milos, I have.
1/3, so 30.
In 2020, there was no appointment. Milos, in 2000.
Average.
In 2020 and in 2022, during the COVID years, there were no appointments under either of the quotas.
Yes.
And Milos, may kindly see the last thing. The average age is 57 vis-a-vis 55 in promotee and direct recruits in Punjab. And Haryana, it is 57 and 56. So, Your Lordships, with this, Milos, I end, Milos, by saying, Milos, that as far as Punjab, Haryana and Haryana High Court is concerned, the roster has worked, and Milos, the apprehensions of the learned amicus, Milos, have no basis. Oblige you.
Thanks.
Best argument should have been.
May it please your Lordships. Lordship, to put in a nutshell, I appear for direct recruitees in IA 251959 of 25, 251959 of 25. They are some direct recruitees from Kerala, and IA 270501 of 25, some direct recruitees from Bihar.
Yes.
On behalf of these direct recruitees, my lord, my humble submission would be, it's not necessary to disturb on an all India basis the rules that are framed, which are enforced. That would be my ultimate submission. There is no requirement of a change of rules, would be my humble submission before your lord. I'll quickly refer to the reasons for which I say this. Right at the beginning, my lord, I would like your lordships to see right through in the Indian judiciary, we have accepted that lateral induction of members from the bar at higher levels is required and necessary for the health of the institution. I would request that we do not look at it, my lord, from the point of view of some individuals who have been denied promotion or getting promotion. Maybe we'll have to look at it from the point of view of the health of the system. That will be the proper way to look at it. Not a trade union type of an approach where each person says, I did not get it, I did not get it. But the point should be what would contribute to the health of the system as envisaged under the Indian judicial system. For which I would like to bring to your lordship's notice observations in Dheeraj Murray, two places, my lord, where the advantage of having members from the bar recruited at higher levels is recognized. Can I take your lordship through that, my lord? 2027 SCC 401, para 29, 85 and 87 would be the relevance. Giving it.
5B, first part, 5B to 5B, not A to B2, B2, B2. There's no B, A and R. R2, 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 B2.
B नहीं है, A and R.
No.
R1? Volume. Volume 1 is R1, is it?
Page 140, 140.
No more a good law.
No, it may not be good law. I'm not trying to follow anything that is laid down there. Observation as to why lateral induction of members from the bar is relevant.
That is there in Shetty Commission itself in 2002. The Shetty Commission itself recognizes.
The reasons are perhaps stated more clearly here. That's why I wanted to just bring to your lordship's notice that aspect. The
volume.
Para 29.
R1. Please inform the correct volume.
Nobody disputes that the lateral entry has been provided in order to enhance the efficiency of administration.
Right. That's what I wanted to point out to your lordship. And
that is found in 2002 also.
That's why I said, right from the beginning, right from the very early days, decades earlier, we have accepted this principle of get all the volume correctly, so that this much of time should not be taken. Can I go on, my lord? Lordship has got it. Paragraph 29 and 87. I would read 87 because that should be enough. 87. The constitution makers, in the opinion of this court, conscious.
Paragraph?
87.
87.
Yes. 29 also similar observations are there. I'll be satisfied by reading to 87. The constitution makers, para 87.
205.
205.
20?
PDF page 208.
Yes.
Yes.
The constitution makers, in the opinion of this court, consciously wish that members of the bar should be considered for appointment at all the three levels, that is, district judges, high court, and this court. This was because counsel practicing in the law courts have a direct link with the people who need their services. Their views about the functioning of the courts is a constant dynamic. Similarly, their views based on the experience gained at the bar injects the judicial brand with fresh perspectives, uniquely positioned as a professional, an advocate, as a tripartite relationship, one with the public, the second with the court, and the third with her or his client. A counsel learned in the law has an obligation as an officer of the court, to advance the cause of his client in a fair manner and assist the court. Being members of the legal profession, advocates are also considered to be thought leaders. Therefore, the constitution makers envisage that that every rung of the judicial system, a component of direct appointment from members of the bar, should be resorted to. For these reasons, it's held. The point that I want to urge before your lordship is.
Read further.
You want.
Read the next sentence.
Oh, please, my lord.
For all these reasons.
It's held that members of the judicial service of any state cannot claim to be appointed for vacancies in the cadre of district judges in the quota earmarked for appointment from amongst the eligible. That's gone. That's gone.
This is overruled.
That's gone, my lord. There's no doubt about it. The point is, why?
So therefore, the best judgment on which you should have relied on ought to have been 2002, which still holds the field.
Right, my lord. The latest one, why I rely on that.
This one is the one which is overruled.
Lord, overruled on the question whether they can gain entry as a direct recruitee. That is all that is there.
No doubt with regard to the proposition that the lateral entry is provided in order to infuse efficiency in the administration of justice.
I'm only on that point, my lord, because this lateral entry people should also be not frustrated, must be properly looked after. And that's the point that I'm trying to make before your lordship, that the grievance of the other section promotees cannot be looked at it in isolation. For the health of the system, it's very important that people directly recruited also have avenues. They also have career progression, which is assured.
Nobody doubts about that.
Yes.
Nobody doubts about that proposition.
My lord, next submission would be if the type of
weightage. The question is whether only their aspirations have to be looked into,
no, that's not
or the aspirations of all.
Exactly what I'm saying. Not the aspirations of the other side alone. This side also has to be looked
There's
into.
no dispute on that proposition.
Right, my lord. Very evident, my lord. Both have to be looked into. Is my yes.
So that's what we are saying from the beginning. That's what we are saying from the beginning, that aspirations of all have to be
right. I will be
proper perspective.
I will be trying to show before your lordship. I will be trying to show before your lordship.
Nobody disputes. At least neither of five of us dispute that proposition.
Nobody disputes. But my point is,
neither promotee is not direct recruiter.
We should not. That is, in the interest of the promotees, the interest of the direct recruitees cannot be compromised. Is the humble submission that I'm trying to make before your lordship. Right? That's clear. My lord, the next point that I want to make is, when an integrated cadre is made of two sources from two
they lose their birthmark.
Yes, they lose their birthmark. I would rely on three decisions on this point, my lord. Roshanlal Tandon versus Union. I'm not going to take your lordship through that. Roshanlal, then Triloki, and a 7-judge bench in Davinder Singh. I want your lordship to see that. That is at page, paragraph 93, volume R2.
Same volume, page 230. We have raised to 30. Huh?
152. Para ECC.
93.
97, 87.
Para 93.
Yes.
Yes.
155 is the patient. 753 is the patient.
Para 93 is not presenting the entries.
This para?
Para 93 in the SCC para 93.
This is the Punjab judgment.
Yes. Yes.
The classification.
I'm not taking a lot through all the detailed discussions, my lord.
Para 97.
93. No, it starts with Nakara, principle is stated.
Yes.
Yes. I invite your lordship's attention to the statement of the law there. Thus, a class which is not similarly situated for the purpose of law can be further classified. The test that the court must follow to determine the validity of subclassification of a class is as follows. That is the point that I wanted to point out here. Now there is a classification as district judges, the common cadre. Can there be a subclassification? Under what circumstances it can be? That's what I'm trying to point out there. Now the test is whether the class is homogeneous or similarly situated for the purpose of the specific law. If the answer to A above is in the affirmative, the class cannot be subclassified. If the answer to A is in the negative, the class can be subclassified. My humble submission would be the cadre is homogeneous, similarly situated persons, and therefore.
You read those things. Further, the class can be subclassified upon the fulfillment of the following standards.
Yeah. If that is, if the answer to the first portion is no, then only that comes. The
difficulty is that the judgments have to be read as a whole.
It has to be, my lord.
Not once.
Ultimately,
the practice here is that one sentence is here and there are pointed out.
Ultimately, the law is laid down by them in these lines.
So therefore, you have to read C also.
Yes, see. If the answer A above is in the negative, the class can be subclassified. The submission is it can, there can be a yardstick of intelligible differentia further classifying the class, and the yardstick must have normal nexus with the object of the. Now here, if it is homogeneous and they are similarly situated, there is no question of a further classification. That's the point that I'm trying to urge for your action. In this case, all of them are from different streams have come into the common cadre, and having come to the common cadre, on the basis of the streams from which they came, you cannot make a subclassification. That's what.
After Sangam, there it's Ganga.
You know?
After Sangam, it is Ganga.
Right.
There
cannot be a further classification of a homogeneous and similarly situated group is a submission that I make.
With due respect, that is not entirely correct because Ganga flows into the delta which comprises of both Brahmaputra and Ganga.
Okay.
So that's the further classification.
Okay, we are only here. Your Lordship, and my point is when the integrated cadre.
That's what which Acharya also argued that once you enter a cadre, then the birthmark is lost and you are
everything.
Right. That is very clearly stated in Triloky also, Miller. When they come from two different sources, when they merge into one and the common category comes, thereafter your birthmark is lost and there cannot be a distinction on the basis of the source from which we came. Here, distinction is attempted to be made on the basis of the source from which we came because the argument is they have service in the judiciary and therefore they can be distinguished or further classified appears to be the argument that's there. Your Lordship, and it cannot be because look at the other side, my Lord. Later on, you cannot say for every 5 years of practice you will get one weightage. You cannot say that obviously. Just as you can't say when the integrated cadre comes, you cannot later on contend that I came from the judiciary and therefore 5 years of weightage or a quota for a promotion. And the other side can also, the ridiculous nature of that argument can be seen from the fact, supposing the member of the bar were to argue that I have come from the bar and therefore 5 years I must get a weightage.
But this court has done that for pensionable services of the High Court judges. It has said that the judges coming from the bar, they will be entitled to 10 years additional for getting the pension.
That is, Your Lordship is referring to the service in the bar to be counted.
Justice Sadashivan's judgment.
That is for the purpose of pension. That's for the purpose of pension, it's mentioned, yes. Yeah, my humble submission would be, when they come from different sources and merge into one source, integrated cadre, similarly situated cadre, thereafter, you can't make a distinction based on the birthmark that where you came from. Other considerations can happen. Last time, my lord was putting the question, supposing there is a better educational qualification, that would be a different situation altogether. All the decisions holding otherwise would only say that it's a different criteria, not the source from which you came. When the source from which you came cannot be the basis for distinguishing or discriminating between the two different groups. And therefore, it would be my submission, my lord, it's not possible for us to, on the basis or the length of service that one has at the bar or the other at the bench, as a judicial officer, to further subclassify them on the basis of their birthmark, on the basis of the source from which they came. The next question is, I think just Mr. Dwivedi has already adverted to that aspect. I'll just mention it. What is the basis for this? Why do they want this to be further restrictions or improvements to be made to the rule? There are only two things that are stated. One, that there is bunching of direct recruitees on the top. That appears to be one argument. There is bunching of direct recruitees at the top, and the second is the age difference. These are the 2 points on which they are. My lord, bunching is a phenomena which has arisen because of not making the selections promptly. It's a matter of the past. After Malik Mazhar decision, there cannot be. We need only enforce the law. We need only enforce the directions in Malik Mazhar. Every year, the selection has to be conducted, and every year, everything is mentioned. Can I invite your lordship's attention to Malik Mazhar also, my lord, please?
Page number 483. What is 5A? With 5A. It's A1.
5A.
Your lordships are aware of this. I just want to particularly point out here.
5A. Roman 5, capital A. Page number, previous page 487, otherwise 483.
Paragraph 7. Have a look at paragraph 7. I'll take your lordship to 7A and B. We direct us here under
487.
My lords have got it. Can you see, my lord, that A is with regard to direct recruitees. and B is in respect of recruitment by promotion, 50%. Kindly see, my lord, the number of vacancies is to be ascertained by 31st March in both cases, A and B. Or the dates on which examinations are to be conducted, everything is mentioned, and ultimately the orders have to be passed, issue appointment order by 30th September in both cases. What I'm trying to point out before your lordship is, now this has to be followed. We need only insist that this must be followed. No change of the rules is required. If there is human failure regarding compliance with these, we have to correct that. Now, if that happens, your lordship finds, every year we will have both categories of people ready for absorption to the common cadre, and there will be no bunching as it is now alleged. Now, your lordship will go, if you go through the seniority list, you will find number of direct recruitees are bunched together. This happens because both in Bihar as also in Kerala at times, this happens because in due time, the selection do not take place, which malady is not there now. If Malik Bazar is followed, there can be no question of bunching at all. There is no question of selection for various years being bunched together and the direct recruitees or the promotees coming in one lot occupying the entire position. So that what my submission before your lordship would be that in the light of Malik Mazhar, there is no possibility now, except in violation of that judgment, of any bunching together. And therefore, the possibility that the promotees will have to wait until the entire list of direct recruitees are exhausted is a story of the past. It will not anymore be there. To counter that or to provide against that, it is not necessary for us to amend the rules. That is what I will have to submit before you.
But the other side of this very principle will be that in light of now Mazhar Malik, that every High Court is obligated to hold the annual examination and go for annual recruitment process. Where is the necessity of assigning roster points for the purpose of seniority?
I'll come to that. That's the next point that I have to make. The lordship point, so that what I'm saying, we know from the both streams, we have people selected, appointed also.
It's an annual feature.
Right.
Annual feature.
Right, annual feature.
Both recruitments will never take place together because the examination is different.
Exactly.
Merit cum seniority criteria is altogether different than direct recruit.
Right.
Direct recruit is normally different than the LDCE.
Right.
Therefore, all three will be different selection processes.
Right. From each stream, the persons to be appointed are selected. Right. From each stream, person to be appointed are selected. Now the question is, how do you appoint? Supposing 3 persons are selected from one stream, do you appoint all of them together on top? Supposing 5 persons promotees are selected, do you appoint all of them together at the top? That is where the principle of roster comes from. The principle of roster comes so that you may have selected people from various sources. They will not together join the mainstream. That is where the roster becomes important. Your Lordship, I found such a lot of grievances against the roster. I believe the roster is something which ought to be accepted gracefully, because what it seeks to prevent is, again, bunching of selectees from one particular stream for one particular year together. To avoid that, what is said is, there shall be a roster. Now, it is referred to as a 40-point roster. I am unable to understand how the 40-point comes.
What is the genesis or the history of introducing roster? Was it not essentially meant only to ensure the representation for the constitutionally provided reservations, which were unfortunately being overlooked and ignored by most of the states throughout the country?
Right. Now, whatever may have been the historic reasons that the roster came into existence, here the purpose I explained to my lords. Now, all the 3 streams people are selected. Now, my lord's decision in All India Judges case, 50% to one, 25% to one, 25% to the other. If all the 50% together are appointed on top, that would work out injustice. And therefore, my lord said,
a direct recruit is appointed in January and a promotee comes in December of that very year. What is wrong if that December appointee ranks junior to the January appointee?
Well, I would say all the appointments are to take place together. If you follow Malik Mazhar, all the appointments are to take place.
If it is only when you have a ready-made list of the direct recruits, you have a ready-made list of LDCE, you have also a list of the promotees, and you are to give appointment to them all together. They are entering the cadre together.
Right.
There the question of, you may be right, that how to place them in bulk at one place than another, that may arise.
Right.
That if the appointments are at different points of time, then where is the,
Lord,
under which law there is a compulsion of
my humble submission would be, after Malik Mazhar, there is no question of appointments being at different points of time. That's why it took a lordship to Malik Mazhar. Malik Mazhar, from the date of publication to date of appointment, is the same date. And therefore, appointments will be made on the same date. And while making that appointment...
To what extent it is followed?
No, my lord, if it is not followed, it's for us to enforce that and not change the rules for that. With great respect.
Issue contempt notice to the High Courts.
Yes, madam.
Issue contempt notice to the High Courts.
Now, your lordship, whatever, I don't think the High Court would be interested in violating the directions of this court. The possibility of violation should not persuade us to amend the rules. That's what I'm submitting. What are we worried about? We have issued specific directions in Malik Mazhar specifying the date on which the appointments should be made. All three lists must be ready on one particular day. And for that, the court very gracefully said, don't appoint them, bunch them together to follow the roster. That's what it said. Your lordship, and that's all that is said. They said the 40-point roster, I think the 40-point is a misnomer, 40-point will not be there. It will be only, as of now, 50% to one, 25% to one, 25% to the other. So at worst, at best, it can only be a 4-point roster.
For according to you, an annual roster is the ideal answer to this situation.
Right. It is the answer, not my suggestion. That is what Malik Mazhar says. That is what para 29 of All India Judges case decision says when it said roster. But it said 40-point roster. I'm not able to understand how the 40-point roster would come in because there are only three sources. Two for promotees, one for direct recruiting, one for LCD. And then therefore LDC, and therefore there is no question of a 40-point roster. Many of the high courts have said 4 plus 4 plus 4 plus 4 made it 40. It's not necessary. It's a 4-point roster. According to me, it's only a 4-point roster. And then your lordship finds ideally, I would suggest what should happen is the promotees, they having been in service, give them the first 1, 2, and then 3, the LDC, and the 4th, the direct recruitee. And therefore, there is no chance of people being bunched together to deny the legitimate aspirations of those coming lower. This is what para 29, which when it spoke of the roster said, though I must confess the 40-point roster usage of that expression does not appear to be very correct. 40-point roster would come only where the constitutional reservations come. Here, a roster. Read the 40-point roster as only a roster. And in that roster, the purpose of the roster is very evident. Don't bunch people together in one. You give them this 2 plus 1 plus 1. That is the purpose. And if that is followed, my respectful submission will be all the assumed difficulties, imbalances that are there will vanish. And as pointed out by the Allahabad High Court, it is vanishing also. It's not necessary to do that now. It's already done. It's already done. It's being followed. I'll take a lordship the Kerala rules and again try to convince your lordship on that. Your lordship, and therefore, what is required is the 40-point roster will now be, because there was one 10%, 65% and 25%, there was some confusion. Right now, after the last judgment by this court, all that is required is it has to be promotee 1, promotee 2, LDC 3, and direct recruitee 4. As simple as that.
Yes.
For this, is it necessary to amend the rules is a question I would request my lords to consider, and my humble submission will be kindly do not do that. It's not necessary at all. Right.
Thank you.
No. Sorry. I'll complete now. Your lordship finds the other aspect has also been urged. Now, your lordship finds the question is today the fact scenario is very, very different. Direct recruitee 25% also these people can get in. LDCE, your
That
lordship.
is already argued, Mr. Singh.
Yeah,
There's no point in again repeating the same argument.
Right, I just want your lordship to be reminded of that because.
So that has been argued time and again that now the dynamics have changed. Mr. Dwivedi also has argued that.
That's what I said. I accept what this, Mr. Dwivedi submitted on that. Now, your lordship finds. Now the next question is, my lord, from the entry grade district judges, when they go to the next higher of the selection grade and the super time scale, what happens? That's the next point. The lordship can kindly have a look at the Kerala rules. The Kerala rules from the entry grade to the selection grade, it is only merit. It's only merit. I want to read your lordship the rules. If at all any rules are to be maintained, identical rules on the Kerala pattern has to be maintained, made elsewhere. It is only, please see that, rule 2.2. It is what is submitted by the Kerala High Court, isn't it? I can read, yes. Your lordship, it says, it speaks like this, madam. Appointment to 35% selection grade posts in the service shall be made by the High Court with effect from the 1st January 2020 from amongst the members of the service on the basis of, now comes it, merit and ability, seniority being considered only when merit and ability are equal.
But that is broadly same criteria everywhere.
No, yeah.
Merit is the first emphasis.
Yeah.
Seniority only determines the zone of consideration.
Right.
Rest is the ability and suitability.
Your lordship, from all the next, I wanted to read the next line also.
That's why
Next,
Maninder Acharya points out.
Only approved probationers with 5 years service shall be eligible for being considered for promotion. So that whoever has completed 5 years is eligible to be considered. Forget about where you come from, which stream, all of them are eligible.
Mr. Basan, we don't think that there is a single High Court having criteria of seniority cum merit or seniority cum fitness or seniority cum suitability. Every High Court has merit, then come maybe ability, maybe seniority, maybe suitability, maybe anything. But first emphasis is on merit. So selection in promotion quota has to be there purely on the basis of merit. Seniority will be only for the limited purpose of identifying the zone of consideration. That's all.
Right. My humble submission would be, and therefore the grievance that we are lower in the seniority list is not going to affect your movement upwards to the selection grade or thereafter. That's what I'm trying to point out. So that your lordship finds, well, how it is being enforced, your lordship may clarify that it has to be purely on the basis of merit. And pursuit of excellence is an axiom under 51A or the fundamental duties also. And therefore, your lordship finds, in the light of the rules that we have in Kerala, which identical rules, if your lordship wants, the others can be asked to, and it can be directed that strictly this movement from entry point district judge to selection grade shall be only on the basis of merit. And therefore, what happens is the question of seniority lapses into insignificance. You don't have to upset the seniority for this purpose. They would still be on top if they have merit and ability. So that where is the need to amend the rules to accommodate something which is already there? If they are good, if they are meritorious, they come up. There are many sources by which they can become the entry cadre district judge. From the entry cadre to the next higher level, selection grade, it is going to be only on merit, and therefore your seniority does not matter at all. And therefore, to give you a position in there, it's not necessary to amend the rules at all.
Yes. What next?
Yes.
That's all.
Now, the same position relating to movement from selection grade to the next grade also. That is the super time scale. Right. Now, my lord, can I take your lordship through the Kerala rules one? The Kerala High Court's affidavit. Please see that affidavit, my lord. What is the position in Kerala? Is it necessary to invoke the 142 powers to interfere with something that is happening in Kerala? Yeah.
As my learned brother pointed out, that we are not considering state-wise position.
No.
Not considering state-wise position.
No, I want to point out that if no amendment to the rules is required, the rules presently in force is sufficient. Now, if at all your lordship feels it is necessary, extend this rule to other places is what my humble submission would be. Your lordship finds an amendment to the rule to provide quota, amendment to the rule to provide weightage is not necessary at all, and maintenance of separate seniority lists are not necessary at all, because the malady which we are trying to cure, the solution is already there.
In the Kerala rules.
Yes.
So you want the Kerala rules to be model rules to be followed by all these?
Now, my lord, if your lordship feels that such a clarification will be given so far as the others are concerned, please do that. Please do that. Please make it clear that the seniority shall be on the basis of the order of appointment. Now, the order of appointment will get posted according to the roster. And now thereafter, the promotion from there will be not on the basis of the seniority at all, but purely on merit. And if that is so, there can be no grievance. Now, we don't want to promote somebody who is not meritorious and go to the selection grade. Only those who are meritorious must go in. Your lordship finds the want of merit cannot be used as an excuse to go up the ladder. Because your lordship finds from the entry cadre promotee district judges, your lordship finds what will happen is all of them, all the entry cadre, they are people who have not qualified for, they have not come for direct recruitee as per the last decision. They are people who have not succeeded in the LDCE. For them, who have not got into the selection grade, for them to protect their interest, please don't think of an amendment to the rule. It's not necessary at all.
You have understood. You understood.
Yes.
Thank you.
No, just one. I just wanted your lordship to see the Kerala situation as reported by the High Court. Will your lordship kindly see paragraph 7 of the Kerala High Court's affidavit?
Mr. Giri has already pointed that out.
Yeah.
I read out the affidavit.
Yeah, he has read out the affidavit.
Now, what is of importance is, my lord, the statistics given there shows out of 30.
So that was read to us yesterday by Mr. Giri.
Yes. 18.
He has already read it to us, his affidavit.
Right. I just wanted to bring it to your lordship notice again so that it stays with your lordship, because it is important so far as the Kerala rules are concerned. They do not result in the apprehensions which are aired by the amicus. That is what I want to point out.
So that is already pointed out to us by the learned senior counsel appearing on behalf of the High Court of Kerala.
High Court, unfortunately did not take a specific stand as to whether this should be there or that should be there.
Rightly, because the High Court can't.
High
Court can't, but
what is
actual position was pointed out by the counsel.
What is just and fair? The High Court must have the guts to.
How could the High Court afford to take a particular stand that they are promoting? They are supporting promoters or they are supporting direct?
I will not say that, but it is up to the High Court to take a stand on what is fair and just. We can't avoid that. We can't avoid that responsibility. And that's for the High Court to point out to the court, as they have done in this, and analyze and show that the apprehensions of the amicus are non-existent in Kerala. That is what I wanted to point out.
Yes, thank you, Mr. Basu. Thank you. Who is next?
I am also in the same application, though my sequence is in the end, Milon. I may be
So
also.
in one eye only one counsel can argue. So your name is there in some other eye.
I just wanted to apprise this court that I am in the sequence in the end, Milon, though I am also representing few of the direct committee, the same application.
So
insofar
as one application is concerned, only one senior counsel can argue.
I am also there. Therefore, yesterday I said I am with him, Milon.
Okay,
That's what I said yesterday.
Your presence is marked.
Yeah.
What has happened is, my lord, there were 7 applicants. I continue with 4. 3 have gone to others.
That's the reason I said.
That's why he is coming out. 7 applicants originally.
You are not appearing for anybody from Punjab and Haryana.
No, Lord. For the timing, I am.
And
South only, Lord, not so far.
So South has been.
I'm trying to, Lord.
That's all.
Thank you, Lord.
Yes,
May it please, Lord. Lord, I am appearing in IA number 260414 of 2025 for the direct recruits in Delhi. Now, my Lord, I have 3 or 4 submissions to make. I adopt what has already.
You have also shifted venue.
No, my Lord, actually, Actually, by the time the Punjab people came, I had already appeared for Delhi, so I could not appear for the other side in Punjab. But what I'm submitting, I'm going to submit, I'm adopting what Mr. Dwivedi said and what has been argued earlier. But I have 2 or 3 particular submissions to make on one argument address whether weightage of any sort is necessary to be granted or not. Second, on the roster system, which according to me is a very good system. It has not failed, but it has not been given a chance to operate properly. And my third submission is going to be on the quota, which cannot be granted. Much has been said. I just want to refer to 2 paragraphs. But before I come to that, Manoj, please have my written submission, just 2-3 paragraphs to show that Delhi actually presents the other end of the spectrum, as which the learned amicus pointed to your lordships. It is volume 2, R1, page 1 to 9. 1 to 19.
So then what is the reason? If certain states, it's dominated by promotee, and if it's certain high courts, it is dominated by directs, then some rationalization would be in your benefit.
So my submission is going to be, my lord, that the 2002 judgment in para 30, while rejecting the argument of weightage, introduced a concept of roster. And para 30 weightage is rejected by saying roster will take care of it. Now, unfortunately, in the working of the roster, there have been 1 or 2 problems. And the main problem is the delay in the selection process of the direct recruits. On account of the delay in the selection process of the direct recruits, this roster could not work properly, because what then happens and what has been following from your lordships is promotee comes in, say, year 2007. Process of direct recruitment also commenced in 2007. It is completed in 2009. By the time the direct recruit comes and then makes a claim that I should be given a seniority from 2007, it perhaps becomes a little too late in the day for it to be granted. And then your lordship's judgments have also leaned in favor of length of service. This is what happened in Delhi, in B.S. Mathur and the 2 earlier judgments, even though the rules had rota quota, but because of delay in direct recruitments, the court ultimately said, no, let it be length of service. But all that, I'm just wanting 5 minutes before that, please have this volume 2, R1, page 1 to 19. Now, kindly have first internal page will be 2 and running page will be 4. There is a para 6. Your lordship got factual position in Delhi is just 2-3 paras. I'm not going to dwell much on. The factual position in Delhi is that promotees far outnumber the direct recruits in the post of principal district judge, since out of 12 posts of principal district judges, 9 were promotees and 2 were direct recruits. Please turn over the next page, my lord. This first column is direct and then promotee. So there are 4 direct in 2022, 7 promotees. And if your lordship will go down the chart, my lord, in January 25, there was no direct principal district judge. And now there are 2 and 9 are promotees. Now, please have para 7. The factual position in Delhi is also that during the period 20 to 25, 17 judges from the district judiciary were elevated to the Honorable High Court of Delhi, out of which 15 were promotees and only 2 were direct recruits. Then, my lord, we have said the situation in some other state also remains the same. Of course, your lordship has a much better chart given by the amicus, which Mr. Dwivedi read. Those 13 states, I don't need to read it again. He has given that better chart. Now, my lord, as so far as age is concerned also, if your lordship will come to page 6, running page 6, para 10. The factual position is that the average age at the time of appointment as district judges for both promotees and direct recruits is similar. The average age of appointment of both direct recruits and promotees is in the range of 40 to 41 years. There are instances of promotees being appointed even before the age of 35. We have 3 such people who were 34 years and plus when they became. There are numerous instances of promotees becoming district judges between 35 to 38 and 38 to 40. Then, my lord, I will not read the whole of it. So, age also is the same in Delhi. Average age is 40 versus 40.6. So, promotees are negative by 6 months only. and I have that chart. I will give it to your lordships, my lord, but your lordship may take it. Now, we have said in some other states also, the position remains the same. So far as Delhi is concerned, the promotees actually are taking a larger share, both at the stage of principal district judge and also at the stage of High Court. Now, one other point which I want to point out is at page, because this will then, in the course of arguments, I will be referring to these facts, page 16 running, page 14 internal, para 28. In fact, if I can start from page 13 internal.
Paragraph?
Para 27, that fresh para, last 3 lines at the bottom. It is submitted that whereas appointment of direct recruits against vacancies for a particular year is delayed due to administrative process, on an average, the process takes 2 to 4 years. However, promotees are appointed speedily upon arising of vacancies. Now, here that roster will come, and what my lords were, Justice Suryakant had also observed, that will it be yearly? Why should they get the slots? There are rational answers to that, my lord. I will attempt to give them to your lordships just after I finish reading this. Now, promotees are appointed speedily. As a result, between the period from arising of vacancies and initiation of the recruitment process for direct recruits to the eventual appointment of the direct recruits, several batches of promotees get appointed. In such situation, the application of the rule for determining seniority from date of appointment works in a manner which is grossly unjust and unfair to the direct recruits. Now, we have given instances, my lord, the recruitment notice of Delhi, which was issued in December 13, the left-hand side column, final result is declared in July 15, and direct recruit is appointed in September. In the meantime, in the year 13 itself, 52 promotees came and joined. This is page 14 internal, my lord, in the chart. Yes. Now, similarly is the position every year. Now, in the 15 recruitment, the result is declared in 17, and the direct recruits come in May 2018. And during this time, 47 officers are promoted from 16-17. And then, my lord, in 17 again, direct recruitment, final result is issued in 2020, and direct recruits are appointed in 21, and 87 officers are promoted during this period from 17 to 20. So that is one problem. Now, my lord, in my respectful submission, this problem can be solved if there is proper and honest implementation of the roster system. Now, one of the most important requirements of the roster to operate is a yearly recruitment of 3 sources. If there is no yearly recruitment of 3 sources, then the implementation of the roster is bound to cause practical difficulties and problems. Therefore, in Malik Mazhar, your lordships had actually laid down a time schedule as to when the recruitment is to be made. And if that time schedule is adhered to and the recruitment is made in all sources, from all sources within the year, then in my respectful submission, the roster will operate and the roster will fully satisfy the aspirations of all the 3 batches. Now, 2 or 3 more things. First, your lordship said, how would the roster operate? Since the percentages for direct recruitment, promotees and merit promotees is to be worked out on cadre strength, the roster has to operate on cadre strength and cannot operate on vacancies. This is clearly stated in para 29 of the 2002 judgment. It is also clearly stated in Sabharwal, on which para 29 relies on. I have only half an hour, Lord. I will put all this in a small note, and because this is over yesterday, I have improved a lot of things. So the roster firstly has to operate on posts. Now, Sabharwal says that when you start the roster, every roster says 211, 211, 211. Now, when you start the roster, initially, obviously, the entire cadre is available to you, and then you start and you proceed. Now, the second point is, why should the persons be fitted at the roster point, at the slots? That is very important. Because once you fit the persons at the slots assigned to each category, every category will then get a representation in every 4 slots in the cadre. There will be no bunching. You will have 2 promotees, 1 direct, 1 limited in every 4 slots of the cadre at every stage. So therefore, when you then proceed to give any benefit of the service, whether it is a senior scale, a super time scale, or even deployment as a principal district judge, when you sit down to make the zone of consideration, within that zone, every person in every slot will be available. So my respectful submission to your lordships is that the solution which was given in the 2002 judgment, and in states where the roster has operated, there is no disparity. In Delhi, the disparity is because up to today, there is no roster. In fact, in the judgment of B.S. Mathur, your lordships in para 52, which in my written submission I have quoted, categorically said, we are now doing length of service, but from 6 onwards, please bring back the roster. Delhi has still not brought back the roster, even up to today. Even up to today, there is a length of service which is going on, and roster has been only brought back if direct recruit and promotee is appointed on the same day, only then. That is not a solution. It has to be a year-wise running account, which is necessary for a proper settling of the equities of all concerned. Now, my lord, so far as the principle of weightage is concerned, which is being argued before your lordships, there are 3 reasons why I say weightage should not be given today. First is, my lord, your lordships originally, when appointment to the post of additional district judges were made, there were only 2 modes of recruitment. Some did not have direct recruitment. It was either promotion or direct recruitment. The Shetty Commission records some states had 60-40, 75 promotee, 25 direct. Some had 2/3, 1/3. Your lordships then reworked those quotas to give a 25%, and I'm borrowing the words from the 2025 judgment of your lordships, my lord, to give an accelerated promotion within the cadre of the civil judges. So that accelerated promotion was given by carving out this 25% limited departmental quota so that they could work, so that they could proceed in a slightly faster fashion. This is a facet of weightage, which has already been given to them within the cadre. The man who would have to wait has one option of accelerated LCD and proceed further. Second, now this argument becomes all the more important because now your lordships have given within the junior to senior also an LCD. So now, actually speaking, and hypothetically, it may not happen, if at 24 I pass my law, 3 years I wait, 26 I get appointed as a civil judge junior division, then another 3 or 4 years I get promoted, I take the LCD and become a senior division, then another 4 years I will have to wait. By 34, 35, even within the promotion quota, I could be eligible to become a district judge. So therefore, my lord, this what you have granted, this what your lordships have granted to them now, to move from the lower junior to the senior scale by way of an LCD is also a sort of a weightage or an acceleration which is granted to the brighter of them, as Mr. Dwivedi had put it, that if a person wants to be patient and take the longer route, then it is, of course, each person has his own aspirations and his own thinking. So this is the second thing. The third now, your lordships have also opened the direct recruitment route to the subordinate judges. So therefore, if your lordship sees a subordinate judge who joins, first has an option to go in for direct recruitment. Then he has an option to take the LCD to move faster from the junior to the senior scale. And then he has another LCD to move from the senior to the ADJ scale. So therefore, my lord, now giving them another benefit of weightage, in my respectful submission, is not the solution. This is the second point that I'm making. The third reason for not giving them weightage is that your lordships in the 2002 judgment para 30 have categorically said that weightage should not be granted and roster is the solution. And therefore, my submission on the first point being, roster has not failed actually. Roster has never been given a chance to, actually a fair chance to operate fairly. And for a roster to operate fairly, yearly recruitment is a must. So therefore, if your lordships is giving some directions, then the directions would be that the observations made in Malik Mazhar for yearly recruitment should be scrupulously followed. That is my second submission. Now, my lord, so far as quota is concerned, so far as quota is concerned, my lord, I can do no better than reading paras 44 and 45 of Muhammad Shujat Ali, my lord. If your lordship will just have that judgment, because that is what is ultimately in Khosa, my lord, of Khosa, Talokinath Khosa, that is volume 5A. If your lordship will have at page 49, placitum B, C, and D.
Yeah, that's it.
5A. That's at 21.
But your lordships is coming back at 2 or is it?
No, yesterday only.
Yes, but then there was some circular which confused some of us. That the bench will assemble on Wednesday for the day or something like that. Didn't say for the day, it said bench will assemble, so we thought perhaps.
No, your lordship indicated that only till lunch today you will.
Yes, yesterday only.
Before rising, your lordship.
So can I then get 10 minutes on the next, 10-15 minutes on the next?
You decide amongst yourselves timing.
No, 10 minutes only. I have hardly taken 15 minutes. I got a slot of, only 10 minutes on the next day. Whichever next day your lordship is granted. Tuesday.
5-7 minutes. You can.
Lord, let me get it on the next day, Lord. 10, because.
They will not take 10 minutes, you'll take more.
No.
Yes.
I promise to take 10 with a maximum of 15, Lord. Nothing, right. I'll just recapitulate and.
Get Wednesday, Thursday, Friday.
Time will not change. Time will not change, Lord. I will not take extra day.
Lot of time to get your ammunitions,
Grateful.
Your Lordship, there's been a fresh IA that has been filed. IA number has still not been given. If the court could allow, because the registrar is.
Maybe defect, you find it out.
Okay.